ಈಗ ನಿದ್ದೆ ಮಾಡ್ಬಿಡಿ. ಕೋರ್ಟ್ ಕಂಡ್ರೆ Yes.
Any mentioning through video? Any memos?
They matter regarding detailed areas. The appeal is filed in month of September. Still, it is not listed in the kindly list on 31st.
No, why it is not listed? Are there any office objections?
Senior knows.
Then ascertain. If there are any office objection, comply the office objection. Yes.
Your appeal, criminal appeal this matter, madam. My IA is pending, my IA is for the bail. In the trial court, it has been acquitted. Party is in judicial custody now for 30 days. It's an urgency in this matter, madam.
Whether that matter came up before us a couple of days back?
Yes, ma'am.
What happened on that day?
On the day admission. Mention madam.
What happened on that day? ಅಂಥದ್ದು ಏನಾರು ಇದ್ರೆ ಅದು ಯಾವತ್ತು ಬಂದಿದೆ ಅಂತ ಒಮ್ಮೆ ಹೇಳ್ಬೇಕಲ್ವೇ ಮ್ಯಾಟ್ರು. ಸ್ವಾಮಿ ಇದು ಮೊನ್ನೆ 27ನೇ ತಾರೀಕು ಬಂದಿತ್ತು, ಅವದಕ್ಕೆ ಹೀಗೆ ಆಯ್ತು. ಎಲ್ಲ ನೀವು ಏನ್ ಹೇಳ್ಬೇಕು ಅದನ್ನ ಹೇಳಲ್ಲ. ಎಸ್ ಏನೈತ್ರಿ ಇವತ್ತು?
My lord, on the day the matter was passed over in Minister Judicial Custody. The note ಏನು ಹಾಕಿಲ್ಲ. The accused was produced before the register.
ನೀವು ಅವತ್ತಿನ ದಿವಸ ಬೇಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ, ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಿ, ಮತ್ತೆ ಯಾಕೆ ಮುಂದುವರಲಿಲ್ಲ ಅವತ್ತು ನೀವು? ಮ್ಯಾಟ್ರ್ ಕಾಲ್ ಆದಾಗ ನೀವ್ ಇರ್ಲಿಲ್ಲ. ಮ್ಯಾಟ್ರ್ ಕಾಲ್ ಆಗ್ಲಿಲ್ಲ ಅಲ್ಲ, ಮ್ಯಾಟ್ರ್ ಕಾಲ್ ಆದಾಗ ನೀವ್ ಇರ್ಲಿಲ್ಲ. In 2 rounds that was called, Register of Judicial was also summoned here. No, I don't accept it. Because matter call ಆಗ್ಲಿಲ್ಲ ಅಂತ you are making an allegation against the court. Absolutely not. Absolutely not. ಅದು ಯಾವ್ದು ನಂಬರ್ ಕೊಡಿ ಅದನ್ನ. Not to list that matter for another 15 days. Yes, for another 15 days it won't come. ನೀವೆಲ್ಲ ಯಂಗ್ಸ್ಟರ್ಸ್ ಇದ್ದೀರಿ, ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಿದೀವಿ ಅನ್ನೋದು ನಿಮಗೆ ಅದ್ರದ್ದು ಸೀರಿಯಸ್ನೆಸ್ ಗೊತ್ತಿರಲ್ಲ. ಕೇಸ್ ಕರೆದಾಗ ಇರಲ್ಲ, ಮ್ಯಾಟರ್ ವಾಸ್ ನಾಟ್ ಕಾಲ್ಡ್ ಅಂತ ಕೋರ್ಟ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡ್ತೀರಿ ನೀವು. ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ನಾಟ್. ಬರ್ಕೊಳ್ಳಿ, 15 ದಿವಸ ಬರಬಾರ್ದು. ನಂಬರ್ ತಗೊಳ್ಳಿ, ಅವ್ರ ಸೀನಿಯರ್ ಆಮೇಲೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿ, ದಿಸ್ ವಾಸ್ ದಿ ಸಬ್ಮಿಷನ್ ದಟ್ ವಾಸ್ ಮೇಡ್. ಎಸ್, ಕಾಲ್ ದ ಕೇಸಸ್.
Hearing on interrogated application serial number 1, Mahesh Payal, SPP sir.
That is true. Notice has to be issued first. You should make that mention first. ಅಲ್ವೇ? ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ನೋಟಿಸ್ ಹೋದ್ರ ಮೇಲೆ ಅಲ್ವೇ? ಇನ್ನು ನೋಟಿಸ್ಗೆ ಹೋಗಿಲ್ಲ, ನೀವು ಆಲ್ರೆಡಿ ಡಿಲೇ ಕಂಡೋನೇಷನ್ ಮೇಲೆ, ಮೆರಿಟ್ ಮೇಲೆ ಹೋಗ್ತೀರಿ.
Who is appellant here? Who is appellant?
Appellant is the victim's father. Victim at the date of.
We are not mentioned anything about.
ಬರ್ದಿಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರ್ಯಾಂಕ್. Were you a charge sheet witness? You are not.
I am a charge sheet.
You are a charge sheet witness, but you are not examined. You have the charge sheet copy with you? Yeah. ನೋಡಿ ಇದರಲ್ಲಿ
What is the status?
CW5.
It was mentioned in the appeal memo. So
Timappa son of Tippes.
even the rank also are not mentioned.
Yes. Further submission of learned counsel for the appellant. There is the memorandum of appeal and the impugned judgment. Issue notice to the respondent. Issue emergent notice to the respondent. Learned HCGP, who is physically present, takes notice for respondent number 1 and acknowledges the receipt of the copy of the memorandum of appeal along with annexure plea and prays for 10 days time to file objections if any to IA 1/23. Time as prayed is granted. Appellant to pay the necessary process and furnish copies in the registry if not already done during the course of the day for issuance of emergent notice to respondent number 2. List the matter on 13/12.
Serial number 2, SPP.
The meantime, call for the SCR.
Paying my lord.
Notice SCR, yes.
Further arguments matter. Serial number 3, SPP, Pawan HK for respondent 1 and 2, P Nataraju for 3 and 4.
ಶಾಲಾ ದಾಖಲಾತಿ ಸಂಬಂಧಪಟ್ಟ ಜನ್ಮದಿನವನ್ನು ತೋರಿಸುವ ದಾಖಲಾತಿಯನ್ನು ಇದ್ದರೋ ಇಲ್ಲವೋ ಅಂತ ನಾನು ಶಾಲೆಗೆ 22 ಪೂರೈಸುವ ಕಾಲಕ್ಕೆ ನೋಡಿಲ್ಲ.
ಹಾ.
ಶಾಲೆಗೆ 23
ಮುಂದಿಂದು ಬೇರೆ. Now you are stressing on the point that at the time of issuing the date of birth certificate based on the school record, this witness has not seen whether the relevant documents were furnished at the time of admission. How far that is necessary or required?
just there on judgment.
Sir, first you convince me, then rely upon the judgment. We have seen that judgment in quite number of cases.
That not the parents would only give a date of birth, according to circumstances, not previously. With respect.
She has not stated it was based on the oral statement, her date of birth was recorded. That is not. ವಿದ್ಯಾರ್ಥಿಗಳನ್ನು ಸೇರಿಸುವಾಗ ಪೋಷಕರು ಏನು ಹೇಳುತ್ತಾರೋ ಅದನ್ನು ದಾಖಲಿಸುತ್ತೇವೆ. ಈ ಕೇಸಿನಲ್ಲಿ ವಿದ್ಯಾರ್ಥಿನಿಯನ್ನು ಸೇರಿಸುವಾಗ ಅವರು ಯಾವ ದಾಖಲೆಯನ್ನು ಕೊಟ್ಟಿದ್ದಾರೋ ಎಂಬುದನ್ನು ಪರಿಶೀಲಿಸಿಲ್ಲ. ಅಲ್ಲ, ಗೊತ್ತಿಲ್ಲ ಏನು ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದಾರೋ. PW ನ ವಿನಃ ಶಾಲಾ ದಾಖಲಾತಿ ವೇಳೆಯಲ್ಲಿ ಆಕೆಗೆ ಸಂಬಂಧಪಟ್ಟ ಜನ್ಮ ದಿನಾಂಕವನ್ನು ತೋರಿಸುವ ದಾಖಲೆಯನ್ನು ಕೊಟ್ಟಿದ್ದಾರೋ ಇಲ್ಲವೋ ಅನ್ನುವುದನ್ನು ನಾನು ನಿಶಾನೆ P22 ಪೂರೈಸುವ ಕಾಲಕ್ಕೆ ನೋಡಿಲ್ಲ. ಅಂದ್ರೆ at the time of issuing exhibit P22, I have not seen whether any document related to date of birth was furnished at the time of admission. Not at this say, it is not that by that it cannot be inferred that at the time of admission no such document was given. Make that difference. That judgment applies to that case where at the time of admission the document relating to the date of birth was not furnished. Here, what sentence you have elicited, what answer you have elicited from the witness is that at the time of issuing exhibit P22, not at the time of admission. At the time of issuing exhibit P22, it was not ascertained or it was not checked whether any birth certificate was given at the time of admission. ಶಾಲೆಗೆ ಸೇರಿಸುವ ಸಮಯದಲ್ಲಿ ಜನ್ಮ ದಿನಾಂಕಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ದಾಖಲಾತಿಯನ್ನು ನೀಡಿದ್ದರೋ ಅಥವಾ ಇಲ್ಲವೋ ಎಂಬುದನ್ನು ನಾನು ನಿಶಾನೆ P22 ನೀಡುವ ಸಮಯದಲ್ಲಿ ಪರಿಶೀಲಿಸಲಿಲ್ಲ. ಅದ್ರ ಅರ್ಥ ಅಡ್ಮಿಷನ್ ಆಗ ಟೈಮ್ ನಲ್ಲಿ ಅಂತದ್ದು ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅಲ್ಲ. ನಂಬರ್ 2, ನೀವು ಈ ವಿಟ್ನೆಸ್ ಏನ್ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಸೋ ಇಸ್ ದ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಆಫ್ ದಿ ಮೈನರ್ ಅಂತ ಏನ್ ಹೇಳಿದ್ದಾರೆ 26/1999 ಅಂತ, ಅದನ್ನ ಎಲ್ಲಿಯೂ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಡಿನೇ ಮಾಡಲೇ ಇಲ್ಲ. ಹೌದು, ಅದ್ರ ಅರ್ಥ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಅವಳದ್ದು 20/6/1999 ಅಲ್ಲ ಅನ್ನೋದು ಅಲ್ಲ. Her date of birth is not 26/1999. Is not your specific suggestion to the witness. You have furnished a created document or concocted document does not mean her date of birth is not 26/1999. Yes. You are on the point of kidnapping.
Just like that, judgment.
What it says, draw our attention to the relevant portion. Please. Which is the judgment? First tell the citation. 2000, 2007, 11, volume 2.
Supreme Court cases 380.
Yes.
Respect number 376 and 366. Point for consideration was Supreme Court that A1 abducted or forcibly married victim girl. Point number 2, that victim girl was protect nature. Was considered. Paragraph 40 minutes of the judgment. Thirdly, the transfer certificate exhibit P16 indicates that girl date of birth was 15/6/1977. Therefore, even according to the aforesaid certificate, she would be about 60 years of age.
on the date of the alleged incident, that is 1/7/83, the transfer certificate has been issued by the government school and has been duly signed by the headmaster. Therefore, it would be admissible in evidence under section 35 of Evidence Act. However, the admissibility of such a document would be of not much evidently value to prove the age of girl in the absence of material on basis of which the age was recorded. And para 47. We are of the opinion in facts of this case, the age of girl would not have been fixed on the basis of transfer certificate. There was no reliable evidence to what say correctness of date of birth as recorded in the transfer certificate. In that case, my expert opinion was taken. Clinical was more than 18 years. Medical record was there. That has been considered. Para 48. You may further notice that even with reference to section 35 of the Evidence Act, the public document has to be tested by applying the same standard in civil as well as criminal proceedings. In contest, it would be appropriate to notice the observation made by this court, Ravindra Singh, Turkey versus State of UP. The age of person, as recorded in the school registry or otherwise, may be used for various purposes, namely for obtaining admission, for obtaining an appointment, for contesting elections, registration of marriage, obtaining a separate unit. All those have been discussed.
ಓದಿ ಅದೇನಿದೆ ಮುಂದೆ ಓದಿ.
Obtaining a separate unit under the seating laws and even for purpose of litigating before a civil forum. Example necessary of being represented in court of law by guardian or when suit is filed on the ground that plaintiff being a minor, he was not going to be represented therein, or any transaction made on behalf of this was void and he was a minor. A court of law for the purpose of determining the age of party to the list, having regard to the provisions of section 35 of Evidence Act, will have to apply the same standard. No different standard can be applied in case of an accused as in a case of abduction or rape or similar offense where the victim or the prosecutrix, although might have consented with the accused upon the basis of the entries made in the registry maintained by the school. A judgment of
Read that sentence again.
No different standard can be applied in a case of an accused as in a case of abduction or rape or similar offense where the victim or the prosecutrix, although might have consented with the accused, if on the basis of the entries made in the registry maintained by the school, judgment of conviction is recorded, the accused will be deprived of his constitutional right under Article 51 of the Constitution. As in that case, the accused may unjustly be convicted.
Yes. Leave that judgment. Yes. Part 48. Yes, please.
Only on basis of the admission registry.
Yes.
The age of victim cannot be assessed.
Yes.
Prosecution has failed to prove that victim was minor at the date of age.
Yes.
And sexual act.
Yes.
Respect to not kidnapping.
Yes.
That she stated that he went to fetch water from the public water tap. The accused came there, and he called her to come along. And in the cross examination of Smrats, the victim has categorically admitted that near the public water tank, there were a lot of people sitting there on the date when the accused has called her. And she has not alerted any general public. Respect to Millard's accused taking her. There was no impediment for the victim to narrate the incident to the nearby residents or people who were staying there also.
Yes.
Floods, she has narrated the incident of she going away along with the victim to various places and staying there for a couple of days. But in all the incidents, Mulas, she has not alerted any general public, nor she has asked for any help from the residents where she alleged, she has stated that she was staying. No independent witnesses have been examined for the effect.
Yes.
She was taken to the, initially she was taken to the police commissioner office on 24/10/2013. There also, there was no impediment for the victim to narrate the incident before the officers of the police commissioner. She has not done that. She was taken to Miss police station. From there, their parents were called. From there, she went to Vivupuram police station. There, her statement was recorded. In her statement, she said voluntarily she has gone as her marriage was fixed and she was not intended to marry that person. So
Where she has stated so? That voluntarily she has gone because her marriage was intended to be performed with others. Is it before the magistrate?
No, madam, before the police officer. Based on that report, Manars, the missing complaint was closed on 24.
Where we find that?
Just
Which investigating officer has stated that she stated that she voluntarily went and as such we closed the missing complaint? Specifically.
cross-examination of
PW 15.
investigating officer,
1 minute.
page 11, paper book 131.
Yeah, 1 second.
Para 2. Again.
Yes. Yes.
ಪ್ರಾಸ ಒಂದು ದಿನಾಂಕ 24/10/2013 ಒಂದು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಬಂದು ತಾನೇ ಸ್ವತಃ ತನ್ನ ತಂದೆ ತಾಯಿ ತಂದೆ ಬೇರೆಯವರ ಜೊತೆ ಮದುವೆ ನಿಶ್ಚಯ ಮಾಡಿದ್ದರಿಂದ ಸದರಿ ಮದುವೆ ನಿಶ್ಚಯವಾದ ಕಾರಣ ತನ್ನ ಮನೆ ಬಿಟ್ಟು ಹೋಗಿ ರೈಲ್ವೆ ನಿಲ್ದಾಣವಾಗಿದೆ ಸ್ಥಳದಲ್ಲಿದ್ದು ಈ ದಿನ ಸುಧಾ ಎಂಬ ಹೆಂಗಸು ಪರಿಚಯವಾಗಿ ಅವರ ಕಡೆಯಿಂದ ಬಂದು ಠಾಣೆಗೆ ಹೇಳಿದ್ರು.
But PW1 appears to have stated that the same was stated under some threat or pressure, which was, and her first alleged statement was not true, right?
ನಾವು ಹೇಳದ ಮೇಲೆ ಹೇಳಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ.
ಸದರಿ ಸುಧಾ ಪೊಲೀಸ್ ಕಮಿಷನರ್ ಕಚೇರಿಗೆ ಕರೆದುಕೊಂಡು ಹೋಗುವ ಪೂರ್ವದಲ್ಲಿ ನನಗೆ ಗಿರೀಶ ಸಿಗಬೇಕೆಂದರೆ ನಾನು ಹೇಳಿದ ಹಾಗೆ ಹೇಳಬೇಕು ಅಂತ ತಿಳಿಸಿದರು. ನಾನು ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಇದ್ದೆ ಅಂತ, ನಾನು ಯಾರೊಂದಿಗೂ ಹೋಗಿರಲಿಲ್ಲ ಅಂತ, ನನ್ನ ತಾಯಿ ತಂದೆ ಇಷ್ಟ ಇಲ್ಲದವನ ಜೊತೆ ಮದುವೆ ಮಾಡುತ್ತಿದ್ದರು, ಅದಕ್ಕೆ ಮನೆ ಬಿಟ್ಟು ಬಂದೆ ಅಂತ ಪೊಲೀಸ್ ಕಮಿಷನರ್ ಮುಂದೆ ತಿಳಿಸಬೇಕು ಅಂತ ಸುಧಾ ನನಗೆ ಹೇಳಿದಳು. ನಾನು ಪೊಲೀಸ್ ಕಮಿಷನರ್ ಮುಂದೆ ಸುಧಾ ಆಂಟಿ ಹೇಳಿಕೊಟ್ಟ ಹಾಗೆ ಹೇಳಿದೆನು. ಅದನ್ನ ಶಿ ಹ್ಯಾಸ್ given the reason as to under what situation she was there to make that statement.
But in a
How to ignore that?
cross examination regards, we have asked one question. ಮಹಿಳಾ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಅಂತ ಹೋದಾಗ ಅಲ್ಲಿ ತಮ್ಗೆ ಈ ತರ ತೊಂದರೆ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಕೊಳಕ್ಕೆ ಏನು ತೊಂದರೆ ಇರಲಿಲ್ಲ ಅಲ್ಲವಾ? ನನಗೇನೋ ತೊಂದರೆ ಇರಲಿಲ್ಲ. ಪೇಜ್ ನಂಬರ್ 9 of the cross examination of the PW1. ಮೈಸೂರು ಮಹಿಳಾ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ನಾನು ಮತ್ತು ಸುಧಾ ಇಬ್ಬರೇ ಹೋಗಿದ್ದೆವು. ಸದರಿ ಮಹಿಳಾ ಪೊಲೀಸ್ ನಾನು ದೂರು ಹೇಳಿಕೊಳ್ಳಲು ತೊಂದರೆ ಇರಲಿಲ್ಲ. ನಾನು ಮಹಿಳಾ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋದಾಗ ನನ್ನ ಮೈ ಮೇಲೆ ಯಾವುದೇ ಗಾಯಗಳು ಇರಲಿಲ್ಲ ಮತ್ತು ನನ್ನ ಬಟ್ಟೆಗಳು she was there before the women police station. Plus her parents was also present. The culture of
No, ಮಹಿಳಾ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಹೇಳಲು ತೊಂದರೆ ಇರಲಿಲ್ಲ doesn't necessarily mean that she should have necessarily revealed as to what has happened. She has stated, I could have stated so, I could have stated what has happened, but I was told by Sudha that in case if I want Girish, whom she was in love with, she should say what is tutor to her.
that was could have narrated the incident before the police because her parents was also present.
ಅಲ್ರಿ, ಅವಳಿಗೆ ಆಯ್ಕೆ ಇತ್ತು, ಒಂದು ಪೊಲೀಸ್ನವ್ರ ಮುಂದೆ ಸತ್ಯ ಹೇಳೋದು ಅಥವಾ ಗಿರೀಶ ತನಗ್ ಬೇಕು. ಅವಾಗ ಏನ್ ಮಾಡ್ತಾರೆ, ಯಾವ್ದೋ ಹುಡುಗಿಯರು ಅಥವಾ ಯಾವ್ದೇ ಹೆಂಡಂದ್ರು, ನಮ್ಮ ಗಂಡ ಮುಖ್ಯ ಅಥವಾ ನನ್ನ ಲವರ್ ಮುಖ್ಯ? ಇವಳ ಪ್ರಕಾರ ಇವಳಿಗೆ ಅವಳ ಲವರ್ ಮುಖ್ಯ ಆಗಿದ್ದ ಗಿರೀಶ್. ನನ್ಗೆ ಗಿರೀಶ್ ಮುಖ್ಯ ಆಗಿತ್ತು, ಹಾಗಾಗಿ ಅವನನ್ನ ಮುಂದಿಟ್ಕೊಂಡು ಅವನ್ ಹಾರಿಸ್ಕೊಂಡು ಹೋದ, ಅವನ್ ಕಿಡ್ನಾಪ್ ಮಾಡ್ಕೊಂಡು ಹೋದ ಅಂತ ನೀನ್ ಹೇಳ್ಬಾರ್ದು. ನಿನಗೆ ಅವನ್ ಬೇಕು ಅಂತ ಆದ್ರೆ ನಾವು ಹೇಳಿಕೊಟ್ಟಂಗೆ ಹೇಳ್ಬೇಕು, ನೀನಾಗೆ ಮನೆ ಬಿಟ್ಟು ಹೋದಿ ಅಂತ ಹೇಳ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರು. ನಾನು ಅದಕ್ಕೋಸ್ಕರ ಹಾಗೆ ಹೇಳಿದೆ.
ಯಾವುದೇ ರೀತಿ ತೊಂದರೆ ಆದರೆ ಪೊಲೀಸರಿಗೆ ತಿಳಿಸಬೇಕು ಅನ್ನೋ ವಿಷಯ ಜ್ಞಾನ ನನಗೆ ಇರುತ್ತದೆ ಅಂತ ಈಸ್ ವೆಲ್ ಅವೇರ್ ಆಫ್ ಆಲ್ ದಿ ಫ್ಯಾಕ್ಟ್ಸ್.
ಹೌದ್ರಿ, ಅದೆಲ್ಲದು ಕರೆಕ್ಟು. ಆದ್ರೆ ತೀರಾ ಅನಿವಾರ್ಯ ಅಂದಾಗ ಮಾತ್ರವೇ ಎಲ್ರು ಪೊಲೀಸ್ ಹತ್ರ ಹೋಗೋದು. ನೀವು ಅಷ್ಟೇ, ನಾನು ಅಷ್ಟೇ. ಆದ್ ಕೂಡಲೇ ಹೋಗಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಪೊಲೀಸರು ಅಂತ ಚೆನ್ನಾಗಿ ಅವ್ರ ನಂಬಿಕೆ ಉಳಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಸಮಾಜದಲ್ಲಿ. ನೀವು ಕೋರ್ಟ್ ಬಿಚ್ಚಿಟ್ಟು ಹಂಗೆ ಹೋದ್ರೆ ನಿಮ್ಮನ್ನು ಅವ್ರು ಮೂಸಿ ನೋಡಲ್ಲ, ಮಾತಾಡ್ಸಲ್ಲ. ನಾನು ಹಂಗೆ ಹೋದ್ರೆ ನನ್ನನ್ನು ಮೂಸಿ ನೋಡಲ್ಲ, ಮಾತಾಡ್ಸಲ್ಲ. ಅದೇನೆಲ್ಲ ಬರ್ಬೋದು ಭಾಷೆಗಳು ಎಲ್ಲದೂ ಬರ್ತದೆ ಅವ್ರ ಬಾಯಿಯಿಂದ. ಹಾಗಾಗಿ ತೀರಾ ಅನಿವಾರ್ಯ ಅಂದ್ರೆ ಮಾತ್ರ ಹೋಗ್ತಾರೆ. ಈಗ ದಾರಿಯಲ್ಲಿ ಏನು ಅನಾಹುತ, ಅಪಘಾತ ಅಥವಾ ಇನ್ನೊಂದೇನು ಅಪರಾಧ ನಡೀತು ಅಂತ ಹೇಳಿದ್ರು ಜನ ಯಾಕೆ ಅದ್ರ ಬಗ್ಗೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡಲ್ಲ? ಬರೀ ವಿಡಿಯೋ ತಕೊಳ್ತಾರೆ, ಇನ್ನೇನೋ ತಕೊಳ್ತಾರೆ. ಅಂದ್ರೆ ವಿಡಿಯೋ ತಕೊಂಡು ಮಜಾ ಮಾಡ್ಲಿಕ್ಕೆಲ್ಲ ಅದ್ರಲ್ಲಿ ಅವ್ರಿಗೇನು ಆನಂದ ಕಾಣುತ್ತೆ ಅಂತಲ್ಲ. ನಾಳೆ ಏನೋ ಹೋಗಿ ಕೇಸ್ ಇನ್ನೇನೋ ಆಗುತ್ತೆ, ಬೇರೆದೇನೋ ಎಡವಟ್ಟಾಗ್ತದೆ. ನಮ್ಮ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಬಾಂಧವರುಗಳು ಅಲ್ಲಿ ಏನೇನೋ ಮಾಡ್ತಾರೆ ತನಿಖೆಯಲ್ಲಿ. ಜನಗಳ ಮಧ್ಯೆ ಏನ್ ನಡೆದಿದೆ ಅಂತ ಹರಿದಾಡ್ಲಿಕ್ಕೆ ಬಿಟ್ರೆ ನೋಡೋಣ ಅಂತ ಏನಾಗುತ್ತೆ ಅಂತ ಅಷ್ಟೇ. ಜನ ಯಾಕೆ ಸ್ಟೇಷನ್ ಹೋಗ್ಲಿಕ್ಕೆ ಹೆದರ್ತಾರೆ ಅಂದ್ರೆ ಅಲ್ಲಿ ಹೋಗ್ಲಿಕ್ಕೆ ಅವರಿಗೆ ತಮಗೆ ರಕ್ಷಣೆ ಇಲ್ಲ ಅಂತಕ್ಕಂಥ ಇನ್ಸೆಕ್ಯೂರ್ಡ್ ಅಟ್ಮಾಸ್ಫಿಯರ್ ಕ್ರಿಯೇಟ್ ಆಗಿದೆ. ಅಫ್ಕೋರ್ಸ್ ಲೀಗಲಿ ಯು ಆರ್ ರೈಟ್, ಪೊಲೀಸಸ್ ಆರ್ ದೇರ್, ವಾಟ್ ದೇ ಆರ್ ಎಕ್ಸ್ಪೆಕ್ಟೆಡ್ ಟು ಡೂ, ವಾಟ್ ಈಸ್ ದ ಸಿಟಿಸನ್ಸ್ ಡ್ಯೂಟಿ, ಎವ್ರಿಥಿಂಗ್ ಈಸ್ ರೈಟ್. We cannot deny that because that is the norm in the society and that is the law. We cannot deny that. But I am just saying, asking learned SPP on every occasion, has to look at how do the people react, how do the people respond to the police department. And but your point we will consider. She had every opportunity, not only that, even the knowledge that if any untoward incident happens, that has to be reported to the police at the earliest opportunity. Yes.
3 occasions she had, one before the commissioner office, one before the women's police station, one before the women's police station. 3 incidents also, she does not narrate anything.
ಮತ್ತೆ ಆಕೆಯ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾರೆದ್ರು ಯಾವಾಗ ಬಂತು? ಈ 3 ಜನರಲ್ಲಿ ಒಬ್ಬರ ಹತ್ರನಾದ್ರೂ ಬರಲೇಬೇಕಲ್ವೇ? ಐ ವಾಸ್ ಕಿಡ್ನಾಪ್ಡ್ ಅಂಡ್ ರೇಪ್ಡ್ ಅಂತ.
Before the women's subsequently after 4 days, presented by
Other, according to you, even on the very first day when she was sent to Vivipuram police station, she did not reveal. ಎಲ್ಲಿ ಬಂದಿದೆ ಇದು? ಯಾವತ್ತೊಳಗೆ ವಿವಿಪುರಂ ಇದ್ರ ತಂದ್ರು, ಬಟ್ ಇವಳು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೆ ಯಾವಾಗ ಅಂತ?
24/10/2013.
24/10. Her complaint came to be registered on 28/10.
With respect to the present case, 376 and Moscow.
Yes.
It came to the register on
28/10.
Missing complaint came to the register on 23rd. She was reported on 24th and missing complaint came to be closed on
Yes.
24th.
Yes.
Mallards, last examination of the father.
Yes.
Page number 3, Mallards, paper book page number 93.
Yes.
First paragraph. ಪೊಲೀಸ್ ಕೆಲಸ ಮಾಡುವುದು ಮಾತ್ರ ನನಗೆ ಗೊತ್ತು. ಮನೆಯ ಎಲ್ಲಾ ವಿಚಾರಗಳು ನನ್ನ ಹೆಂಡತಿಗೆ ಗೊತ್ತು. ನಾನು ಮತ್ತು ನನ್ನ ಹೆಂಡತಿ ಬೀಳುವುದು ದೊರಕಿದ ದಿನವೇ 24/10/2013 ಒಂದನೇ ಆರೋಪಿ ಲೈಂಗಿಕ ಅತ್ಯಾಚಾರ ಮಾಡಿದರ ಕುರಿತು ದೂರು ಸಲ್ಲಿಸಲು ಪ್ರಯತ್ನಿಸಲಿಲ್ಲ. ನನ್ನ ಮಗಳು PW1 ಅವರು ದೊರಕಿದ ದಿನವೇ ನಮ್ಮ ಹಾಗೂ ಪೊಲೀಸರ ಮುಂದೆ ಒಂದನೇ ಆರೋಪಿ ಲೈಂಗಿಕ ಅತ್ಯಾಚಾರ ಮಾಡಿದರ ಕುರಿತು ತಿಳಿಸಿದರು. PW1 ದೊರಕಿದ ಮಾರನೇ ದಿನ ನನ್ನ ಹೇಳಿಕೆ ಪೊಲೀಸರು ಪಡೆದಿದ್ದರು. ನಾನು ನನ್ನ ಹೇಳಿಕೆಯಲ್ಲಿ ಒಂದನೇ ಆರೋಪಿ ಯಾವ ಊರಿಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದ ಮತ್ತು ವಿಚಾರವನ್ನು ನಾನು ಹೇಳಿಲ್ಲ. As per the evidence of PW, he states that on the date of she was secured, he came to know about the incident, but he also did not lodge any complaint same day. But PW1 says, ನಾನು ನನ್ನ ತಂದೆ ತಾಯಿಗೆ 3 ದಿನ ಬಿಟ್ಟು ಈ ಘಟನೆ ಹೇಳಿದೆ ಅಂತ cross examination states.
Yes,
Same page minutes,
yes,
para 9.
yes,
ನನ್ನ ಮಗಳು PW1 ಗಿರೀಶನನ್ನು ತಿಳಿಸುತ್ತಿದ್ದಳು ಅಂತ ಸಾಕ್ಷಿದಾರನಿಗೆ ಸೂಚಿಸಿದ್ದಕ್ಕೆ ಸಾಕ್ಷಿದಾರನು ಅದಕ್ಕೆ ತಮ್ಮ ಒಪ್ಪಿಗೆ ಇದ್ದಿರಲೆಂದು ಹೇಳುತ್ತಾರೆ.
yes,
PW1 ಕಾಣೆಯಾಗುವುದಕ್ಕಿಂತ ಪೂರ್ವದಲ್ಲಿ ಸಿದ್ದರಾಮಯ್ಯ ಹೊಂದಿ ಗ್ರಾಮದ ಬಸವರಾಜ್ ಎಂಬುವರಿಗೆ ಮದುವೆ ಮಾಡಿಕೊಡಬೇಕು. ಆಗ ಗಿರೀಶನು PW1 ಪ್ರೀತಿ ಮಾಡುವ ವಿಚಾರ ನನಗೆ ಮತ್ತು ಹಾಗೂ ನಮ್ಮ ಮನೆಯವರಿಗೆ ಯಾರಿಗೂ ಗೊತ್ತಿರಲಿಲ್ಲ. ಒಂದನೇ ಆರೋಪಿ ಗಿರೀಶ್ ಮತ್ತು ಆತನ ತಂದೆ ನಮ್ಮ ಮನೆಗೆ ಬಂದು ತಾವು ಪರಿಶಿಷ್ಟ ಜಾತಿಗೆ ಸೇರಿದವರು, PW1 ಅವರಿಗೆ ಬುದ್ಧಿ ಹೇಳಿ ಮದುವೆಯಾಗಲು ಬರುವುದಿಲ್ಲ ಅಂತ ತಿಳಿಸಿದರೆ ಎನ್ನುವುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನನ್ನ ಹೆಂಡತಿಗೆ ತಿಳಿಸಿರುವುದು.
yes,
Wife of PW2 Mallards was cited as CW3 Mallards. She has been given up by the prosecution.
yes,
4ರಿಂದ 7ನೇ ಆರೋಪಿಗಳು. 1ನೇ ಆರೋಪಿಯ ತಂದೆ ಸ್ನೇಹಿತರೆಂದರೆ ಶ್ರೀ. 4ರಿಂದ 7 ಆರೋಪಿಗಳು ಸಹ ನಮ್ಮ ಮನೆಗೆ ಬಂದು 1ನೇ ಪರವಾಗಿ ಬುದ್ಧಿ ಹೇಳಿದ್ದರು ಅಂತ ಸಾಕ್ಷ್ಯ ಸೂಚಿಸಕ್ಕೆ ತನ್ನ ಹೆಂಡತಿಗೆ ಗೊತ್ತಿರಬಹುದು ಎಂದು ಹೇಳುತ್ತಾರೆ. ಸಿದ್ದರಾಮಯ್ಯ ಗ್ರಾಮದ ಬಸವರಾಜನಿಗೆ PW1 ಕಾಣೆಯಾಗುವುದು ತಿಳಿದಿತ್ತು ಎಂದರೆ ಸರಿ. ತದನಂತರ ವಾಪಸ್ PW1 ಬಂದ ವಿಷಯ ಅವರಿಗೆ ಗೊತ್ತಾಯಿತು ಎಂದರೆ ಸರಿ. PW1 ಅವರನ್ನು ಮದುವೆ ಮಾಡಿಕೊಳ್ಳಲು ತಿಳಿಸಿದರು ಎಂದರೆ ಸರಿ. ಸಿದ್ದರಾಮಯ್ಯ ಗ್ರಾಮದ ಬಸವರಾಜ್ ಮತ್ತು ಅವರ ಮನೆಯವರು PW1 ಮದುವೆ ಮಾಡಿಕೊಳ್ಳುವುದಿಲ್ಲವೆಂದು ತಿಳಿಸಿದ ಕಾರಣ ನಾವು ಅಂದರೆ ನಾನು, ನನ್ನ ಹೆಂಡತಿ ಹಾಗೂ PW1 ಅವರು ಮಾತನಾಡಿಕೊಂಡು PW1 ಮುಖಾಂತರ ಆರೋಪಿ ಮೇಲೆ ದೂರು ಸಲ್ಲಿಸಿದೆವು. ಸರಿ. You are not able to marry, said Basuraz.
yes,
Subsequently, that marriage came to broken. She requested plus the accused number 1 to marry her. As accused number 1 was not interested to marry plus, he has declined for that offer. Even the father, the other people also not into the house, informed the same incident to the parents of the victim.
So you admit that there was a love affair between the victim and accused number 1.
I was not in love with the victim, but victim was in love with me. That was our contention. Even in MLC Harish also she has stated the same. ನಾನು ಗಿರೀಶನನ್ನು ಪ್ರೀತಿಸುತ್ತಿದ್ದೆ ಅಂತ ಹೇಳಿದ್ರು. ನಾವಿಬ್ಬರು ಪ್ರೀತಿಸುತ್ತಿದ್ದೇವೆ.
ಆಗ ಗಿರೀಶರು PW ಅವರು ಪ್ರೀತಿ ಮಾಡುವ ವಿಚಾರ ನನಗೆ ಹಾಗೂ ನಮ್ಮ ಮನೆಯವರಿಗೆ ಯಾರಿಗೂ ಗೊತ್ತಿರಲಿಲ್ಲ.
ಗಿರೀಶನಲ್ಲ, ಗಿರೀಶನನ್ನು. If you are not loving that girl, then why did you allow that girl to come along with you at different places?
First, to substantiate the standards that I was along with the team in various places, but no one has supported the case.
ಆರೋಪಿ ಗಿರೀಶನ ಚಿಕ್ಕಮ್ಮನ ಮನೆಗೆ ನಾನು ಹೋದಾಗಲೂ ಸಹ ಸದರಿ ಚಿಕ್ಕಮ್ಮನ ಮನೆಯವರಿಗೆ ಹಾಗೂ ಅಲ್ಲಿನ ಆಜುಬಾಜು ಜನರಿಗೆ ಆರೋಪಿ ಗಿರೀಶ ನನ್ನನ್ನು ಬಲವಂತವಾಗಿ ಕರೆದುಕೊಂಡು ಬಂದಿದ್ದಾನೆ ಅಂತ ತಿಳಿಸಲಿಲ್ಲ. In the cross examination of PW1 you have elicited.
We have asked the citizens, we have asked from that alleged act ಆಗಿದೆ. ಹಾಗಾದ್ರೂ ಸಹ ಬೇರೆಯವರಿಗೆ ಹೇಳಕ್ಕೆ ನಿಮ್ಗೆ ಏನು ತೊಂದರೆ ಇರಲಿಲ್ಲ.
ಹೌದು, ಅದ್ರ ಅಂದ್ರೆ ಅಲ್ಲಿದ್ದಾಗ್ಲೂ ಬೇರೆಯವರಿಗೆ ಹೇಳಲಿಲ್ಲ. ಆರೋಪಿ ಗಿರೀಶನ್ ಚಿಕ್ಕಮ್ಮನ ಮನೆಗೆ ಹೋದಾಗ್ಲೂ ಕೂಡ ನೀವು ಬೇರೆಯವ್ರ ಜೊತೆಗೆ ಹೇಳಲಿಲ್ಲ ಅಂದ್ರೆ ಆರೋಪಿ ಗಿರೀಶನ ಚಿಕ್ಕಮ್ಮನ ಮನೆಗೆ ನೀವು ಹೋಗಿದ್ದೀರಿ ಅಂತ ಅಲ್ವೇ? ಅಲ್ಲಿ ಹೋಗಿದ ನಂತರವಷ್ಟೇ ಆಚೀಚೆ ಜನಗಳಿಗೆ ಹೇಳುವ ಪ್ರಸಂಗ ಬರ್ತದೆ. ನಿಮ್ಮ ಪ್ರಶ್ನೆ ಆರೋಪಿ ಗಿರೀಶನ ಚಿಕ್ಕಮ್ಮನ ಮನೆಗೆ ಹೋದಾಗಲೂ ಸಹ
What she has narrated in all the incidents where she has gone, they have elicited that whether you have any.
Sir, how you elicit is different. Your intention may be different and how it is reflected in the evidence is different. ಆರೋಪಿ ಗಿರೀಶನ ಚಿಕ್ಕಮ್ಮನ ಮನೆಗೆ ಹೋಗಿದ್ದೇನೆಂದು ಹೇಳಿದ್ದ ಸಮಯದಲ್ಲಿ, that means you are not admitting that she has gone, but you are putting a suggestion. Even on that occasion also you had no problem to alert the people.
An opportunity to alert the people.
But ನೀವು ಕೋರ್ಟ್ ಹೇಳ್ತಿರೋದನ್ನ ನೀವು ತಗೊಳ್ತಾ ಇಲ್ಲ. ನಿಮ್ ತಲೆಯಲ್ಲಿ ಏನಿದೆ ಬರೀ ಅದು ಒಂದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ರಿಪೀಟೆಡ್ಲಿ. ಹೆಚ್ಚಿನ ಜನ ವಕೀಲರದ್ದು ಅದೇ ಪ್ರಾಬ್ಲಮ್. ಅವ್ರ ತಲೆಯಲ್ಲಿ ಏನಿದೆ ಅಲ್ಲೇ ಥಿಂಕ್ ಮಾಡ್ತಾರೆ ಹೊರತು ಅದೇ ವಾಕ್ಯನ ಈ ಪ್ರಕಾರವೂ ಓದಬಹುದು, ಇನ್ನೊಂದು ಪ್ರಕಾರ ಓದುವುದು ಕಷ್ಟ ಅಂತ ಕೋರ್ಟ್ ಒಂದು ತೋರಿಸಿ ಕೊಡ್ತಾ ಇದೆ ಅಂದ್ರೆ ಅದನ್ನ ಕೇಳಲಿಕ್ಕೆ ತಯಾರಿಲ್ಲ. ನೀವು PW1ಗೆ ನೋಡಮ್ಮ ಆರೋಪಿ ಗಿರೀಶನ ಚಿಕ್ಕಮ್ಮನ ಮನೆಗೆ ನಿಮ್ಮನ್ನು ಕರ್ಕೊಂಡು ಹೋದ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಹಂಗೆ ಚಿಕ್ಕಮ್ಮನ ಮನೆಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾನೆ ಎನ್ನುವ ಸಂದರ್ಭದಲ್ಲಿ ನೀವು ಸುತ್ತಮುತ್ತಲಿನ ಜನರನ್ನು ಎಚ್ಚರಿಸಬಹುದಿತ್ತು. ಹಾಗೇನಾದ್ರೂ ಮಾಡಿದ್ದೀರಾ? ಇದೇ ಬೇರೆ ಅರ್ಥ ಕೊಡ್ತದೆ. ಆರೋಪಿ ಗಿರೀಶನ ಚಿಕ್ಕಮ್ಮನ ಮನೆಗೆ ನೀವು ಹೋದಾಗಲೂ ಸಹ ಅಲ್ಲಿನ ಸುತ್ತಮುತ್ತಲಿನವರನ್ನು ನೀವು ಎಚ್ಚರಿಸಲಿಲ್ಲ, ಅದು ಅಡ್ಮಿಷನ್ ಆಗುತ್ತೆ. ಎರಡು ನಡುವಿನ ವ್ಯತ್ಯಾಸ ಗೊತ್ತಾಯ್ತಲ್ಲ? ಇಲ್ಲಿ ಅದು ಎರಡನೇದು ಬಂದಿದೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ. ಆರೋಪಿ ಗಿರೀಶ ತೊಂದರೆ ಮಾಡಿದ್ದರ ಕುರಿತು ಆರೋಪಿತರ ಚಿಕ್ಕಮ್ಮಳಿಗಾಗಲಿ ಅಥವಾ ಅಕ್ಕಪಕ್ಕದವರಿಗಾಗಲಿ ಮಾರನೇ ದಿನವೂ ಕೂಡ ತಿಳಿಸಿಲ್ಲ. ಅಂದ್ರೆ ಆರೋಪಿ ಗಿರೀಶ ತೊಂದರೆ ಮಾಡಿದಾನೆ ಅನ್ನೋದನ್ನ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಾಗ್ತದೆ ತಾನೆ. ಆರೋಪಿ ಗಿರೀಶ ತೊಂದರೆ ಮಾಡಿದ್ದರ ಕುರಿತು ನೀವೇ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಎಲಿಸಿಟ್ ಮಾಡಿದ್ದೀರಿ. ಆರೋಪಿ ಗಿರೀಶನ ತಂಗಿ ಬಟ್ಟೆಯನ್ನು ಪಡೆದುಕೊಂಡು ಧರಿಸಿದ್ದೇನು, ಸದರಿ ಬಟ್ಟೆಗಳನ್ನು ಪೊಲೀಸರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ, ಅದು ನೀವು ಡಿನೇ ಮಾಡಲಿಲ್ಲ. ಗಿರೀಶನ್ ತಂಗಿ ಬಟ್ಟೆನೂ ನಾನು ತಗೊಂಡಿದ್ದೆ, ಹಾಕೊಂಡಿದ್ದೆ. ಅಂದರೆ ಇದು ನಾನು ಕೆಲವೊಂದೆರಡು ಸ್ಯಾಂಪಲ್ ನೋಡ್ತಾ ಇದ್ವಿ. ಡೀಟೇಲ್ ಆಗಿ ನೋಡಿದಾಗ ಬಹುಶಃ ಐ ಆಮ್ ನಾಟ್ ಶೂರ್, ಪ್ರಾಬಬಲಿ ದೇರ್ ಮೇ ಬಿ ಸೆವರಲ್ ಸಿಮಿಲರ್.
ಗದ್ದಿಗೆಹಳ್ಳಿಯಿಂದ ಕಿತ್ತೂರಿಗೆ ಬಸ್ ಪ್ರಯಾಣಿಸುವಾಗ ಸಹ ಪ್ರಯಾಣಿಕರ ನಾನು ಯಾವುದೇ ರೀತಿಯ ಸಹಾಯವನ್ನು ಕೇಳಲಿಲ್ಲ ಹಾಗೂ ಅವರುಗಳಿಗೆ ಆರೋಪಿ ಗಿರೀಶನ ವಿಷಯ ತಿಳಿಸಲಿಲ್ಲ. ಕಿತ್ತೂರಿನ ಬೋರಮ್ಮನ ಮನೆಯಲ್ಲಿಯೂ ಸಹ ನಾನು ಆರೋಪಿ ಗಿರೀಶ ನನಗೆ ತೊಂದರೆ ಮಾಡಿದ್ದಾನೆ, ನನಗೆ ಸಹಾಯ ಮಾಡಿ ಮತ್ತು ನನ್ನನ್ನು ಊರಿಗೆ ಕಳುಹಿಸಿರಿ ಅಂತ ಸದರಿ ಬೋರಮ್ಮನನ್ನು ಕೇಳಿಕೊಳ್ಳಲಿಲ್ಲ. ಸದರಿ ಬೋರಮ್ಮನವರಿಗೆ ವಿಷಯ ತಿಳಿಸಲು ಮತ್ತು ಅವರಿಂದ ಸಹಾಯ ಪಡೆದುಕೊಳ್ಳಲು ನನಗೆ ಯಾವುದೇ ತೊಂದರೆ ಇರಲಿಲ್ಲ. ಮೈಸೂರಿನ ಮಂಜುನಾಥಪುರಕ್ಕೂ ಮತ್ತು ಒಂಟಿಕೊಪ್ಪಲು ಪೊಲೀಸ್ ಠಾಣೆಯ ಮಧ್ಯದಲ್ಲಿ 1/2 ಕಿಲೋಮೀಟರ್ ಅಂತರ ಇದೆ ಎಂದರೆ ಸರಿ. ಮಂಜುನಾಥಪುರದಲ್ಲಿ ಇದ್ದಾಗ ಆರೋಪಿತನು ನನಗೆ ಅತ್ಯಾಚಾರ ಮಾಡಿದ್ದಾನೆ ಎಂದು ಮತ್ತು ನನ್ನನ್ನು ನನ್ನ ತಾಯಿ ತಂದೆ ಮನೆಗೆ ಕಳುಹಿಸಿಬಿಡ್ರಿ ಎಂದು ಅಕ್ಕಪಕ್ಕದ ಮನೆಯವರಿಗೂ ತಿಳಿಸಲಿಲ್ಲ. ಒಂಟಿಕೊಪ್ಪಲು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋಗಿ ದೂರು ಸಲ್ಲಿಸುವ ತೊಂದರೆ ಇರಲಿಲ್ಲ. ಮಂಜುನಾಥಪುರದಿಂದ ಮೈಸೂರು ಸಿಟಿ ಬಸ್ ಸ್ಟ್ಯಾಂಡಿಗೆ ಬರೋ ದಾರಿಯ ಮಧ್ಯದಲ್ಲಿ ಸುಮಾರು ಕಡೆ ಪೊಲೀಸ್ ಠಾಣೆಗಳು ಬರುತ್ತಿವೆ ಮತ್ತು ಅನೇಕ ಟ್ರಾಫಿಕ್ ಸಿಗ್ನಲ್ಗಳು ಬರುತ್ತಿವೆ ಎಂದರೆ ಸರಿ. ಸದರಿ ಮಾರ್ಗದ ಮಧ್ಯದಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯ ಪೊಲೀಸರ ಸಹಾಯವನ್ನು ನಾನು ಪಡೆದುಕೊಂಡಿಲ್ಲ.
ಅಂದ್ರೆ ಬಹಳಷ್ಟು ಕಡೆ ಈ ರೀತಿ ಸಜೆಷನ್ ಮಾಡಿ ಅವಳು ಏನ್ ಹೇಳಿದಾಳೆ ಇನ್ಸಿಡೆಂಟು, ಹೀಗೆ ಹೋದ್ವಿ, ಇಂತಲ್ಲಿಗೆ ಹೋದ್ವಿ, ಈ ಊರಿಗೆ ಹೋದ್ವಿ, ಹೀಗೆ ಬಸ್ಸಿನಲ್ಲಿ ಹೋದ್ವಿ. ಅದನ್ನ ನೀವು ಫ್ಯಾಕ್ಟ್ ಅನ್ನುವ ರೀತಿ ಅವಳಿಗೆ ಬಿಂಬಿಸಿ, ಈಗ ಆಸ್ ಮೈ ಬ್ರದರ್ ಲಾರ್ಡ್ಶಿಪ್ ರೆಡ್, ಗದ್ದಿಗೆಯಿಂದ ಕಿತ್ತೂರಿಗೆ ಬಸ್ನಲ್ಲಿ ಪ್ರಯಾಣಿಸುವಾಗ ಸಹಪ್ರಯಾಣಿಕರು ನಾನು ಯಾವುದೇ ರೀತಿಯ ಸಹಾಯವನ್ನು ಕೇಳಲಿಲ್ಲ, ಹಾಗೂ ಅವರುಗಳಿಗೆ ಆರೋಪಿ ಗಿರೀಶನ ವಿಷಯ ತಿಳಿಸಲಿಲ್ಲ. ಅಂದ್ರೆ ಪ್ರಯಾಣಿಸುವಾಗ, ದಟ್ ಮೀನ್ಸ್ ಯು ಆರ್ ಅಡ್ಮಿಟಿಂಗ್ ಹರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ದಟ್ she or they traveled in the bus. ನೀವು ಪ್ರಯಾಣಿಸುವಾಗ ಕೇಳಲಿಲ್ಲ, ನೀವು ಪ್ರಯಾಣಿಸಿದ್ದೇನೆ ಎಂದು ಹೇಳುವ ಕಾಲಕ್ಕೆ ಕೇಳಲಿಲ್ಲ. ಅಂಥದ್ದು ಬಹಳಷ್ಟು ಕಡೆಗಿದೆ. Only few what I could see, I am reading it. How do you overcome that? Fine, then according to you, if she is minor in her age, if her age is taken as proved as minor, then you will be at fault. If she is major, then no case is made out, because it is with her consent only she has come. So is it that your entire case depends upon the age of the victim?
Age of the victim also. And she had several opportunities as raised the victim.
ಅಲ್ಲ, ಅದು ಬಿಡಿ. ಈಗ ಅದೆಲ್ಲ ಸವರಲ್ ಆಪರ್ಚುನಿಟಿ ಇತ್ತು ಅಂತ ಆದ್ರೆ, ಅವಳು ಮೇಜರ್ ಆಗಿದ್ಲು ಅಂತ ಆದ್ರೆ ಪ್ರಾಸಿಕ್ಯೂಷನ್ಗೆ ಕೇಸೇ ಇಲ್ಲ. ಇಲ್ಲ, ಅದನ್ನು ನೀವು ಹೇಳಿದ್ರಿ, ಏಜಿನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಅದನ್ನು ಹೇಳಿದ್ರಿ. ಅವಳು ಮೇಜರ್ ಆಗಿದ್ದಾಳೆ ಅಂತ ಆದ್ರೆ ಇದು ಒಂದು ಪ್ರೀತಿಯ ಪ್ರಕರಣ. ಇಲ್ಲಿ ಈಗ ನೀವು ಬಹಳಷ್ಟು ತೋರಿಸಿದ್ರಿ, ಪ್ರೀತಿ ಪ್ರೀತಿ ಪ್ರೀತಿ, ಅವಳು ಪ್ರೀತಿ ಮಾಡ್ತಿದ್ಲು ಅನ್ನೋದು ಸುಮಾರಷ್ಟು. ಸೊ ದ ಎಂಟೈರ್ ಕೇಸ್ ಡಿಪೆಂಡ್ಸ್ ಅಪಾನ್ ದ ಏಜ್. ಇಫ್ ಶಿ ಇಸ್ ಮೇಜರ್, prosecution has got no case. If the prosecution could able to prove that as on the date of the alleged incident she was minor, then we have to see what is proved and what is not. Yes.
Which I read on that only minutes of para 50, respect to minutes of abduction, rape, that has been referred to as a rape, para 50 of the judgment.
1 minute. Para 15. 50. 1 minute. Yes.
Could not be recorded on the sole evidence of PD2. Undoubtedly, the testimony of victim of sexual assault stands on a par with testimony of an injured witness and is entitled to great weight. Therefore, corroboration for the testimony of victim would not be insisted upon, providing the evidence does not suffer from the basic probabilities and probabilities probability factor to render it unworthy of greatness. Page number para 53 notes. In our opinion, that evidence of PW2 does not satisfy the first case. The report erroneously concluded that girl had not linked God with Shaker. Conclusion could only be recorded by ignoring the entire evidence with regard to conduct of the girl from time of the alleged abduction till time of alleged recovery. We have noticed earlier that she did not make any complaint or.
That is the appreciation of evidence, not any principle. Whether the evidence of the alleged victim PW2 there was a trustworthy and inspiring confidence. That observation. We are not bound by that because that is confined to that case. What evidence has come, the Honorable Apex Court has observed that in para 53. Yes. If your case, if the evidence of PW2 victim is shaky and unbelievable, then we may consider how safe that is to rely upon that.
PW10 doctor was examined first. And the entire evidence merits.
Yes.
Page 2 minutes of page of PW10.
Yes.
Para 1 page 1
Dr. Arpita. Yes. Page 2. Yes.
PW1 ತಿಳಿಸಿದ ಇತಿಹಾಸ ಬೆಳವಣಿಗೆ ವೈದ್ಯಕೀಯ ಪರಿಸ್ಥಿತಿ ಆಧಾರದಲ್ಲಿದೆ. PW1 ಲೈಂಗಿಕ ಸಂಭೋಗದಂತಹ ಕ್ರಿಯೆಗೆ ಒಳಪಟ್ಟಿತ್ತು. ಆದರೆ ಇಚ್ಛೀತಿಗೆ ಹಾಕಿದರೆ ಲೈಂಗಿಕ ಸಂಭೋಗದ ಕ್ರಿಯಾಶೀಲಿ ಒಳಪಟ್ಟಿರುತ್ತದೆ ಯಾವುದೇ ಎಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟಿರುತ್ತೇನೆ.
Yes.
No evidence to not victim was sexually assaulted, intended sexual assault.
ಓದಿ ಇನ್ನೊಮ್ಮೆ ನನಗೆ ನನ್ನ ಕನ್ನಡ ಬಹುಶಃ ನಿಮ್ಮಷ್ಟು ಒಳ್ಳೇದಿಲ್ಲ, ಇನ್ನೊಮ್ಮೆ ಓದಿ ಆ ಸೆಂಟೆನ್ಸ್.
PW1 ತಿಳಿಸಿದ ಇತಿಹಾಸ PW1 ಅನ್ನು ವೈದ್ಯಕೀಯವಾಗಿ ಪರೀಕ್ಷಿಸಿದ ಆಧಾರದ ಮೇಲೆ PW1 ಲೈಂಗಿಕ ಸಂಭೋಗದಂತಹ ಕ್ರಿಯೆಯಲ್ಲಿ
ಒಳಪಟ್ಟಿದ್ದು. ಆದರೆ ಇತ್ತೀಚೆಗೆ ಆಕೆಯು ಲೈಂಗಿಕ ಸಂಭೋಗದಂತಹ ಕ್ರಿಯೆಯಲ್ಲಿ ಒಳಪಟ್ಟಿದ್ದರ ಕುರಿತು ಯಾವುದೇ ಕುರುಹುಗಳು ಕಂಡು ಬಂದಿಲ್ಲ ಎಂದು ಅಭಿಪ್ರಾಯ ಪಟ್ಟಿರುತ್ತೇನೆ. ಏನಾದ್ರು ಅರ್ಥ? ಮೈಟ್ ಅಂತ ಯಾಕೆ ಸೇರಿಸ್ತಿದ್ದೀರಿ? ಮೈಟ್ ಎಲ್ಲಿದೆ? ಯಾಕೆ ನೀವು ವಕೀಲರುಗಳು ನಿಮಗೆ ಅನುಕೂಲ ಆಗಂಗೆ ಟ್ರಾನ್ಸ್ಲೇಷನ್ಗಳನ್ನು ಮಾಡ್ತೀರಿ, ನಿಮಗೆ ಅನುಕೂಲ ಆಗಂಗೆ ಕೋರ್ಟ್ ಮುಂದೆ ಹೇಳ್ತೀರಿ? ಎರಡನ್ನ ಯಥಾವತ್ತಾಗಿ ಹೇಳಿ. ನಿಮಗದ್ರಲ್ಲಿ ಏನ್ ಅಡ್ವಾಂಟೇಜ್ ಇದೆ ಅದನ್ನ ಯಾಕೆ ತಗೊಳ್ಬಾರ್ದು ನೀವು? ಅದನ್ನ ಹೇಳಿದ್ದಾರೆ. ದೇರ್ ಇಸ್ ನೋ ಎವಿಡೆನ್ಸ್ ಆಫ್ ರೀಸೆಂಟ್ ಸೆಕ್ಷುವಲ್ ಇಂಟರ್ಕೋರ್ಸ್, ಬಟ್ she was accustomed to the sexual act. ಲೈಂಗಿಕ ಸಂಭೋಗದಂತಹ ಕ್ರಿಯೆಯಲ್ಲಿ ಒಳಪಟ್ಟಿದ್ದು. She was subjected to, she was accustomed to sexual act. ಆದರೆ ಬಟ್ ಇತ್ತೀಚೆಗೆ ಆಕೆಯು ಲೈಂಗಿಕ ಸಂಭೋಗದಂತಹ ಕ್ರಿಯೆಯಲ್ಲಿ ಒಳಪಟ್ಟಿದ್ದರ ಕುರಿತು ಯಾವುದೇ ಕುರುಹುಗಳು ಕಂಡು ಬಂದಿಲ್ಲ. There is no signs of the recent sexual intercourse. ರೀಸೆಂಟ್ ಸೆಕ್ಷುವಲ್ ಇಂಟರ್ಕೋರ್ಸ್ ಬಗ್ಗೆ ಏನು ಸೈನ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದೇ ಡಾಕ್ಟರ್ ಆಕೆಗೆ ಸೆಕ್ಷುವಲ್ ಇಂಟರ್ಕೋರ್ಸ್ ಆಗಿದೆ, ಅದು ಇವನೇ ಮಾಡಿದ್ದು ಅಂತ ಇವ್ರು ಹೇಳಲಿಲ್ಲ, ಹೇಳಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಆದ್ರೆ ಆಕೆಗೆ ಸೆಕ್ಷುವಲ್ ಇಂಟರ್ಕೋರ್ಸ್ ಅನ್ನೋದು ಆಗಿದೆ. ರೀಸೆಂಟ್ ಸೆಕ್ಷುವಲ್ ಇಂಟರ್ಕೋರ್ಸ್ ಬಗ್ಗೆ ಯಾವ ಸೈನ್ಸು ಇಲ್ಲ. Yes.
Case of Mallard's false implication. When the marriage was broken, subsequently Mallard's father and PW Mallards narrated that ನಾನು ನನ್ನ ಹೆಂಡತಿ ಮಗಳು
ಹೌದು, ಅವ್ನು ಹೇಳಿದನ್ ಪೂರ್ತಿ ಓದ್ಬೇಕಲ್ವೇ? ನಾನು ನನ್ನ ಹೆಂಡತಿ ಮಗಳು ಕೂತ್ಕೊಂಡು ಮಾತಾಡ್ಕೊಂಡು ಆಮೇಲೆ ನಾವು ಇದನ್ನ ಕೇಸ್ ಕೊಟ್ಟಿದ್ದೇವೆ ಅಷ್ಟನ್ನ ಮಾತ್ರ ಸೆಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಬಾರ್ದು. ಆ ಇಡೀ ಪ್ಯಾರದಲ್ಲಿ ನೀವೇ ಏನು ಹೊರಗೆ ತಂದಿದ್ದೀರಿ ಅಷ್ಟನ್ನು ಎಲಿಸಿಟ್ ಮಾಡ್ಬೇಕು. ಅವನು ಯಾವನು ಬಸವರಾಜ ಅನ್ನೋನ್ ಜೊತೆಗೆ ಮದುವೆ ಮಾತುಕತೆ ಆಗಿತ್ತು ನಿಜ, ಅವನಿಗೆ ಕೊಡ್ಬೇಕಂತ ಮಾತುಕತೆ ಆಗಿತ್ತು ನಿಜ. ಆಮೇಲೆ ಇವಳು ಗಿರೀಶನ್ ಲವ್ ಮಾಡ್ತಿರೋ ವಿಷಯ ಅವಾಗ ನಮಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ. ಆಮೇಲೆ ಗಿರೀಶಿಂದ ಜೊತೆ ಆಮೇಲೆ ಇವಳು ವಾಪಸ್ಸು ಮನೆಗೆ ಬಂದಾಗ, ಕಾಣೆ ಆದವಳು ವಾಪಸ್ಸು ಮನೆಗೆ ಬಂದಾಗ ಕಾಣೆ ಆದ್ಲು ಅನ್ನೋದು ಅವನಿಗೆ ಬಸವರಾಜನಿಗೆ ಗೊತ್ತಾಯ್ತು ನಿಜ. ಆಮೇಲೆ ಇವಳು ವಾಪಸ್ಸು ಸಿಕ್ಲು ಅನ್ನೋದು ಅವನಿಗೆ ಗೊತ್ತಾಯ್ತು ನಿಜ. ಆಮೇಲೆ ಅವರು ನಮ್ಮ ಹುಡುಗಿನ ಮದುವೆ ಆಗ್ಲಿಕ್ಕೆ ಒಪ್ಪಲಿಲ್ಲ ನಿಜ. ಅನಂತರ ನಾವು ಹೋಗಿ ಆರೋಪಿತನ ತಂದೆ ತಾಯಿಗಳನ್ನ ಆರೋಪಿತನ ಜೊತೆ ಮದುವೆ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಕೇಳಿದ್ವಿ ನಿಜ. ಆಮೇಲೆ ನಾವು ಹೆಂಡತಿ ಮಗಳು ಕೂತು ಮಾತುಕತೆ ಆಡಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೇವೆ ನಿಜ. ಇವಿಷ್ಟನ್ನು ಓದ್ಬೇಕು. ಹೆಂಡತಿ ಮಗಳ ಜೊತೆ ಕೂತು ಮಾತುಕತೆ ಆಡಿ ಫಿರ್ಯಾದು ನೀಡಿದ್ದೇವೆ ಅಷ್ಟನ್ನು ಮಾತ್ರ ಸೆಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಬಾರ್ದು. ಇಡೀ ಪ್ಯಾರ ನೀವೇ ಎಲಿಸಿಟ್ ಮಾಡಿಸಿದ್ದೀರಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ. ಸೊ ಅವನ ಪ್ರಕಾರ, ತಂದೆ ಪ್ರಕಾರ ಹುಡುಗಿ ಗಿರೀಶನ ಲವ್ ಮಾಡ್ತಿದ್ವಿ, ನಮ್ ಗಮನಕ್ಕೆ ಬರಲಿಲ್ಲ. ನಾವು ಅವಳು ಮದುವೆ ಇನ್ನೊಬ್ಬನ ಜೊತೆಗೆ ನೋಡಿದ್ವಿ, ಗುರ್ತು ಮಾಡಿದ್ವಿ. ಮದುವೆ ಮಾತುಕತೆ ಅವನ ಜೊತೆನೆ ಮಾಡೋದು ಅಂತ ಹೇಳಿ ನಾವು ಡಿಸೈಡು ಮಾಡಿದ್ವಿ. ಅದು ಗೊತ್ತಾಗಿ ಹುಡುಗಿ ನಾಪತ್ತೆ ಆದ್ವಿ. ಅದನ್ನ ಹುಡುಗನಿಗೂ ಗೊತ್ತಾಯ್ತು, ಹುಡುಗನ ಮನೆಯವ್ರಿಗೂ ಗೊತ್ತಾಯ್ತು. ನಾವು ಒಪ್ಪಿರೋ ಹುಡುಗಿ ಮನೆಯಲ್ಲಿ ಇಲ್ಲಪ್ಪ, ಕಾಣೆಯಾಗಿದ್ದಾಳೆ. ಆಮೇಲೆ ಹುಡುಗಿ ಸಿಕ್ಲು ಅನ್ನೋದು ಗೊತ್ತಾಯ್ತು. ಆಮೇಲೆ ಅವ್ರು ಮದುವೆಗೆ ಒಪ್ಪಲಿಲ್ಲ, ಎಲ್ಲ ಓಡಿ ಹೋಗಿದ್ ಹುಡುಗಿ ವಾಪಸ್ ಬಂದಿದ್ದಾಳೆ, ಬೇಡ ನಮ್ಗೆ ಹುಡುಗಿ ಅಂದ್ರು. ಆಮೇಲೆ ನಾವು ಹೋಗಿ ಹುಡುಗನ ತಂದೆ ತಾಯಿನ ಕೇಳಿದ್ವಿ, ಮದುವೆ ಮಾಡ್ಕೊಳ್ರಿ ಅಂತ. ಇಲ್ಲ ಅಂದ್ರು. ಆಮೇಲೆ ನಾವು ಮಾತುಕತೆ ಆಡಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ವಿ. ಅದು ಏನ್ ತೋರಿಸುತ್ತೆ? ಒಂದು ವಿಧ, ಒಂದು ಆಂಗಲ್ ಈಸ್ ದಟ್ ಗಿರೀಶನ ಜೊತೆಗಳು ಹೋಗಿದ್ಲು. ಹಾಗಾಗಿಯೇ ಕನ್ನಡದಲ್ಲಿ ಒಂದು ಸಾಹಿತ್ಯಿಕ ಪದ ಇದೆ, ನಾಯಿ ಮುಟ್ಟಿದ ಮಡಕೆ ಅಂತ. ಅದು ಎಷ್ಟರ ಮಟ್ಟಿಗೆ ಸುಸಂಸ್ಕೃತ ಪದವೋ ಗೊತ್ತಿಲ್ಲ. ಹಾಗಾಗಿ ನಿಮ್ಮ ಹುಡುಗನ ಜೊತೆಗೆ ಓಡಿ ಹೋಗಿದ್ದಾಳೆ. ಈಗ ಅವಳು ಯಾರ ಜೊತೆ ಅವಳನ್ನ ಮದುವೆ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ವು ಅವರು ಒಪ್ತಿಲ್ಲ. ನಿಮ್ ಹುಡುಗಿ ಬೇಡಪ್ಪ ನಮಗೆ, ಅವಳು ಬೇರೆ ಜೊತೆ ಓಡಿ ಹೋಗಿ ಬಂದಿದ್ದಾಳೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ಹಂಗಾಗಿ ಈಗ ನಮಗೆ ಬೇರೆ ಆ ಹುಡುಗಿಗೆ ಆ ಹುಡುಗನ ಜೊತೆ ಮದುವೆ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ, ನಿಮ್ಮ ಹುಡುಗನ ಜೊತೆಗೆ ಹೋಗಿದ್ದಾನಲ್ಲ ಅವ್ನ ಕೂಡನೆ ಮದುವೆ ಮಾಡ್ಕೊಳ್ರಿ ಅಂತ ಕೇಳಿದ್ವಿ. ಅವ್ರು ಒಪ್ಲಿಲ್ಲ. ಆಮೇಲೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಈ ಕಡೆ ಆ ಹುಡುಗನೂ ಇಲ್ಲ, ಇವ್ನ್ ಕರ್ಕೊಂಡು ಹೋದವನು ಇಲ್ಲ. ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು? ನಡಿ ಹಂಗಾರೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋಣ. ಈ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ಗಳಲ್ಲಿ ವಿಚ್ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಸೂಟ್ಸ್ ಇನ್ ದಿ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಆಫ್ ದ ಕೇಸ್ ಅದನ್ನ ನೋಡ್ಬೇಕು. ಯಾಕೆಂದ್ರೆ ಅದಷ್ಟು ಡೀಟೇಲ್ ನೀವೇ ತಂದಿದ್ದೀರಿ ಹೊರಗೆ. ಎಸ್, yes.
Prosecution has failed to prove the charges.
Yes, evidence of victim is suffering with various inconsistencies. Yes. Then yes, yes, yes. Yes.
But allegation or the charges against this petitioner is not along with the number 1 and 2.
ತೋರಿಸ್ತೀವಿ.
A16.
1 minute. So section 506 IPC, 21 POCSO, 34 IPC. Yes.
That's my kind of page number 134.
Which is that document? Exhibit P1. P1. Yes. One second. Yes, exhibit P1. Yes, please. Yes.
ಆರನೇ ದಿನ ಆಕಾಶವಾಣಿಯ ಹೀಗೆ ಬಂದ ಇಲ್ಲಿ ಗಿರೀಶ ಹೇಮಂತ್ ಸಂಜಯ ರಮೇಶ ಇನ್ನ ಆಟೋಮೂರ್ತಿ A5 ನವೀನ A6 ಮತ್ತು ಆಟೋ ಹನುಮಂತ A7 ಎಲ್ಲರೂ ಇದ್ದರು. ಅವರೆಲ್ಲರೂ ನನ್ನನ್ನು ಸಮಾಧಾನ ಮಾಡಿ ಹೇಳಿದಂತೆ ನಂತರ ಭಯ ಹುಟ್ಟಿಸಿ ನಾವು ಹೇಳಿದಂತೆ ಕೇಳಿದೆ. ನಂತರ ಹನುಮಂತರವರು ಅವರಿಗೆ ತಿಳಿದಿರುವ ಒಬ್ಬ ಹೆಂಗಸಿನ ಹೆಂಗಸಿಗೆ ಹನುಮಂತ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ಎಂದು ಹೇಳಿಕೊಟ್ಟರು. ಆ ಹೆಂಗಸಿನ ಜೊತೆಯಲ್ಲಿ ಇನ್ನೊಂದು ಕಮಿಷನರ್ ನಂತರ ಅಲ್ಲಿಂದ 24 ವರ್ಷ ಅದಕ್ಕಾಗಿ ಆ ದಿನ ನಾನು ಹೇಳಿದಂತೆ ಗಿರೀಶನ ಆಯಾಸ as per the complaint government for these along with A1 for the present the case. But she has stated that what in the complaint ನನ್ನನ್ನು ಸಮಾಧಾನ ಮಾಡಿ ನಾವು ಹೇಳಿದಂತೆ ಕೇಳಬೇಕಂತ ಬೆದರಿಕೆ ಹಾಕಿದೆ. She has stated in the complaint. But according to the evidence of PW1 for the victim. But in the evidence for page 75 was brought from victim evidence. But page 70, page 18
Internal page
internal page
2. Yes.
Page what ಕೆಳಗಡೆಯಿಂದ 7ನೇ
Yes.
7ನೇ
Yes.
ಅದೇ ದಿನ
ಹಾ.
ಮಧ್ಯಾಹ್ನ 1 ಆವೃತ್ತಿ ಗಿರೀಶ ನನ್ನನ್ನು ಮೈಸೂರಿಗೆ ಚೆಲುವಾಂಬ ಪಾರ್ಕಿಗೆ ಬಂದನು. ಚೆಲುವಾಂಬ ಪಾರ್ಕಿಗೆ ಆಟೋ ಹನುಮಂತ, ಆಟೋ ಮೂರ್ತಿ, ಹನುಮಂತ, ರಮೇಶ, ನವೀನ ಇವರೆಲ್ಲರೂ ನಾನು ಮತ್ತು 1ನೇ ಆವೃತ್ತಿ ಇದ್ದ ಸ್ಥಳಕ್ಕೆ ಬಂದರು. ನನ್ನನ್ನು ಹಾಗೂ ಗಿರೀಶನನ್ನು ಏನಾಯಿತು ಅಂತ ಕೇಳಿದರು. ಆಗ 1ನೇ ಆವೃತ್ತಿ ಬಿಟ್ಟು ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಬಂದಿದ್ದೇನೆ ಅಂತ ಹೇಳಿದರು. ಆಗ ಬಂದ ಜನರ ಪೈಕಿ ನನಗೆ ನಾವು ಹೇಳಿದಾಗಿ ನೀವು ಹೇಳಿದರೆ ಅಂತ ಹೇಳಿದರು. ಮುಂದೆ ಸದರಿ 5 ಜನ ನನ್ನನ್ನು ಹಾಗೂ ಗಿರೀಶನನ್ನು ಒಂಟಿಕೊಪ್ಪಲಿನ ಸುಧಾ ಎಂಬ ಮಹಿಳೆ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಸುಧಾ ಆಂಟಿ ನನ್ನನ್ನು ಪೊಲೀಸ್ ಕಮಿಷನರ್ ಕಚೇರಿಗೆ ಕರೆದುಕೊಂಡು ಸದರಿ ಸುಧಾ ಪೊಲೀಸ್ ಕಮಿಷನರ್ ಕಚೇರಿಗೆ ಹೋಗುವ ನನಗೆ ಗಿರೀಶ ಸಿಗಬೇಕೆಂದ್ರೆ ನೀನು ನಾನು ಹೇಳಿದಾಗೆ ಹೇಳಬೇಕು ಅಂತ ತಿಳಿಸಿದರು. ಬಟ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಬ್ಲಡ್ ದಿಸ್ ಎವಿಡೆನ್ಸ್ there is no blood letter from these circles.
Yes.
But in the evidence report, she has stated against CW13, PW13 was Sudha. Sudha stated that ಹೋಗುವುದರಲ್ಲಿ ನನಗೆ ಗಿರೀಶ ಸಿಗಬೇಕಾದರೆ ನೀವು ಹೇಳುವ ಹಾಗೆ ಕೇಳಬೇಕು ಅಂತ ತಿಳಿಸಿದರು. Sudha.
Yes.
Not against all these people.
Yes.
But in page 88 is there. In our same. In 88 page 10.
Yes.
But second paragraph. Second paragraph.
Yes.
ನಮ್ಮ ಜಾತಿಯ ಜನಗಳು ಮತ್ತು 1ನೇ ಆವರ್ತನ ಜಾತಿಯ ಜನರ ನಾನು ಮೊದಲಿನಿಂದಲೂ 1ನೇ ಆವರ್ತನವನ್ನು ಗೆಲ್ಲಿಸಿದ್ದೆ. ಆದರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು 1ನೇ ಆವರ್ತನ ವಿಚಾರ ನನ್ನ ಮನೆಯಲ್ಲಿ ಸರಿಯಲ್ಲ. ಗಂಟೆಯನ್ನ ತುಂಬಿ ಬಸವರಾಜನು ನನ್ನನ್ನು ಗುರಿಯಾಗುವುದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಕ್ಕೆ ನಾನು ಮತ್ತು ನಮ್ಮ ಮನೆಯವರು ಆರೋಪಿ 4ರಿಂದ 7 1ನೇ ಆರೋಪಿಗಳ ತಂದೆಯ ಸ್ನೇಹಿತರು ಎಂದರೆ ಸರಿ. ಆರೋಪಿ 4ರಿಂದ 7 ನನ್ನ ತಂದೆ ತಾಯಿ ಕೊಡಿ 1ನೇ ಆರೋಪಿ ಮತ್ತು ಕುಡಿ 1ನೇ ಆರೋಪಿ ಮತ್ತು ಆತನ ತಂದೆ ತಾಯಿಗೆ ಖುಷಿ ಹೇಳಿ ನನ್ನ ಮಗುವಿಗೆ 1ನೇ ಆರೋಪಿ ಗಿರೀಶನಿಗೆ ಮಾಡಿಸಬೇಕು ಅಂತ ಕೇಳಿಕೊಂಡಿದ್ದರು ಸರಿ. 4ರಿಂದ 7ನೇ ಆರೋಪಿ ಅದೇ ಕಾರಣಕ್ಕಾಗಿ ಎಲ್ಲ ಆರೋಪಿಗಳನ್ನು ದ್ವೇಷ ಇಟ್ಟುಕೊಂಡು ಅವರ ಮೇಲೆ but nothing she has stated not except for the allegation in the complaint of it, there is no supporting evidence there returned to the victim on the mark itself. There is no evidence, but evidence she has stated against PW13. No evidence she has stated, typically stated against PW13, not this petitioner, not this accused. But even father of the page number 93, even father of the victim alert PW2, Euro and the garage para 9. ಆದ್ದರಿಂದ 7ನೇ ಆರೋಪಗಳು 1ನೇ ಆರೋಪಿ ಸಂದೇಶಕ್ಕೆ 4ರಿಂದ 7ನೇ ಆರೋಪಿ ನಮ್ಮ ಮನೆಗೆ ಅಂತ ಸಾಕ್ಷಿದಾರರಿಗೆ ಸೂಚಿಸಿದ್ದಕ್ಕೆ ನನ್ನ ಹೆಂಡತಿಗೆ ಗೊತ್ತಿರಬಹುದು ಎಂದು ಹೇಳಿರುತ್ತಾನೆ ಅಷ್ಟೇ.
He is not a complaint person. That was given to PW.
But he is aware that entire facts is having a knowledge. Next witness PW13. Page 117 was Sudhamani, PW13. ಕಂಪ್ಲೇಂಟ್ ಅವರ್ಮೆಂಟ್ಸ್ ಪ್ರಕಾರ PW ಎವಿಡೆನ್ಸ್ ವಿಕ್ಟಿಮ್ ಎವಿಡೆನ್ಸ್ ಪ್ರಕಾರ ಪಾರ್ಕ್ ಇಂದ ಇವರಿಗೆ ಎದುರಿಸಿ ಸುಧಾಮಣಿ ಹತ್ರ ಕರ್ಕೊಂಡ್ ಬರ್ತಾರೆ ಅಂತ ಇರೋದು. He has got taken to the blood commission office. Along with all the questions.
ನಮ್ಮಲ್ಲೆಲ್ಲ ಕೆಲವೊಂದು ವ್ಯಕ್ತಿಗಳು, ಕೆಲವೊಂದು ಸಂಘ ಸಂಸ್ಥೆಗಳು ಸಮಾಜ ಸೇವೆ ಹೆಸರಿನಲ್ಲಿ ಬೇರೆ ಏನೇನೋ ಮಾಡ್ತಾರೆ ಅಂತೆಲ್ಲ ಅಲಿಗೇಷನ್ಸ್ ಇದೆ. ಪ್ರಾಬಬಲಿ ಇದು ಅಂತದ್ದು ಒಂದು ಕೇಸ್.
ಉದಾಹರಣೆ ಗೊತ್ತೇ ಇಲ್ಲ except combined governments and PW one victim number. Any document that would get. I request for this court to confirm the judgment.
What about section 21?
But immediately we have got to the blood commission office, blood PW 13.
She herself, according to her case, she herself went there, commissioner. What is your role there?
As per complaint government, as of the day of the accused are present. Are present in the blood path. There are no went to the blood PW 13. PW 13 along with this person went to the police commission office. They are informed about the information given to the police.
Because the allegation is that you know very well that the day out of kidnap, you know very well all these things, and you are instructing those persons, that accused number 1 and accused number 2, how to escape from the police.
Complaint government subsequently Marnadina Batalia. Complaint specifically she has stated that the Marnadina or Chelvamba Park is Batalia, Alinda you was to.
ಹೌದ್ರಿ, ಚಲುವಂಬ ಪಾರ್ಸಿ ಬಂದ ಮೇಲೆ ಆದ್ರೂ ಕೂಡ
Also on the same day the PW 13 my also worked. PW 13 commission office worked.
PW 13 ಹೋಗುವ ಅವಶ್ಯಕತೆ ಎಲ್ಲಿತ್ತು?
That's
ನೀವು A3 to A7 ನೋಡಿ, ಚಲುವಂಬ ಪಾರ್ಕ್ ಅಲ್ಲಿ ನಾವೊಂದು ಬೈಠಕ್ ಮಾಡಿದಿವಿ. ಹುಡುಗಿನ ಮತ್ತೆ ಗಿರೀಶನ್ನ ಇಬ್ಬರನ್ನು ವಿಚಾರಿಸಿದ್ವಿ. ಗಿರೀಶ ಹುಡುಗಿನ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದ ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಾಯ್ತು. ಹಾಗಾಗಿ ಈ ಬಗ್ಗೆ ತಾವು ಸೂಕ್ತ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳಬೇಕು. ಅವ್ನು ಕಿಡ್ನಾಪ್ ಮಾಡಿದಾನೆ, ರೇಪ್ ಮಾಡಿದಾನೆ ಅಂತಲ್ಲ. ಸೊ ಒಬ್ಬ ಹುಡುಗ ಒಂದು ಹುಡುಗಿನ ಹಿಂಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿದಾನೆ ಅನ್ನೋದು ನಮಗೆ ಗೊತ್ತಾಯ್ತು. ಈ ಬಗ್ಗೆನೂ ಸೂಕ್ತ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳಿ ಅಂತವ್ರು ಪೊಲೀಸರಿಗೆ ಹೇಳ್ಬೋದಿತ್ತಲ್ವೇ? ಅದನ್ನ ಯಾಕೆ ಹೇಳಲಿಲ್ಲ? ಅದು ನಮ್ಮ ಬ್ರದರ್ ಲಾರ್ಡ್ಶಿಪ್ನ ಡೌಟ್. ಸೊ ಹಾಗಾದ್ರೆ ನೀವು ಪಾರ್ಶಿಯಲಿ ಡನ್ ಅಂತೀರಿ?
at least one of them is brought to the notice.
ಹೌದು. Yes.
First, the law is respected the judgment relied on the
Yes.
2021
Not brother, your learned friend. Yes, in your community, you have got the privilege of addressing your fellow practitioner as a learned friend. In our fraternity, we have got the privilege of addressing our colleague as brother. Don't encroach our field, we don't encroach your field. Yes.
my friend,
Huh.
the judgment, my lord, has not rendered looking into the rules and JJ Act and JJ Act. Therefore, my lord, I submit, my lord, this judgment is of no applicable to the present fact of the case because
No, repeat it.
this judgment
Huh.
has not applied the principle
of JJ Act and JJ rules, which gives the procedure for determination of age. This judgment does not apply to it.
ರೂಲ್ ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ ನಿಮ್ ಕೇಸ್ ಇನ್ನೂ ಕಷ್ಟ ಆಗುತ್ತೆ ಅಲ್ವೇ? ನೀವು ಸೊಂಟದವರೆಗೆ ಮೊಣಕಾಲು ಆಳದ ನೀರಿನಲ್ಲಿ ಇಳಿಯೋದ್ರ ಬದಲು ಸೊಂಟದವರೆಗೆ ಕೆಸರಲ್ಲಿ ಸಿಕ್ಕಂಡಂಗ ಆಗುತ್ತೆ. ನಿಮ್ಮದು JJ ರೂಲ್ಸ್ ನೀವು ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ ನೀವು ಮೊಣಕಾಲುದ್ದದ ನೀರಿನಲ್ಲಿ ನಿಂತು ನಾ ದಾಟ್ಕೊಂಡ್ ಬರ್ತೀನಿ ಅನ್ನೋದ್ರ ಬದಲು ಸೊಂಟ ಮಟ್ಟದವರೆಗಿನ ಕೆಸರು ಗುಂಡಿಯಲ್ಲಿ ಸಿಕ್ಕಿ ಬಿದ್ದಂಗ ಆಗ್ತದೆ ನಿಮ್ಮ ಕೇಸು ಅಲ್ವೇ? ನಾ ಬರ್ಕೊಳ್ತೇನೆ, ನನಗೇನ್ ತೊಂದರೆ ಇಲ್ಲ. ಲರ್ನೆಡ್ ಅಡಿಷನಲ್ SPP himself has stated this. ಇನ್ವೋಕ್ ಮಾಡ್ತೇನೆ ರೂಲ್ 12 of JJ ರೂಲ್ಸ್. ಯಾಕೆಂದ್ರೆ you yourself is inviting us to do that. ನಾವು ಬೇರೆದೊಂದೆರಡು ದಾರಿನೂ ನಿಮಗೆ ತೋರಿಸಿಕೊಟ್ವಿ ಆ ವಕೀಲರುಗಳು ಅಡ್ರೆಸ್ ಮಾಡುವಾಗ. ಅಲ್ಲ, ಅದಕ್ಕಾಮೇಲೆ JJ Act ಫಸ್ಟ್ ಹೇಳಿ. ಲೀವ್ ಇಟ್ ಅಂತಲ್ಲ, ನೀವೇ ಹೇಳಿದಿರಿ. ನೀವು ಲೀವ್ ಇಟ್ ಅಂದ್ರೆ ನಮ್ಮ ಹತ್ರನೇ ಇರ್ತದೆ. ನಿಮ್ಮ ನಾಯಿ ಮರಿ ಬಂದು ನಮ್ ಕಾಂಪೌಂಡ್ ಒಳಗೆ ದಾಖಲೆ ಮಾಡ್ತಿದೆ. ಅನ್ಲೆಸ್ ಯು ಕಾಲ್ ದಟ್ ನಾಯಿ ಮರಿ ಬ್ಯಾಕ್, ದಟ್ ವಿಲ್ ಬಿ ದೇರ್ ಇನ್ ಅವರ್ ಪ್ರೊಮೈಸಿಸ್. ವಾಪಸ್ ತಗೊಂಡು ಸರಿಯಾಗಿ ಕಟ್ಟಗಳಿ. ಕಟ್ಟಿ ಯಾಕೆ ನಾಯನ ಈಗ ಹೇಳಿ ಏನ್ ಹೇಳ್ತೀರಿ ಅಂತ. Yes.
The evidence of doctor and evidence of school teacher. Both they have not denied. And first take the lordship to the evidence of doctor.
PW 10 or 11. Arpita.
Yes.
Yes.
My lords, in that evidence, that he recorded the age of the victim in 14 years.
ಎಲ್ಲಿದೆ ಇದು?
The exhibit ಅಲ್ಲೂ ಇದೆ.
ಅಲ್ಲ, ಎವಿಡೆನ್ಸ್ ನಲ್ಲಿ ಇದೆ ರೆಕಾರ್ಡೆಡ್ ಏಜ್ 14 years ಅಂದ್ರಿ. ಅದನ್ನ ನಮ್ಗೊಮ್ಮೆ ತೋರಿಸಿ ಬಿಡಿ, ಆಮೇಲೆ ಮುಂದೆ ಹೋಗೋಣ.
ನಿಶಾನದಿ 20ರಲ್ಲಿ
ತಾಯಿ ಹೇಳಿದ್ದಾರೆ ಮೇರೆಗೆ ಆಕೆಯ ವಯಸ್ಸನ್ನು 14 ವರ್ಷ ಎಂದು ನಮೂದಿಸಿದ್ದೇನೆ. ಎಸ್. ಸೊ ಎಕ್ಸಿಬಿಟ್ ಅಲ್ಲಿ ಏನ್ 14 years ಅಂತಿದೆ, ದಟ್ ಈಸ್ ದಿ ಸೇಯಿಂಗ್ ಆಫ್ ದಿ ಮದರ್ ಆಫ್ ದಿ ಗರ್ಲ್.
It is not that case that the age of the victim is not 14 years.
That is not a relevant question for that.
It is not asked. I am saying it is not asked or it is not even suggested.
It is not her independent opinion. It is only hearsay. Whatever she is getting, got information from PW1 and her mother noted in that is a certificate. If it was the opinion of the doctor, then your submission might be right.
Like even actually the observation error, but my submission is that their own suggestion to the doctor is that the mother, according to mother, it is at age 14 years. They could have suggested to her saying that this victim is not 14 years.
The doctor has not opined that victim was aged 14 years. Kindly please, if the doctor has opined that in my examination of the girl, I notice or I could notice that she was aged between 14 to 15 years or 14 years or 16 years, then probably the liability and the part of the defense counsel to deny the same would have arisen. But when the witness herself makes it clear, my mentioning of the age of the girl is based upon the information given to me by the mother of the girl. Yes, they thought it is the mother of the girl who has stated this. Doctor has copied that. Therein it is hearsay. It is not the medical opinion of the doctor. Why should they deny that?
I say, my lord, she being a doctor,
Huh.
she examined the victim.
Huh.
So she admitted that she examined the victim. May not necessarily for the purpose of age.
She has examined the witness.
Therefore, I say, my lord, she is competent witness to say approximate age of the victim.
ಈಗ ಅದೇನು ಓದಿದ್ರಿ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಓದಿ. ಈಗ ಎಲ್ಲಿಗೆ ನಿಲ್ಸಿರಿ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್?
ಈಗ ಒಂದು ದಿನ ಅಂದಾಜು ವಯಸ್ಸಿನ ದೃಢೀಕರಣಕ್ಕಾಗಿ ವೈದ್ಯ ನ್ಯಾಯಶಾಸ್ತ್ರ ವಿಭಾಗಕ್ಕೆ ಕರೆದೊಯ್ಯಬೇಕಾದ ಪೊಲೀಸರಿಗೆ ನಾನು ತಿಳಿಸಿದ್ದೇನೆ.
ಅಂದ್ರೆ ಏಜ್ ಬಗ್ಗೆ ನಾನೇನು ಗ್ಯಾರಂಟಿ ಇಲ್ಲ, ಅಸರ್ಟೈನ್ ಮಾಡ್ಲಿಲ್ಲ. ಅವಳು ವಯಸ್ಸು ಕುರಿತಂತೆ ಇನ್ನೊಂದು ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದೆ, ಆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಕರ್ಕೊಂಡು ಹೋಗ್ರಿ ಅಂತ ನಾ ಪೊಲೀಸರಿಗೆ ಹೇಳಿದ್ದೆ. ಅಂದ್ರೆ ಏಜ್ ಬಗ್ಗೆ ಈಕೆ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತಿಲ್ಲ, ಡಿನೇನು ಮಾಡ್ತಾ ಇಲ್ಲ. ಏಜ್ ಬಗ್ಗೆ ಇವಳದ್ ಏನು ಒಪಿನಿಯನ್ ಇಲ್ಲ. ಸೆಕ್ಷುವಲ್ ಅಸಾಲ್ಟ್ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಮಾತ್ರ ನಾನು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದೇನೆ, ನನ್ನ ರಿಪೋರ್ಟ್ ಅದ್ರ ಬಗ್ಗೆ ಮಾತ್ರ. ಸೋ ಫಾರ್ ದ ಏಜ್ ಇಸ್ ಕನ್ಸರ್ನ್, ಟೇಕ್ ಹರ್ ಟು ದಿ ಅನದರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
That's correct. That's correct. My lord. She is not given an opinion about the age.
Yes.
But I say, my lord, that she being a doctor, she is an expert. Since she is examining the victim for whatever, not necessarily for the age purpose, my lord, but
No, she is a doctor. Expert in what?
she is
Expert in determination of age? No. Had she been expert in determination of age, she would not have asked the police to take her to some other section. By suggesting to the police that the girl must be taken to another section for determination of age, the doctor has shown that she is not expert in determining the age of a victim. ನೀವು ನಮ್ಮ ಕೋರ್ಟಲ್ಲಿ ಇದ್ದೀರಿ. Exhibit P20, take it.
the evidence she has given, I take contrary to exhibit P20. Sorry, my lord,
ಬರ್ತದೆ ಆ ಪ್ರಶ್ನೆ, ನಿಮಗೂ ಗೊತ್ತಿದೆ. ನೀವು ಅದಕ್ಕೆ ಈಗಲೇ ತಯಾರಾಗಿ ಸಾರಿ ಮೈಲಾರ್ಡ್ ಅಂತ ಕೇವೇಟ್ ಹಾಕ್ತಿದ್ದೀರಿ. Exhibit P20 is the opinion, the answers to the question.
Yes, sir. Answer, depending on history and clinical examination, I am at the opinion that she is used to an act that of the sexual intercourse. That there is no dispute, my lord, she is given evidence. Now, and could not collect any evidence of recent sexual intercourse. With P20 says, I could not collect evidence of recent sexual intercourse. She is not saying that there is no recent sexual intercourse.
ನಿಮ್ಮ ಕನ್ನಡ ಬಹಳ ಸುಂದರವಾಗಿದೆ, ಇನ್ನೊಮ್ಮೆ ಹೇಳಿ ನೋಡೋಣ.
ಸೆಕ್ಷುವಲ್ ಇಂಟರ್ಕೋರ್ಸ್ ಆಗಿ ಸಂಬಂಧಪಟ್ಟಂತ ಎವಿಡೆನ್ಸ್ ಗಳನ್ನ ನಾನು ಕಲೆಕ್ಟ್ ಮಾಡಿ
ಆ ವಿದ್ಯಾರ್ಥಿಯನ್ನು ಮುಂದಿನ ವರ್ಗಕ್ಕೆ ಉತ್ತೀರ್ಣನೆಂದು ಕಳುಹಿಸಲು ನನಗೆ ಯಾವುದೇ ಅಂಶಗಳು ಕಂಡು ಬರುತ್ತಿಲ್ಲ. ಅದರ ಅರ್ಥ ಫೇಲ್ ಅಂತ ಅಲ್ವೇ?
not collect any evidence of recent sexual intercourse.
ಹೌದು, ರೀಸೆಂಟ್ ಸೆಕ್ಷುವಲ್ ಇಂಟರ್ಕೋರ್ಸ್ಗೆ ಏನು ಇಲ್ಲ ಸೈನ್ಸು, ಹಾಗಾಗಿ ಕುಡ್ ನಾಟ್ ಕಲೆಕ್ಟ್. ಏನಾದ್ರೂ ಇದ್ದಿದ್ರೆ ಕಲೆಕ್ಟ್ ಮಾಡ್ತಿದ್ದೆ. ಆತರ ಬರ್ದಲ್ಲ, ಅದೇ ಅರ್ಥ ಅದು. ಅದಕ್ಕೆ ನಾನು ನಿಮಗೆ ಸಾಮಾನ್ಯ ಜನಗಳಿಗೂ ಅರ್ಥ ಆಗಂತ ಉದಾಹರಣೆ ಕೊಟ್ಟೆ. ನೀವು ಅದನ್ನ ಅರ್ಥ ಆದ್ರೂ ಆಗಿಲ್ಲ ಅಂತ ನಡೆಸಿದ್ರೆ ನಾನೇನ್ ಮಾಡ್ಲಿ? ಅವನನ್ನು 9ನೇ ಇಯತ್ತಿಗೆ ಕಳುಹಿಸುವ ಯಾವುದೇ ಸೂಕ್ತ ಅಂಕಗಳು ನನಗೆ ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಪೇರೆಂಟ್ಸ್ ಬಂದು ಕೇಳ್ತಾರೆ, ಮೇಷ್ಟ್ರು ಈ ಉತ್ತರ ಕೊಡ್ತಾರೆ, ಪಾಸ್ ಆಗಿಲ್ಲ ಅನ್ನೋದನ್ನ ಹೆಂಗೆ ಹೇಳ್ತಿದ್ದಾರೆ? ಅವ್ನು ಪೇಲು ಅನ್ನೋದನ್ನ ಪೇಲು ಅಂತ ಹೇಳ್ತಿಲ್ಲ. ನಾನು ಕಳ್ಸೋಣ ಅಂತಾನೆ ಇದ್ದೆ ಮುಂದಿನ ಸೆಕ್ಷನ್ಗೆ. ಏನ್ ಮಾಡೋದು ಹೇಳ್ರಿ? 2 ಎಂಟ್ಲಿಂದ್ರ ಇದ್ದು 4 ಅಂತ ನಾನು ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳ್ರಿ? 9ನೇ ಕ್ಲಾಸ್ಗೆ ಹೆಂಗ್ ಕಳಿಸ್ಲಿ?
ಕಾರ್ ನಂಬರ್ 10 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ, ನೀವ್ ಹೇಳಿದ ಆನ್ಸರ್.
That is where not sent because clothes were washed and not brought with them. Pubic hair, vaginal semen were not taken as patient has demonstrated after the act of and
how she could collect it.
That is my submission.
No, your previous sentence is different from what the doctor says. He says he has not collected recent evidence regarding the sexual.
ಹೌದಲ್ಲ, ನಾಟ್ ಕಲೆಕ್ಟಿಂಗ್ ಅಂತಲ್ಲ. ಅದ್ರ ಅರ್ಥ ಅದೇನು ಆಗಿಲ್ಲ ಅಂತಲ್ಲ, No signs of recent sexual intercourse does not mean there is no recent sexual intercourse. There may be recent sexual intercourse, but she could not collect the signs. ಅದು ಅವರ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಯಾಕೆಂದ್ರೆ ಎವಿಡೆನ್ಸ್ ಅಂತ ಒಂದ್ ಸ್ವಲ್ಪ
ಎಲ್ಲ ದೊಡ್ಡ ಮಿಸ್ಟೇಕ್ಗಳು ನಿಮ್ ಎಲ್ಲರದ್ದು ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ಅನಾಕರು, ತರಾಸು, ಕಾರಂತರು, ಅವ್ರು ಯಾರ ಕೃತಿಗಳನ್ನೂ ಓದ್ಲಿಲ್ಲ, ಹೆಸರು ಕೇಳೋದು ಹೋಗಿ, ಅವ್ರ ಹೆಸರು ಕೇಳಿದ್ದೀರೋ ಇಲ್ವೋ, ಹಂಗಾಗಿ ನಿಮ್ದೆಲ್ಲ ಕನ್ನಡಗಳು ಹೀಗೆ ಬರ್ತಾರೆ. ಅವರು ಓದಿದ್ದು ನೀವು ಅದನ್ನ ತರ್ಜುಮೆ ಮಾಡಿ ಹೇಳ್ತಾ ಇರೋದು.
ಎವಿಡೆನ್ಸ್ ಅಂತ ಹೇಳ್ಬೋದು.
ಹಾ, ಓದಿ.
Phase 2 ನಲ್ಲಿ PW
ಎಸ್
11
ಎಸ್
Phase 1 Phase 1
ಎಸ್ ಅಲ್ಲೇ
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾದಲ್ಲಿ
ಎಸ್
PW1 ಪ್ರೀತಿಯಾದ ಹಾಗೂ PW1 ದಿನ ವೈದ್ಯಕೀಯ ಪರೀಕ್ಷಿಸಿದ ಆಧಾರದ ಮೇಲೆ PW1 ಲೈಂಗಿಕ ಸಂಭೋಗದಂತಹ ಕ್ರಿಯೆಗೆ ಒಳಪಟ್ಟಿದ್ದು. ಆದರೆ ಇತ್ತೀಚೆಗೆ ಆಕೆಯ ಲೈಂಗಿಕ ಸಂಭೋಗದಂತಹ ಕ್ರಿಯೆಯಲ್ಲಿ ಒಳಪಟ್ಟಿದ್ದರ ಕುರಿತು ಯಾವುದೇ ಕುರುಹುಗಳು ಕಂಡು ಬಂದಿಲ್ಲ ಎಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟಿರುತ್ತೆ.
ಏನಾದ್ರು ಅರ್ಥ? ಈಗ ಅವರು ಅದೇ ಒಂದು ಪ್ರಯತ್ನ ಮಾಡಿ ಎಲ್ಲಾ ಮಿಸೈಲ್ಸ್ಗಳು, ಉಕ್ರೇನ್ ವಾರು, ಹಮಾಸ್ ವಾರು, ಗಾಜಾ ಸ್ಟ್ರಿಪ್ ಎಲ್ಲದೂ ಅವ್ರ ಮೇಲೆ ಬಂಬಾರ್ಡ್ ಆಯ್ತು. ಈಗ ನೀವು ಮತ್ತೆ ಅದನ್ನೇ ಕೇಳ್ತಿದ್ದೀರಿ. ನಮ್ಮಲ್ಲಿ ಇನ್ನೂ ವೆಪನ್ ಸ್ಟಾಕ್ ಇದೆ, ಎಲ್ಲ ಮಿಸೈಲ್ಸ್ ನಿಮ್ಮ ಮೇಲೂ ಬಿಡೋಣ. ಕೇಳಿ ಏನಾದ್ರು ಅರ್ಥ? ಅದ್ರ ಅರ್ಥ ಏನ್ ಹೇಳಿ? ಈಗ ನೀವು ತಾವು ಓದಿದ್ರಿ.
ಅವರ ಅರ್ಥ
ಹಾ
ಯಾವುದೇ ಕುರುಹುಗಳು ಇರಲಿಲ್ಲ ಅಂತ.
ಹಾ
ಇಲ್ಲಿ
ಹಾ
ನಾನು ಅರ್ಥ ಮಾಡ್ತೀನಿ,
ಹಾ
ಕುರುಹುಗಳನ್ನು ಕಲೆಕ್ಟ್ ಮಾಡಲಿಲ್ಲ.
ಹಾ ಕಲೆಕ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅನ್ನೋದನ್ನ ಅವರು ಎವಿಡೆನ್ಸ್ ನಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅದು ಇಂಪಾರ್ಟೆಂಟ್ ಅಲ್ವೇ? ನಂಬರ್ 1 ಎವಿಡೆನ್ಸ್ ನಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅದು ಇಂಪಾರ್ಟೆಂಟ್. ಎಕ್ಸಿಬಿಟ್ P20 goes to the background when the very same author of exhibit P20 has been examined as given in evidence. Number 2, what he has stated, what she has stated in her evidence in the paragraph what read can be inferred even in exhibit P20 also. When you read that exhibit P20, which runs into around 11 lines in its entirety, in the last 3 lines, what my brother lordship just now drew your attention towards the same, that says why she could not collect, because there were nothing. It was ಅದೇ ಸ್ನಾನ ಎಲ್ಲ ಮಾಡಿದ್ಲು, ಋತುಮತಿ ಆಗಿದ್ಲು, ಎಲ್ಲದೂ ಮುಗ್ದು ಹೋಗಿತ್ತು. ಹಾಗಾಗಿ ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ಯಾವ ಕುರುಹುಗಳು ಇಲ್ಲ, ಹಾಗಾಗಿ ಕುಡ್ ನಾಟ್ ಕಲೆಕ್ಟ್ ಅಷ್ಟೇ. ಅದಕ್ಕೋಸ್ಕರವೇ there is no signs of recent sexual intercourse. ನೀವು ಫಸ್ಟ್ ನಮ್ಮನ್ನು ಏಜನ್ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ ಆಮೇಲೆ ಇದಕ್ಕೆ ಬರೋಣಂತೆ. That judgment relied upon by him.
That judgment, my lord, I say
ನೀವು ಬಿಟ್ಟಿದ್ ನಾಯಿನ ವಾಪಸ್ ಕಟ್ಕೊಂಡ್ರಿ, ಆಮೇಲೆ ಮತ್ತೆ ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಲೇ ಇಲ್ಲ. ನೀವು ನಿಮ್ಮ ಅಂಗಳದಲ್ಲಿ ಸುಮ್ಮನೆ ಕೂತ್ ಬಿಟ್ಟಿದ್ದೀರಿ.
present JJ rule applicable even for old acts ಅಂತ ಒಂದು ಟ್ರೈನಿಂಗ್ ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಇದೆ. I have not done the research, ಅದಕ್ಕೋಸ್ಕರ ಅದನ್ನ ವಾಪಸ್
ಹಾಗಾದ್ರೆ ಮತ್ತೆ ಮುಂದುವರಿಬೇಡಿ. ಆ ನಾಯಿಗೆ ಸ್ವಲ್ಪ ಊಟ ಗೀಟ ಎಲ್ಲ ಚೆನ್ನಾಗಿ ಹಾಕಿ ಚೆನ್ನಾಗಿ ಸ್ವಲ್ಪ ದಷ್ಟಪುಷ್ಟ ಮಾಡಿ ಆಮೇಲೆ ನಮ್ ಕಾಂಪೌಂಡಿಗೆ ಓಡಿಸಿ. ಟೇಕ್ ಡೌನ್. Additional SPP for the appellant and learned counsels for the respondents are physically present. Heard the further argument in full from the learned counsel for respondent number 1 and 2 and arguments from learned counsel for respondent number 3 to 6. The learned SPP prays for a short accommodation for his reply. List the matter on 4th December 4/12/2023 reply. Yes.
Number 4. SPP, S.
On
Javed,
the top of the list.
serial number 4, SPP, S. Javed, amicus curiae.
ಫೌಂಡೇಶನ್ ಹಾಕಿ ಸೈಜ್ಗಳನ್ನೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಇಟ್ಟು ಸ್ವಲ್ಪ ಸಿಮೆಂಟ್ ಚೆನ್ನಾಗಿ ಮಿಕ್ಸ್ ಮಾಡಿ ಒಳ್ಳೆ ಕಾಂಕ್ರೀಟ್ ಹಾಕಿ ಕಾಂಪೌಂಡ್ ಕಟ್ಟ್ರಿ ಅಂದ್ರೆ ತೇಜೇಶ್ ಅವರು ಗಡಿಬಿಡಿಯಲ್ಲಿ ಏನು ಇಲ್ಲದ ಹಾಗೆ ಮಣ್ಣಿನಿಂದ ಒಂದು ಗೋಡೆ ಕಟ್ಟಿಬಿಟ್ಟಿದ್ದಾರೆ ಈಗ. ಸೊ ಈಗ ನಿಮ್ಮದು ಕಾಂಪೌಂಡ್ ಆಯ್ತೋ ಇಲ್ವೋ? Is it not the case of building of a compound wall around the house? The dairy people objecting to the same. ಓದ್ಲಿಲ್ಲ ನೀವು. What the case is about? ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಹೇಳಿದ್ರಿ, ಅದಕ್ಕೆ ಬರೀ ಹಂಗೆ ಹೇಳಿದ್ರೆ ಆಗಲ್ಲ, ದಕ್ಷಿಣ ಸಮೇತ ಬರಬೇಕು. ತಂದಿದ್ದೀರಿ, ಗರಿ ಗರಿ ನೋಟೆ ತಂದಿದ್ದಾರೆ. ಯು ಆರ್ ಲಕ್ಕಿ. ಅದು ಅಯ್ಯೇ ಇರ್ಬೇಕು ನೋಡ್ರಿ ರೆಕಾರ್ಡಿಂಗ್. ಹಾಕಿದ್ದೆ. ಸೊ ಲಾಸ್ಟ್ ಟೈಮ್ ಇದ್ದಿದ್ದೆಲ್ಲ ಫಿಲ್ ಇನ್ ದ ಬ್ಲಾಂಕ್ಸ್ ಆಯ್ತು. ಎಲ್ಲ ಇರ್ತಾರೆ, ಇಲ್ಲೇ ಸುತ್ತಮುತ್ತ ಇರ್ತಾರೆ. ನಿಮ್ ಬಲಗಡೆ ಜೇಬಲ್ಲಿ ಎಡಗಡೆ ಜೇಬಲ್ಲಿ ಕ್ಲೈಂಟ್ಗಳು ಇರ್ತಾರೆ, ನಿಮ್ಮ ಹಳೆ ವಕೀಲರು ಇರ್ತಾರೆ. ಅವೆಲ್ಲ ಅದು ಕೋರ್ಟ್ ಮುಂದೆ ಅದೆಲ್ಲ ಏನೇನೆಲ್ಲ ಕೋರ್ಟ್ ಎದುರು ಭೂಚಕ್ರ, ವಿಷ್ಣು ಚಕ್ರ, ಮಸಿ ಕುಡಿಕೆ ಬಿಡಬಹುದು, ಎಲ್ಲವನ್ನೂ ಬಿಡ್ತೀರಿ ಪಟಾಕಿಗಳು. ಹಾ ಹಾ learned HCGP for the appellant and learned amicus curiae for respondent, learned counsel Sri S. Javed as amicus curiae for respondent number 1 to 4, and learned counsel Sri Vinay Kirti M are physically present. Subsequent to the observation made on 24/11/2023, the learned counsel Sri Vinay Kirti has filed an application under section 482 of CRPC seeking withdrawal of the appointment of the amicus curiae and permitting him to represent respondents 1 to 4. ಅದರಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಎಷ್ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಬರೀರಿ. ಬರೀ respondents 1 to 4. He has also filed a fresh wakalat for respondents number 1 to 4. There is the IA 1/23. Considering the reasons shown therein, more particularly of the fact that the respondents number 1 to 4 have again chosen to opt for the advocate of their choice. As such, the choice of the respondents 1 to 4 of engaging the services of their counsel is required to be considered. IA 1/23 deserves to be allowed. However, at the same time, considering the effort and the labor put forth by last time ನೀವು ಅದರಲ್ಲಿ ವರ್ಡ್ ಅಲ್ಲಿ ಒಂದು ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ರಿ. Put forth by learned amicus curiae, we are of the view that the applicant is required to consider the same by paying the honorarium to the learned amicus curiae. Accordingly, IA 1/23 stands allowed, and the order appointing the learned amicus curiae, the order appointing learned counsel C.H. Javed as amicus curiae, and the order appointing Beda stands allowed, and learned amicus curiae C.H. Javed stands relieved from appearing for respondent number 1 to 4. However, upon an honorarium payable to him by the applicant, upon the honorarium of a sum of ₹3,000 payable by the applicant. Iskolri. The next slide. Learned amicus curiae acknowledges the receipt of the honorarium. The learned counsel Sri Vinay Kirti, the wakalat filed by learned counsel Sri Vinay Kirti for respondent number 1 to 4 is taken on record. He is permitted to appear for respondent number 1 to 4 and to proceed further in the matter without taking any adjournment. Yes, proceed, please. You are relieved.
Charges are 504 per line. And last charge is that section 3 class I and
504, 506.
504 and
506. SC Act 3110, 325.
With respect to the SC Act is concerned, my first argument is the start of that charge. With respect to that, it is neither in the complaint nor in the evidence. There will be no such statements for
Averment regarding what?
with respect to the atrocity. With respect
No,
to-
whether,
with respect to the charges concerned, the atrocity of the
what it requires. 3110, 325. What it requires.
it requires that there should be a word used in a public, the specific words. Kindly, for that reason, Your Worship, there is no iota of the amendments about that the accused persons were used that word caste by taking the name of the caste.
Hmm.
Neither the evidence. First, Your Worship, permit me to take out the complainants in Sharda PW1 evidence. Examination sheet. ನಾನು ಭೂಮಿ ಜನಾಂಗಕ್ಕೆ ಸೇರಿರುತ್ತೇನೆ.
ಒಂದು yes. PW.
One.
SHB quickly. Yes.
ನಾನು ಭೂಮಿ ಜನಾಂಗಕ್ಕೆ ಆರೋಪಿತರು ಸರ್ವ ಒಕ್ಕಲಿಗ ಜಾತಿಗೆ ಸೇರಿದವರಾಗಿದ್ದಾರೆ. ಸುಮಾರು 1.5 ವರ್ಷದ ಹಿಂದೆ ನಮ್ಮ ಮನೆಯ ಹತ್ತಿರ ಕಾಂಪೌಂಡ್ ಗೋಡೆ ದಿನಾಂಕ 5/12/2017 8 ಗಂಟೆಗೆ ನಾನು ನಮ್ಮ ಯಜಮಾನರು ಎಲ್ಲ ಆರೋಪಿತರು ಹೇಗೆ ಕಟ್ಟುತ್ತೀಯಾ ಅಂತ ನಿನ್ನ ತಾನಾಡ ನಿನ್ನ ಅಮ್ಮನಾಡ ಎಂದು ಬೈದು ಜಾತ 2ರವರ ಮನೆಯಿಂದ ಒಂದು ಮತ್ತು 2ನೇ ಆರೋಪಿತರು ದೊಣ್ಣೆಗಳಿಂದ
ಅಷ್ಟೇ ಬೈಗಳ ಬಗ್ಗೆ ಅಷ್ಟೇ ಇರೋದು.
ಅಷ್ಟೇ ಇಲ್ಲದ ಬಗ್ಗೆ in examination PW2 is the witness. ನನ್ನ ವಿದ್ಯಾರ್ಥಿ ಆಗಬೇಕು ಆರೋಪಿತರು ನನಗೆ ಗೊತ್ತಿರುತ್ತಾರೆ. ನಮ್ಮ ಮನೆಯ ಪಾಲಿನ ಕೈಯಲ್ಲಿ ನಮ್ಮ ಮನೆಯ ಕಾಂಪೌಂಡ್ ಕಟ್ಟಲು ದಿನಾಂಕ 5/12/2012 ನಮ್ಮ ಮನೆ ಮುಂದೆ ಏಕರಿಸಿದರು. ನಾನು ಒಂದು ರಾತ್ರಿ 8 ಗಂಟೆಗೆ
ಅವನೇನು ಹೇಳಿಲ್ಲ ಬಿಡಿ, ಹೊಡೆದಿದ್ದನ್ನೆಲ್ಲ ಹೇಳಿದಾನೆ, ಬೆದರಿಕೆ ಹಾಕಿದ್ ಹೇಳಿದಾನೆ.
He is not all. Only one awareness with respect to the Manjunath PW3. ಇದರಲ್ಲಿ ಅವರು ಒಂದು ಯೂಸ್ ಮಾಡಿ ನನ್ನ ಅತ್ತೆ ಪ್ರಾಸ ಒಂದು ನನ್ನ ಅತ್ತೆ ನನಗೆ ಮಾವನಾಗಬೇಕು. ದಿನಾಂಕ 5/12 ನಾನು ಹೋಗಿದ್ದೆನು. ನಾನು ಹೋದಾಗ ಪ್ರಾಸಕ್ಕೆ ಗಟ್ಟಿಯಾಗಿ ಕೂಗಿಕೊಳ್ಳುತ್ತಿದ್ದರು. ನ್ಯಾಯಾಲಯದ ಮುಂದೆ 4 ಮತ್ತು 2ನೇ ಆರೋಪಿತರು ಪ್ರಾಸ 2ರವರೆಗೆ ನಾನು ಮತ್ತು ಪ್ರಾಸ 1ರವರೆಗೆ ತಿಳಿಸಲು ಹೋದೆವು. ಆರೋಪಿತರು ನನಗೆ ನೀನು ಯಾರ ಸಪೋರ್ಟ್ ಮಾಡಲು ಬಂದಿದ್ದೀಯಾ ಎಂದು ಒಡ್ಡರ ಮಗನೇ ಏನು ಸಪೋರ್ಟ್ ಮಾಡುತ್ತೀಯಾ ಎಂದರು. ನಾನು ಸಹ ಒಡ್ಡರ ಚರ್ಚೆಗೆ ಸೇರಿದವನೇ. ಆರೋಪಿತರು ನನ್ನ ಮೇಲೆ ಜಗಳಕ್ಕೆ ಬಂದಿದ್ದರು. ನಾನು ಅಲ್ಲಿಂದ ಹೊರಟು ಹೋದೆನು.
Yes.
ಒಡ್ಡ ನನ್ನ ಮಗನೇ ಏನು ಸಪೋರ್ಟ್ ಮಾಡುತ್ತೀಯಾ ಎಂದರು. Whether he belongs to the Vada community or other things or he is a Dandina Dippa Madhagiri Talos. In his cross examination he stated that ನಾನು ಈ ಘಟನೆ ವಿಚಾರಣವಾಗಿ ಪೊಲೀಸರನ್ನು ಹೇಳಿಕೆ ನನ್ನ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದಿಲ್ಲ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ in the cross examination second paragraph. ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗುವಷ್ಟರಲ್ಲಿ ಜಗಳ ಆರಂಭವಾಗಿದೆ. ನಾನು ತಕ್ಷಣ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋಗಿ ಫಿರ್ಯಾದಿ ಕೊಟ್ಟಿಲ್ಲ. ಪೊಲೀಸರು ನನ್ನ ಘಟನೆ ವಿಚಾರಣೆ ಮಾಡಿ ಹೇಳಿಕೆ ಪಡೆದಿಲ್ಲ. ವಿಚಾರಣೆ ಒಂದನ್ನು ನಾನು ಬರೆದಿಲ್ಲ. ನಾನು ಠಾಣೆಗೆ ಆದೇಶವನ್ನು ನೀಡಿದ್ದೇನೆ. ನಾನು ಪ್ರವಾಸವನ್ನು ಮಾತ್ರ ಠಾಣೆಗೆ ಹೋಗಿದ್ದೇನೆ. 6 to 5. Most important thing is that on that day, he was not at all present. That is the evidence of Sharda. In her cross-examination, sixth paragraph, ಅದು ಸ್ಟಾರ್ಟ್ ಆಗೋದು ನಾನು ದಿನಾಂಕ 6/12/2012
Cross examination. Yes. Yes. Yes.
ಇದರಲ್ಲಿ ಲಾಸ್ಟ್ ಮಂಜುನಾಥನು ಘಟನೆ ನಡೆದ ಮರುದಿವಸ ನಮ್ಮ ಊರಿಗೆ ಬಂದಿರುತ್ತಾನೆ. ಸದರಿ ಮಂಜುನಾಥ ಕಲ್ಲಿನ ಮಾಡುತ್ತಾರೆ. ಕೋವಿ ಸಂಘದ ಕಾರ್ಯಾಲಯ ಇದ್ದರೆ ಸ್ತ್ರೀಯರು.
ಒಬ್ಬನೇ ಮಂಜುನಾಥನ ಇರೋದು ಇಡೀ ಕೇಸಲ್ಲಿ.
ಒಬ್ಬನೇ ಮಂಜುನಾಥ.
Whether the complaint was given on the same day of the incident?
No. Your Lordship, according to them, is that allegation
8 days.
took place on 5.
5/12, complaint given on 13/12.
First, I demonstrate that Manjunath in his evidence he stated that word, but that Manjunath was not at all present on that day. Second argument with respect to the charges, Your Lordship, kindly take up the past examination of Prosecution first.
1 minute. Yes, please.
That in my respect to my second argument is concerned, Your Lordship. Past examination of Prosecution.
Second argument on same SC/ST. PW1 cross examination.
ನನಗೆ ಇಬ್ಬರು ಗಂಡು ಮಕ್ಕಳು ಇರುತ್ತಾರೆ.
Cross examination beginning. Yes. Yes.
ನನಗೆ ಇಬ್ಬರು ಗಂಡು ಮಕ್ಕಳು ಇರುತ್ತಾರೆ.
Yes.
ಒಬ್ಬ ಮಗ ಮಡಿಕೇರಿಯಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತಾರೆ. ದೊಡ್ಡ ಮಗ ನಮ್ಮ ಪಕ್ಕದ ಮನೆಯ ಸಂಸಾರದೊಂದಿಗೆ ವಾಸವಾಗಿರುತ್ತಾರೆ. ನಮ್ಮ ಮನೆಯ ಎದುರಿಗೆ ಚಿಕ್ಕಣ್ಣನವರ ಮುತ್ತಣ್ಣ ಅವರ ಸಂಸಾರದ ಜೊತೆ ವಾಸವಾಗಿರುತ್ತಾರೆ. ನಮ್ಮ ಮನೆಯ ಪಕ್ಕದಲ್ಲಿ ರಂಗಸ್ವಾಮಿ, ನಮ್ಮ ಮನೆಯ ಹಿಂಭಾಗದಲ್ಲಿ ಹನುಮಂತಯ್ಯನ ವಾಸದ ಮನೆ ಇರುತ್ತದೆ. ನಮ್ಮ ಮನೆಯ ದಕ್ಷಿಣದ ಕಡೆಗೆ ಮೇಲದ ಹಳ್ಳಿಗೆ ಹೋಗುವ ರಸ್ತೆ ಇರುತ್ತದೆ. ಮೊದಲನೇ ಆರೋಪಿ ಡೈಲಿ ರಂಗಸ್ವಾಮಿ ಪಕ್ಕದಲ್ಲಿ ನಮ್ಮ ಊರಿನಲ್ಲಿ ವಾಸಿಸುವ ಮನೆಗಳು ಇವೆ. argument is that there is so many neighbors next to his son and daughter-in-law. None of them were. Prosecution is not taken any steps to examine any one of them, whether that words is in public or not. None of them were examined. No statements was taken either neighbors from his own son who is residing in next to their house. Only the person who is
ಮಗನಿಗೂ ಅವರಿಗೇನೋ ಸರಿ ಇಲ್ಲ ಅನ್ನೋದು ಯಾವ್ದೋ ಒಂದು ವಿಟ್ನೆಸ್ಸಿನ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಂದಿದೆ ನೋಡಿ.
ಆದ್ರೆ ಅವರು ನಾವು ನಿಮ್ಮ ಮಗನಿಗೂ ಸೊಸೈಟಿ ಸರಿ ಇಲ್ಲ ಅಂತ ನಾವು ಕ್ವಶನ್ ಪೋಸ್ ಮಾಡಿದ್ದೀವಿ. ಅವ್ರು ಇಲ್ಲ ನಾವು ಚೆನ್ನಾಗಿದ್ದೀವಿ ಅಂತ
ಅಲ್ಲ ಆದ್ರೆ ನೀವೇ ಹೇಳಿದ್ದೀರಿ, ಯು ಯುವರ್ ಸೆಲ್ಫ್ ಹ್ಯಾಸ್ ಸಜೆಸ್ಟೆಡ್ ಸಂಬಂಧ ಸರಿ ಇಲ್ಲ ತಂದೆ ಮಗನಿಗೆ ಅಂತ ನೀವೇ ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ದೀರಿ. ಯು ಕುಡಂಟ್ ಹ್ಯಾವ್ ಸಜೆಸ್ಟೆಡ್ ಇಟ್. When you yourself have suggested the answer to the same, denying the suggestion go to background, you cannot made use of that answer when you yourself have suggested.
But the fact is that ಚೆನ್ನಾಗಿದ್ದೀವಿ ಪಕ್ಕದಲ್ಲಿ ಇದ್ದಾನೆ, but the prosecution is not taken their statement or any type of.
That cannot be fact because you have not admitted it as fact. According to you, ಸಂಬಂಧ ಸರಿ ಇಲ್ಲ. ಹಾಗಾಗಿ ಬಟ್ ಫ್ಯಾಕ್ಟ್ ಇಸ್ ದಟ್ ಅಂತ ನೀವು ಹೇಳಲಿಕ್ಕೆ ಬರಲ್ಲ. ಫ್ಯಾಕ್ಟ್ ಇಸ್ ದಟ್ ಆದ್ರೆ ನೀವು ಆ ಸಜೆಷನ್ ಮಾಡಬಾರ್ದಿತ್ತು.
Apart from that, there is several neighbors were there. According to them, Galata was taken there.
ಅದು SC ST ಇದಕ್ಕೆ ಯಾಕೆ ಸಂಬಂಧ ಪಡ್ತದೆ? ಅದು ದಟ್ ಈಸ್ ಅಬೌಟ್ ಇನ್ಸಿಡೆಂಟ್.
That's why my contention is that your lordship, if instance took place and if it is a publicly we are alleged is cast and taken is cast, that definitely any prosecution is good that taken a statement of that any one of the witness, because I intention by asking those questions put forth those questions to the complainant is to show that there is a neighbor, so many houses were there, none of them were
examined by the
witness. Only Manjunath, Rendinadipura, who is a relative of them, who is even not present on that day, according to the complaint.
ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ನೈಬರ್ಸ್ ಯಾರೇ ಸಿಗ್ತಾರೆ ಈಗ? ಸುಪ್ರೀಂ ಕೋರ್ಟೇ ಹೇಳಿದ ನಾನು ದೊಡ್ಡ ಡ್ರಾಬ್ಯಾಕ್ ಏನು ಗೊತ್ತೇ, ನಮ್ಮಲ್ಲಿ ಏನು ರಿಸರ್ಚ್ ವರ್ಕ್ ಏನು ಎಫರ್ಟ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮಾಡ್ಬೇಕೋ ಮಾಡಲ್ಲ. ಕೇಸ್ ಗೆದ್ರೇನು ಸೋತ್ರೇನು ಒಂದು ಡಿಸ್ಪೋಸ್ ಆಯ್ತು ಅನ್ನಷ್ಟು ಬಹಳ ಸರಳವಾಗಿ ಸುಲಲಿತವಾಗಿ ಅವ್ರು ಹೋಗ್ತಾರೆ. ಪ್ರಾಬ್ಲಮ್ ಇರೋದು ಅದು. ನಮಗೆ ಯಾಕೆ ಬರ್ಡೇನ್ ಜಾಸ್ತಿ ಆಗ್ತದೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಪ್ರಾಸಿಕ್ಯೂಷನ್ ತಗೊಳ್ಳಷ್ಟು ಜವಾಬ್ದಾರಿ ತಗೊಳ್ಳಲ್ಲ, ತಗೊಳ್ಳಷ್ಟು ಮುತುವರ್ಜಿ ತಗೊಳ್ಳಲ್ಲ. ಅವ್ರ ಎದುರೇ ಹೇಳ್ತಿದ್ದೇನೆ ನಾನು, ಬೇಕಾದಷ್ಟು ಜಜ್ಮೆಂಟ್ ಇದೆ, ಜಮಾನ ಪೂರ್ತಿ ಬದಲಾಗಿದೆ, ಕಣ್ಣೆದ್ರೆ ಅಪರಾಧ ನಡೆದ್ರು ಕೂಡ ವಿಟ್ನೆಸ್ ಮುಂದೆ ಬರಲ್ಲ, ಹೇಳಲ್ಲ. ಏನಿಲ್ಲ, ಅವ್ರು ದೇರ್ ಲೀಸ್ಟ್ ಬಾದರ್. ಅಕ್ವಿಟ್ ಆದ್ರೆ ಏನು, ಕನ್ವಿಕ್ಷನ್ ಆದ್ರೆ ಅದು ಅಪೀಲ್ ಅಗೇನ್ಸ್ಟ್ ಅಕ್ವಿಟಲ್ ಅಂತ ಬಂದ್ರೆ ಅವರಿಗೆ ಕನ್ವಿಕ್ಷನ್ ಆಗ್ಲೇಬೇಕಂತಿಲ್ಲ. ಕನ್ವಿಕ್ಷನ್ ಆದ್ರೆ ಬೇಕಾದ್ರೆ ಪೇಪರ್ ಅಲ್ಲಿ ಫೋಟೋ ಹಾಕಿಸ್ಕೊಳ್ಬಹುದು. ಬಿಡುಗಡೆ ಆದಾಗ ಅದರಲ್ಲಿ ಶಿಕ್ಷೆ ಆಯ್ತು, ಹೈಕೋರ್ಟ್ ಇಂದ ಶಿಕ್ಷೆ ಆಯ್ತು. ಇಂತಹ ಗನಂದಾರಿ ಸರ್ಕಾರಿ ಅಭಿಯೋಜಕರು ಸರ್ಕಾರದ ಪರವಾಗಿ ವಾದ ಮಂಡಿಸಿದರು. ಡಿಸ್ಮಿಸ್ ಆದ್ರೆ ಏನು ಅವರಿಗೆ, ಅಯ್ಯ ಸ್ವಾಮಿ ಇಟ್ ಇಸ್ ಆಲ್ರೆಡಿ ಅಕ್ವಿಟಲ್ ಜಜ್ಮೆಂಟ್, ಮುಗೀತು. ಕೇಳೋರು ಯಾರಿದ್ದಾರೆ? ಬೇಸಿಕಲಿ ಅದನ್ನ ಕೇಳೋರು ಯಾರು? ನಾವು ಜಜ್ಮೆಂಟ್ ಅಲ್ಲೇ ಬರೀತೇವೆ ಅಂತ ಮಾಡಿ ಅದನ್ನೇನು ಹೋಮ್ ಮಿನಿಸ್ಟರ್ ಕೂತು ನೋಡ್ತಾರಿಯೇ? ನಾವು ಅಪ್ರೂವ್ ಮಾಡಿರೋ ಲಿಸ್ಟು ಅವ್ರು ಹೆಂಗ್ ಕೇಸ್ ನಡೆಸಿದಾರೆ ಏನು ಅಂತ ಯಾರು ನೋಡ್ತಾರೆ? ಯಾರು ನೋಡಲ್ಲ. ನಮ್ಮ ಸಮಾಧಾನಕ್ಕೆ ನಾನ್ ಬರೀಬೇಕು, ಒಲ್ಲದ ಮನಸ್ಸಿಂದ ಸಾಹೇಬರು ಹೂ ಅನ್ಬೇಕು ಅಷ್ಟೇ. ಕೊಡ್ತಾನೆ ಇದೆ. ನಮ್ಮಲ್ಲಿ ಕಾನೂನುಗಳು ನಿಯಮಗಳು ಅಂತ ಒಂದಿರ್ತದೆ. ಸೊಸೈಟಿಲಿ ವ್ಯವಸ್ಥೆ ನಡ್ಕೊಂಡು ಹೋಗೋದು ಬೇರೆದೇ ರೀತಿಯಲ್ಲಿ ನಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದೆ. ನೀವು ಇಲ್ಲಿ ನೈಬರ್ಸ್ ಇದ್ರು ನೈಬರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋದನ್ನ ಹೈಲೈಟ್ ಮಾಡ್ತಿದ್ದೀರಿ. ಇದರಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ನೈಬರ್ಸ್ ಇದ್ದಾರೆ ಅನ್ನೋದನ್ನ ಅವ್ರ ಹೆಸರುಗಳನ್ನು ಹೇಳಿ, ಚಿಕ್ಕಣ್ಣ ಎಲ್ಲಿದ್ದಾರೆ, ರಂಗಸ್ವಾಮಿ ಎಲ್ಲಿದ್ದಾರೆ, ಎಲ್ಲದನ್ನು PW1 ಹೇಳಿದ್ದಾರೆ. ಅದನ್ನು ಅವರು ಗಮನಿಸಿದ್ದಾರೆ. ಎಸ್
Prosecution is not even reduced the order of the evidence.
ಅಲ್ಲ, ಫಾರ್ ಬೋತ್ ದ ಚಾರ್ಜಸ್ ಅಂದ್ರೆ ಯಾವುದು? SC/ST ಆಕ್ಟ್?
Both are this argument. The higher court is also told that there is no order of the material.
ನೀವು ಒಂದು ಚಾರ್ಜ್ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳಿ ಬೋತ್ ದ ಚಾರ್ಜಸ್ SC/ST ಅಂತ ಹೇಳಿ ಕ್ಲೋಸ್ ಮಾಡಿ ಬಿಡ್ತೀರಿ.
Jury is concerned. 323, 324. My first.
ಅದನ್ನ SC/ST ಇನ್ನೊಂದನ್ನ ನೀವು ಆಮೇಲೆ ತಗೊಳ್ಬೇಕು. IPC ಅಫೆನ್ಸ್ ಬಂದ್ರ ಮೇಲೆ ಮತ್ತೆ SC/ST ಅನದರ್ ಅಫೆನ್ಸ್ 325ಗೆ ಆಮೇಲೆ ಹೋಗ್ಬೇಕು. ಈಗ ನೀವು ಏನ್ ಇಷ್ಟೊತ್ತು ಹೇಳಿದ್ರಿ ಅದು 310ಗೆ ಮಾತ್ರ. ನೀವು 310ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ 325 ಅದರಲ್ಲೇ ಸೇರಿಸಲಿಕ್ಕೆ ಬರಲ್ಲ. 325 ಇಂಗ್ರೀಡಿಯೆಂಟ್ ಬೇರೆ ಇದೆ. ನೀವು ಅದ್ರದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೋಗ್ಬೇಕಾದ್ರೆ ನೀವು IPC ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು ಫಸ್ಟ್.
First, with respect to that, your Worship, the allegation is that with respect to that, the instance took place on 5/1/2012. The allegation. And complaint is larger 13/12/2012. There is no explanation with respect, proper explanation with respect to delay of the complaint.
ಹೇಳಿದ್ದಾಳಲ್ರಿ ಅವಳು, ಎವಿಡೆನ್ಸ್ ಅಲ್ಲೂ ಹೇಳಿದಾಳೆ, ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೂ ಹೇಳಿದಾಳೆ, ಗಂಡನ್ ನೋಡ್ಕೊಳ್ಲಿಕ್ಕೆ ಯಾರು ಇರ್ಲಿಲ್ಲ, ನಾನೇ ನೋಡ್ಕೊಳ್ಬೇಕಿತ್ತು ಅಂತ. ಅದಕ್ಕಿಂತ ದೊಡ್ಡದು ಇನ್ನೇನ್ರಿ ಬೇಕು ನಿಮಗೆ ಎಕ್ಸ್ಪ್ಲನೇಷನ್?
ಅದಕ್ಕೆ ನಾ justification ಕೊಡ್ತಾ ಹೋಗ್ತಾನೆ. First thing is that with respect to that, the allegation is concerned that there is a lot of discrepancy with respect to the incidents. The PW1 in his evidence ಹೇಳ್ತಾರೆ, ನನ್ನ ಗಂಡನವರನ್ನು ಮನೆಯಿಂದ ಎಳೆದುಕೊಂಡು ಬಂದು 1 and 2 ಅಸಾಲ್ಟೇಟ್ ಅಂತ ಹೇಳ್ತಾರೆ. 5 ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಆದರೆ ಇಮ್ಮೈನವರು in their cross examination he specifically denied that instance. ಅವರು ತಮ್ಮ ಲಾಸ್ಟ್ ಕ್ವಶನ್ ಪೊಲೀಸರ ಮುಂದೆ 1 ಮತ್ತು 2ನೇ ಆರೋಪಿತರು ನನ್ನನ್ನು ಮನೆಯಿಂದ ಹೊರಗೆ ಎಳೆದುಕೊಂಡು ಬಂದರು ಎಂದು ಹೇಳಿದ. He is not in cross examination.
ಇನ್ನೊಮ್ಮೆ ರಿಪೀಟ್ ಮಾಡಿ ಪಾಯಿಂಟ್.
ನಾನು ಪೊಲೀಸರ ಮುಂದೆ 1 ಮತ್ತು 2ನೇ
ಅಲ್ಲ, ಅದು ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ನಿಮಗೆ ಹೇಳ್ತಿರೋದು. ದಿ ಎಂಟೈರ್ ಪಾಯಿಂಟ್ ವಾಟ್ ಯು ಆರ್ ನೌ ಕ್ಯಾನ್ವಾಸಿಂಗ್ ಅಬೌಟ್ ದಿ ಇನ್ಸಿಡೆಂಟ್.
with respect to the instance itself.
ಹಾ,
First, Sharadamma in his evidence she stated that ನನ್ನ ಗಂಡನನ್ನು ಮನೆಯಿಂದ ಹೊರಗೆ ಎಳೆದು ತಂದರು.
ತೋರಿಸಿ ಇದನ್ನ. Para 1 last sentence. ಮನೆಯಿಂದ ಎಳೆದುಕೊಂಡು ಬಂದರು.
5 ಒಂದು ಮನೆಯಿಂದ ಎಳೆದು
Yes.
ನಂತರ ದಾಸ 2 ಅಲ್ಲೇ ಮಾಡಿ ರಕ್ತ ಗಾಯವಾಗಿತ್ತು. ಆಂಬುಲೆನ್ಸ್ನಲ್ಲಿ ಬಿಫೋರ್ ದಟ್ ಅವನ ಇದರಲ್ಲಿ ಬರೀ ತಿಮ್ಮಯ್ಯನವರಿಗೆ ಮಾತ್ರ ಎಳೆದುಕೊಂಡು ಬಂದು ಗಲಾಟೆ ಮಾಡಿಬಿಡೋದು ಅಂತ. ತಿಮ್ಮಯ್ಯನವರು ಅದನ್ನ ಇಂಪ್ರೂವ್ ಮಾಡಿ in their crash examination. Second paragraph,
Second para of Timaya's cross examination. 1 minute.
ನಾನು ಕಾಂಪೌಂಡ್ ಅನ್ನು ಸರ್ಕಾರಿ ರಸ್ತೆ ಮುಖ್ಯವಾಗಿ ಮಾಡಿ ಕಟ್ಟಲು ಚಿತಾವಣೆಯಿಂದಲೇ ಫಿರ್ಯಾದಿ ನನಗೆ ಪಡಿಸಿದ್ದರಿಂದ ನಾನು ಕಾಂಪೌಂಡ್ ಗೋಡೆ ಕಟ್ಟುತ್ತೇನೆ ಎಂದು ಹೇಳಿಕೊಂಡು ಗಲಾಟೆ ನಡೆಯಿತು ಎನ್ನುವ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮಗ ಪಕ್ಕದ ಮನೆಯವರು ಯಾರು ಬಂದಿರಬಹುದು. ಸುಮಾರು 15 ನಿಮಿಷ ಕಾಲ ನಡೆಯಿತು. ಘಟನೆ ನಡೆಯುವಾಗ ನನ್ನ ಮಗ ಸೊಸೆ ಹಿಡಿಸಲು ಬಂದಿದ್ದರು. ಅವರಿಗೂ ಸಹ ಹಲ್ಲೆ ಮಾಡಿರುತ್ತಾರೆ. Without the prosecution is that our ಮಗ ಮತ್ತು ಸೊಸೆಗೂ ಗಲಾಟಿನಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ರು. ಸಹ ಇಂಜುರಿ ಆಯಿತು. they are examining not theory. ನನ್ನ ಪತ್ನಿ ಮಗ ಸೊಸೆ ನೆಕ್ಸ್ಟ್ ಸೆಂಟರ್ ಘಟನೆಯ ವಿಚಾರಣೆಯನ್ನು ಮಾಡಿಕೊಳ್ಳುವುದರಿಂದ ನನಗೆ ಚಿಕ್ಕನಾಯಕನಲ್ಲಿ ಆಸ್ಪತ್ರೆಗೆ ಹೋದಾಗ ನನಗೆ ಪ್ರಶ್ನೆ ಬಂದಿದ್ದು. ಚಿಕ್ಕನಾಯಕನ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ 15 ನಿಮಿಷ ಕಾಲ ವಿಚಾರಣೆ ಮಾಡಿ ಚಿಕ್ಕನಾಯಕನಲ್ಲಿ ಪೊಲೀಸರು ಬಂದು ನನ್ನನ್ನು ಮತ್ತು ಪ್ರಾಸಂಗವನ್ನು ಘಟನೆಯ ಬಗ್ಗೆ ವಿಚಾರಣೆ ಮಾಡಿ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಂಡು ಹುಳಿಯಾರು ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ದಿನಾಂಕ 6/12/2012 ಘಟನೆ ಬಗ್ಗೆ ವಿವರವಾದ ಹೇಳಿಕೆಯನ್ನು ಫಿರ್ಯಾದಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ ಎಂದರಿಸಿದರು. ದಿನಾಂಕ 6/12/2012 there is no awareness or with respect to that there is no according to the complainant saha Sharadamur saha in cross examination he stated that ನಾನು ದಿನಾಂಕ 6/12/2012 ಫಿರ್ಯಾದಿ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ದಿನಾಂಕ 6/12/2012 ಫಿರ್ಯಾದಿ ಕೊಡಲು ಹೋಗಿರುತ್ತೇನೆ. ನನ್ನ ಮಗ ಅವರು ಆಸ್ಪತ್ರೆಗೆ ಸೇರಿದ ಮರುದಿವಸ ಬಂದು ವಿಚಾರಣೆ ಮಾಡಿಕೊಂಡು ನಾನು according to the complaint the 6th itself they are filed the complaint.
Again, now you are on the point of the delay in lodging the complaint or what?
The entire instance is suspicious with respect to that delay. First thing is that suspicious there is a divergent statements inconsistent statements among the complainant and victim. Complainant in one statement she says that ನನ್ನ ಗಂಡ ನನ್ನ ಮನೆಯಿಂದ ಹೊರಗೆ ಎಳ್ಕೊಂಡು ಬಂದಿರುತ್ತಾರೆ. PW2 in his statement is state that ಹೌದು ನಾನು ಆತರ ಏನು ಹೇಳಿಕೆ ಕೊಟ್ಟಿಲ್ಲ ಪೊಲೀಸ್
PW2 ನನ್ನನ್ನು ಹೊರಗಡೆ ಹೇಳ್ಕೊಂಡು ಬಂದ್ರು ಅಂತ ಹೇಳಿದ್ದಾರೆ ಚೀಫ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಆ ಸ್ಟೇಟ್ಮೆಂಟ್ ನ ಪೊಲೀಸರ ಎದುರು ನೀವು ಹೇಳಿಲ್ಲ ಅಂತ ನೀವು ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ದೀರಿ.
ಹೌದು, ಅದನ್ನು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಹೌದು, ನಾವೇನು ಹೇಳಿಲ್ಲ.
ಅಂದ್ರೆ ಹೊರಗಡೆ ಎಳ್ಕೊಂಡ್ ಬಂದ್ರು ಸುಳ್ಳು ಅಂತಲ್ಲ, ಎಳ್ಕೊಂಡ್ ಬಂದ್ರು ನಾನು ಅದನ್ನ ಪೊಲೀಸ್ನವ್ರ ಎದುರು ಹೇಳಲಿಲ್ಲ.
ಇನ್ಫರೆನ್ಸ್ ದಾಟಿವಲ್ಲ.
ಹೇಳಿ.
ಸೆಕೆಂಡ್ ಇನ್ಕನ್ಸಿಸ್ಟೆನ್ಸಿ ಇದರಲ್ಲಿ ನನ್ನ ಶಾರದಮ್ಮ ನನ್ನ ಯಜಮಾನನ ಮಾತ್ರ ಹೇಳ್ಕೊಂಡ್ ಬಂದ್ರು, ಹೊಡೆದ್ರು ಅಂತಾರೆ. ತಿಮ್ಮಯ್ಯನವರು ಅವರು ಇದರಲ್ಲಿ ನನ್ನ ಮಗಳು ಸಹ ಇದ್ರು, ಅವರು ಅವ್ರಿಗೂ ಹೊಡೆದ್ರು ಅಂತಾರೆ. ದಟ್ ಈಸ್
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೇಳಿದ್ರು.
ಆಗ್ಲಿ, ಮಗ ಅವರಿಗೂ ಹೊಡೆದ್ರು ಅಂತಾದ್ರೂ ಕೂಡ ಹೊಡಿಸ್ಕೊಂಡವನ್ ತಿಮ್ಮಯ್ಯ ನನಗೂ ಹೊಡೆದಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದಾನೆ ತಾನೆ. ಈಗ PW1 ನನ್ ಗಂಡ ತಿಮ್ಮಯ್ಯನಿಗೆ ಹೊಡೆದ್ರು ಅಂತ ಹೇಳಿ, ತಿಮ್ಮಯ್ಯ ನನಗ್ ಹೊಡಿಲಿಲ್ಲ ನನ್ನ ಮಕ್ಕಳಿಗೆ ಹೊಡೆದ್ರು, ಮಗ ಸೊಸೆ ಹೊಡೆದ್ರು ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಡಿಸ್ಕ್ರಿಪೆನ್ಸಿ.
Argument before this court is the entire instance is they are frequently changing by stage. The entire instance is not neither they are trying to create according to their own knowledge. ಶಾರದಮ್ಮ ತನಗೆ ಹೇಗಬೇಕು ಹಾಗೆ ಹಾಕಿ ಕ್ರಿಯೇಟ್. ನೆಕ್ಸ್ಟ್ ತಿಮ್ಮಯ್ಯನವರು ಅದನ್ನ ಎಕೋ ಮಾಡ್ಕೊಂಡು ತಮಗೆ ಹೇಗೆ ಬೇಕೋ ಹಾಗೆ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾರೆ. Second thing is that with respect to complaint against complaint ಹೋಗೋಕ್ಕಿಂತ ಮುಂಚೆ with respect to delay ಒಂದು ಫೈಂಡಿಂಗ್ಸ್ ಆಫ್ ದ ರಿಪೋರ್ಟ್ ಆನ್ ವಾಟ್ ಬೇಸಿಸ್
ನೀವು ಜಂಬಲ್ ಮಾಡಬೇಡಿ. 1 by 1 ತಗೊಳ್ತಾ ಹೋಗಿ. ಅಲ್ಲಿಗೆ ಹೋದೆ, ಇನ್ನೊಂದು ಯಾವ್ದಕ್ಕೆ ಹೋದೆ, ಮತ್ತೆ ಹಿಂದಕ್ಕೆ ವಾಪಸ್ ಬಂದೆ.
2012 ಕಂಪ್ಲೇಂಟ್ ಹೋಗೋಕ್ಕಿಂತ ಮುಂಚೆ ಡಿಲೇ ಬಗ್ಗೆ ಹೇಳೋದು.
Yes.
ಪಾರ್ಟಿ ಸವಾಲ್ ಇದೆ.
Yes.
ನಾನು ದಿನಾಂಕ 6/12/2012 ಫಿರ್ಯಾದಿಯನ್ನು ಕೊಟ್ಟಿರುತ್ತೇನೆ. ದಿನಾಂಕ 6/12/2012 ಮಧ್ಯಾಹ್ನ ಫಿರ್ಯಾದಿ ಕೊಡಲಿಕ್ಕೆ ನನ್ನ ಮಗನು ಶಾಸ 2ರವರು ಆಸ್ಪತ್ರೆ ಸೇರಿದ ಮರುದಿವಸ ಒಂದು ವಿಚಾರ ಮಾಡಿದರು ಎಂದರೆ ಸರಿಯಿಲ್ಲ. ನಾನು ನನ್ನ ಫಿರ್ಯಾದಿಯಲ್ಲಿ ಶಾಸ 2ರವರಿಗೆ ಹೀಗೆ ಗಾಯ ಆಗಲು ಎಂದು ಬರೆದುಕೊಟ್ಟಿರುತ್ತೇನೆ. ಶಾಸ 2ರವರು ಸಹ ಫಿರ್ಯಾದಿಗೆ ಕೊಡುವಾಗ ಹಾಜರಿದ್ದರು. ಸದರಿ ದೂರನ್ನು ಬರೆದುಕೊಟ್ಟಿರುತ್ತೇನೆ. ಶಾಸ 3ರವರು ಸಹ ಫಿರ್ಯಾದಿ ಕೊಡುವಾಗ ಹಾಜರಿದ್ದರು. ಸದರಿ ದೂರನ್ನು ಮಂಜುನಾಥ್ ರವರೇ ನನಗೆ ಬರೆದುಕೊಟ್ಟಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಪೊಲೀಸರು ನಾನು ಹೇಳಿದಂತೆ ಫಿರ್ಯಾದಿಯನ್ನು ಬರೆದುಕೊಂಡರು ಎಂದರೆ ಸರಿ. ಮಂಜುನಾಥ ಘಟನೆ ನಡೆದ ಊರಿಗೆ ಬಂದಿರುತ್ತಾನೆ. ಸದರಿ ಮಂಜುನಾಥನು ಶಾಸ 3ರವರ ಕಲೆ. ನೆಕ್ಸ್ಟ್, ನಮ್ಮ ಊರಿನ ಗೋಪಾಲ್ ಕೂಡ 20 ಕಿಲೋಮೀಟರ್ ದೂರವಿರುತ್ತದೆ. ಅವರು ಓವಿ ಜನಾಂಗಕ್ಕೆ ನಾಯಕನಾಗಿರುತ್ತಾರೆ. ಶಾಸ 4ರವರು ನನ್ನ ಗಂಡನು 8 ದಿವಸ ಶಾಸ 3ರವರು ಹಾಗೂ ನನ್ನ ಮಗ ಅನಂತಯ್ಯ ಸಹ ಇದ್ದರು ಎನ್ನುವುದು ಸರಿ.
ದಿನಾಂಕ 13/12/2012 ಶಾಸನ 4 ಠಾಣೆಗೆ ನಿಕ್ಷೇಪ 1 ಶಾಲಾ ನಿಕ್ಷೇಪ 2 ಬೇರೆಯವರ ಕಡೆ ಹೇಳಿ ಬರೆಸಿರುತ್ತಾರೆ. ನಿಕ್ಷೇಪ 1ರಲ್ಲಿ ಏನು ಬರೆದಿದ್ದಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿರುವುದಿಲ್ಲ. ನಿಕ್ಷೇಪ 2ರಲ್ಲಿ ಏನು ಸಹಿಯನ್ನು ಹಾಕಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿ. ನಿಕ್ಷೇಪ 2 ಬೇರೆ ಯಾರು ಸಹಿ ಹಾಕಿರುತ್ತಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿರುವುದಿಲ್ಲ ಎಂಬ ಒಂದು ಹೇಳಲಾಗುತ್ತದೆ. I intentionally tell you that on 6th itself we are lodged the complaint according to this instance. We went to the police station, but the said fact is not put forth by the prosecution. The entire prosecution case is that 13th ಗಂಡನ ಆಸ್ಪತ್ರೆಗೆ ಸೇರಿಸಿದ್ದೆ, ನಮಗೆ ಬರೋದಕ್ಕಾಗಲಿಲ್ಲ, ಆದ್ರಿಂದ 13th ಬಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತೀವಿ. ಬಟ್ ಕಂಪ್ಲೇಂಟ್ ಇನ್ ದೇರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ 6ನೇ ತಾರೀಕು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಹೋಗಿದ್ವಿ, ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತೀವಿ. ಬಟ್ ನಥಿಂಗ್ ಈಸ್ ದೇರ್ ಅಬೌಟ್ ದಟ್ statement about that or any document with respect to that 6ನೇ ತಾರೀಕು, because it shows that 6th they have filed a complaint. I suggested that 6th, but the police for the instance is not taken place. For that reason 6th is not registered. That is the only on 13th ಊರಿನ ದುರವಗಳು ಓವಿ ಜನಾಂಗದ ನಾಯಕರವರು on their instance complaint has been registered against this accused person. There is no explanation with respect to that. What the explanation they are given is that after exit, because very next day their son, everyone is present in the hospital. So for that reasons, ನನ್ನ ಗಂಡನ ನೋಡ್ಕೊಳ್ಳೋದು ಯಾರು ಇರಲಿಲ್ಲ, ಅದಕ್ಕೆ 13ವರೆಗೂ there is a delay ಅನ್ನುವ statement. In cross examinations, what they are discussing is admitted statements. And the explanation given for the delay in filing the complaint is not believable. Considering this fact, the trial court rightly holds that
Yes.
because in the evidence of the testimony also clearly stated that 7ನೇ ತಾರೀಕು ನನ್ನ ಮಗ ಮತ್ತು ಸೊಸೆ were present in the hospitals from that day. With respect to the next, my seizing of the Casa 3 ಮತ್ತು 4 seizing. Both the master witnesses were not supported the case of the prosecution. The theory of the prosecution is that on 15th measure was conducted, 14th measure was conducted. On that day, both the used that in bidre banguಗಳನ್ನು ಯೂಸ್ ಮಾಡ್ತಾರೆ. ಅದೇ ಜಾಗದಲ್ಲಿ ಇದ್ದು we are seized in presence of the Mahajan after lapse of almost
8 days.
8 days. The five.
Yes.
Yes.
With respect to the injuries are concerned,
Yes.
in that effect, the accused, what we are cross-examining that and we are given a theory of that. So, you got certain injury. Where page 20 is in cross-examination of the Timaya, we are post that.
Yes.
Third paragraph. ನಾನು ಕೆಳಗೆ ಬಿದ್ದು ಗಾಯಪಡಿಸಿಕೊಂಡಿದ್ದೇನೆ ಎಂದು ಹೇಳಿಕೊಟ್ಟಿದ್ದೇನೆ ಅಂದರೆ ಲಾಸ್ಟ್
Yes.
we are post that. In that you are like in support of that the prosecution in support injury examine the field of your court the not that in the cross examination doctor clearly said that your lordship he is the not the doctor who examined the victim the Timaya is the doctor at Chickney. The wound certificate all other issued by the Tumkur fellowship in cross examination ಮೇಲೆ ಹೇಳಿದ ಎರಡು ಗಾಯಗಳು ಒಬ್ಬ ಮನುಷ್ಯನಿಗೆ ಗಟ್ಟಿಯಾಗಿ PW4
Yes.
examination chief stated that I verified the wound certificate issued by the Tumkur hospital as inpatient according based on the wound certificate I giving it to deposing the evidence in cross examination ಮೇಲೆ ಹೇಳಿದ ಎರಡು ಗಾಯಗಳು ಒಬ್ಬ ಮನುಷ್ಯ ಗಟ್ಟಿಯಾಗಿ ನೆಲದ ಮೇಲೆ ಬಿದ್ದರೆ ಆಗಬಹುದು ಒಂದು ಮತ್ತು ಎರಡರ ಗಾಯಗಳು ಕಾಲಿನ ಯಾವ ಭಾಗದಲ್ಲಿ ಆಗಿದೆ ಅಂತ ಗಾಯದ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಸರಿ ಪೊಲೀಸ್ ಠಾಣೆಯು ನಮ್ಮ ಆಸ್ಪತ್ರೆ ಎದುರುಗಡೆ ಇರುತ್ತದೆ ಒಡನಾಟ ಇತಿಹಾಸದೊಂದಿಗೆ ಹಾಜರಾದ ವ್ಯಕ್ತಿಯ ಬಗ್ಗೆ ಪೊಲೀಸ್ ಠಾಣೆ ಮಾಹಿತಿ ಇರುತ್ತದೆ ತನಿಖಾಧಿಕಾರಿಗಳ ಆಸ್ಪತ್ರೆ ಬೇರೆ ಕುಳಿತಿರಬಹುದು ತನಿಖಾಧಿಕಾರಿಗಳು ಒಂದು ಮತ್ತು ಎರಡನ್ನು ಮುಂದೆ ಹಾಜರುಪಡಿಸಿ ಗಾಯಪಡಲಿಲ್ಲ ತನಿಖಾಧಿಕಾರಿಗಳು ತುಮಕೂರು ಜಿಲ್ಲಾ ಆಸ್ಪತ್ರೆ ವೈದ್ಯಾಧಿಕಾರಿಗಳ ವರದಿಯ ಗಾಯದ ಪ್ರಮಾಣದ ಜೊತೆ ಕೊಟ್ಟಿರುತ್ತೇನೆ ತುಮಕೂರು ಜಿಲ್ಲಾ ಆಸ್ಪತ್ರೆಯಿಂದ ವೈದ್ಯಾಧಿಕಾರಿಗಳ ವರದಿ ಪಡೆದುಕೊಳ್ಳದೆ ಪೊಲೀಸರ ವಿನಂತಿಯ ಮೇರೆಗೆ ನನ್ನ ಅಭಿಪ್ರಾಯ ಕೊಟ್ಟಿದ್ದೇನೆ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ ಮತ್ತೆ 1-2 ಮಾಡಿದ ಹಲ್ಲೆ ಈ 4ರಲ್ಲಿ ತೋರಿಸಿದ ಗಾಯಗಳು ಆಗುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ either in the wound certificate it shows that which place it is and the specific opinion of the doctor ಕೆಳಗೆ ಬಿದ್ದು this type of injury occurs and the most important thing is that your lordship the entire prosecution nowhere it is stated he admitted on 5th of 6th to the Tumkur hospital. But when he is discharged or discharge summary, nowhere either presence or nowhere stated. Our inpatient ಆಗಿದ್ದಾದ್ರೆ ಅವರು ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದ್ದು ಸ್ಪೆಸಿಫಿಕಲಿ ಇಂದನಾಗಿತ್ತು ಇಲ್ಲ ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿರುವ ಬಗ್ಗೆ ಎಲ್ಲೂ ಹೇಳುವುದಿಲ್ಲ when he was discharged
The injured was not admitted to Tumkuru hospital ಅನ್ನೋದನ್ನ ನೀವು ಎಲ್ಲಿಯಾದ್ರೂ PW4 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ? ಮತ್ತೆ ನೀವು ಹೇಳ್ಬೇಕಾಗಿರೋದನ್ನ ಹೇಳದಂಗೆ ನೀವು ಸೆವರಲ್ ಥಿಂಗ್ಸ್ ಇಮ್ಯಾಜಿನ್ ಮಾಡ್ಕೊಂಡ್ರಿ. You have not denied that the injured was referred to Tumkuru and he was admitted there as at Tumkuru.
Prosecution case is that first initially he was taken to Chiknacknalli hospital.
ಹಾ.
They were referred.
ಹೌದು.
But ಅದನ್ನ ಕೇಳಿದ್ವಿ, ಅವರು ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ಆಸ್ಪತ್ರೆಗೆ ತಂದಿರುವಂತಹ ನಮ್ಮ ಹತ್ರ ಯಾವುದು ಇದಿಲ್ಲ, ನಾವು ತುಮಕೂರು ಹಾಸ್ಪಿಟಲ್ಗೆ ರೆಫರ್ ಮಾಡಿದೀವಿ ಅನ್ನೋದಕ್ಕೂ ನನ್ನ ಹತ್ರ ಏನಿಲ್ಲ ಅಂತ ಈ ಡಾಕ್ಟರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ಅಂದ್ರೆ ನಿಮ್ಮ ಪ್ರಕಾರ ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿಗೂ ಇವ್ರು ಹೋಗ್ಲಿಲ್ಲ ಅಂತನಾ?
ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ
ಹೋಗ್ಲಿಲ್ಲ ಅಂತ
ಹೋಗಿಲ್ಲ.
ಓದಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ವಿಟ್ನೆಸ್
ಮೇಲೆ ಹೇಳಿದ ಎರಡು ಒಂದು ಎರಡನೇ ಗಾಯ ಯಾವ ಭಾಗದಲ್ಲಿ ಅಂತ ಪ್ರಮಾಣ ಪತ್ರ ಸರಿ. ಪೊಲೀಸ್ ಠಾಣೆಯು ನಮ್ಮ ಆಸ್ಪತ್ರೆ ಎದುರುಗಡೆ ಇರುತ್ತದೆ. ಹೊಡೆದಾಟದ ಇತಿಹಾಸ ಹಾಜರಾದ ವ್ಯಕ್ತಿಯ ಬಗ್ಗೆ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಮಾಹಿತಿ ರವಾನಿಸುತ್ತದೆ. ತನಿಖಾಧಿಕಾರಿಗಳು ಆಸ್ಪತ್ರೆಗೆ ಭೇಟಿ ಕೊಡುತ್ತಾರೆ. ತನಿಖಾಧಿಕಾರಿ ಗಾಯದವರು ಹಾಗೂ ಹೆಂಡತಿಯ ವಿಚಾರಣೆ ಮಾಡಿಕೊಂಡು ಹೋಗಿದ್ದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಹುದ್ದೆ ಮಾಲು 1, 2 ನನ್ನ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿ ಅಭಿಪ್ರಾಯ ಪಡೆದಿರುವುದಿಲ್ಲ. ತನಿಖಾಧಿಕಾರಿಗಳು ತುಮಕೂರು ಜಿಲ್ಲಾ ಆಸ್ಪತ್ರೆ ವೈದ್ಯಾಧಿಕ ವರದಿ ಗಾಯದ ಪ್ರಮಾಣ ಪತ್ರ ಜೊತೆ ಕೊಟ್ಟಿರುತ್ತೀವಿ. ತುಮಕೂರು ಜಿಲ್ಲಾ ಆಸ್ಪತ್ರೆಯಿಂದ ವೈದ್ಯಾಧಿಕ ವರದಿ ಪಡೆದ ಪೊಲೀಸ್ ಇಲಾಖೆ ಮೇರೆಗೆ
ನಿಮ್ ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ಆಸ್ಪತ್ರೆಗೆ ಬಂದೇ ಇಲ್ಲ, ನೀವು ಎಕ್ಸಾಮಿನೇ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಿ? ಅವ್ನು ನಿಮ್ಮ ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ಬರ್ಲಿಲ್ಲ, ನೀವು ಅವನು ನೋಡ್ಲಿಲ್ಲ, ಅವ್ನು ತುಮಕೂರಿಗೆ ಹೋಗ್ಲಿಲ್ಲ, ಅದೆಲ್ಲದನ್ನು ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಿ ನೀವು? ಅದು ಯಾವುದು ಹೇಳಲಿಲ್ಲ, ಅದೆಲ್ಲದನ್ನು ಇಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀರಿ.
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಇದು ಬರ್ಬೇಕಾಗಿತ್ತು. ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅದನ್ನ ಇದನ್ನ ತಂದೆ ಇಲ್ಲ ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ತೋರಿಸಿದ್ರು ಅನ್ನುವಂತಹ ಒಂದೇ ಒಂದಂತಹ ವಿಟ್ನೆಸ್ ಆಗಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಆಗಲಿ ಎಲ್ಲೂ ಬರಲೇ.
ಡಾಕ್ಟ್ರೇ ಹೇಳಿದ್ದಾರಲ್ರಿ, ಡಾಕ್ಟರ್ ಬಿಟ್ಟು ಇನ್ಯಾರು ಹೇಳ್ಬೇಕು?
ಪರೀಕ್ಷೆಗಾಗಿ ಹಾಜರುಪಡಿಸಿದ್ದರು.
ನನ್ನ ಮುಂದೆ ಪರೀಕ್ಷೆಗಾಗಿ ಹಾಜರುಪಡಿಸಿದರು. ಏನ್ ಅರ್ಥ ಅದು?
ಬಟ್ ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಇದನ್ನು ಕೊಡ್ತಾರೆ. ನೈದರ್ ಈಸ್ ರೆಕಾರ್ಡೆಡ್ ದ ಸ್ಟೇಟ್ಮೆಂಟ್ ದಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
ನೀವು ಏನೋ ಅಂತ ಹೇಳಿ ಅದನ್ನ ಸಬ್ಸ್ಟಾನ್ಶಿಯೇಟ್ ಮಾಡದೆ ಇನ್ನೊಂದು ಜಂಪ್ ಆಗಬೇಡಿ. Don't waste the precious time of the court by making whatever submission that flashes in your mind.
I only submission is that with respect to that he was taken a treatment in Chiknacknalli hospital. Neither the entry or referring the he was referred to the Tumkuru hospital. No such.
ಇದು 4ನೇ ಪಾಯಿಂಟ್. 3 ಪಾಯಿಂಟ್ ಹೇಳಿದ್ರಿ, ಅದು ಹೆಂಗ್ ಸಬ್ಸ್ಟಾನ್ಶಿಯೇಟ್ ಮಾಡ್ತೀರಿ ಅಂದಾಗ ಅದು ನಲ್ಲಿಗೆ ಕೈ ಬಿಟ್ರಿ 4ನೇದಕ್ಕೆ ಹೋಗ್ತಿದ್ದೀರಿ.
My inference is that out of that is not, I am not suggested that.
ಹೌದು, ಮತ್ತೆ ಅದು ಸಜೆಸ್ಟ್ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರ ಮೇಲೆ ಇದು ಪಾಯಿಂಟ್ ಬರಲ್ಲ. ಪ್ರಶ್ನೆನೂ ನೀವೇ ಹೇಳ್ತೀರಿ, ಉತ್ತರನೂ ನೀವೇ ತೋರಿಸ್ತೀರಿ. ವಕೀಲ್ರೆ, ಒಂದು ತಿಳಿರಿ ದಯಮಾಡಿ, ವಿತ್ ಗ್ರೇಟೆಸ್ಟ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದ ಬಾರ್ ಐ ಆಮ್ ಟೆಲ್ಲಿಂಗ್, ಮನ್ಸಿಗೆ ಬಂದಿದ್ದೆಲ್ಲದನ್ನು ನನ್ನ ಸಬ್ಮಿಷನ್ ಏನಂದ್ರೆ ದಿಸ್ ಇಸ್ ಮೈ ವ್ಯೂ, ದಟ್ ಕ್ಯಾನ್ ಬಿ ಟೇಕನ್ ಆಸ್ ಮೈ ಸಬ್ಮಿಷನ್ ಅಲ್ಲ. ಅದು ವಕೀಲರ, ಇಫ್ ಐ ಕ್ಯಾನ್ ಯೂಸ್ ದ ವರ್ಡ್, ಐ ಆಮ್ ನಾಟ್ ಸೇ ದಿ ಕರೆಕ್ಟ್ ಇನ್ ಯೂಸಿಂಗ್ ದಟ್ ವರ್ಡ್, ಅವರ ಬುದ್ಧಿಮತ್ತೆಯನ್ನು ಪ್ರದರ್ಶಿಸುತ್ತದೆ. ವಕೀಲರು ಏನ್ ಹೇಳ್ತಾರೆ ಪ್ರತಿಯೊಂದು ಶಬ್ದವನ್ನು ಕೂಡ ಅವರು ಸಬ್ಸ್ಟಾನ್ಶಿಯೇಟ್ ಮಾಡಬೇಕು, ನೀವೇ ಆಗ್ಲಿ ಅದರ್ ಸೈಡ್ ಆಗ್ಲಿ. ಅದು ಆರ್ಗ್ಯುಮೆಂಟು. ಏನು ಅಂತ ಹೇಳಿ ಸ್ವಾಮಿ ದಟ್ ಇಸ್ ಆಲ್ ಮೈ ಸಬ್ಮಿಷನ್, ಐ ಲೀವ್ ಇಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, your lordship may write anything, that is not argument, that is not argument.
My submission based on this evidence that your lordship, he is given the entire evidence on the basis of the wound certificate issued by the Tumkuru hospital.
His observation plus the Tumkuru hospital report. ಅವ್ರ ಅಬ್ಸರ್ವೇಷನ್ ಈಗ ತಾವೇ ಓದಿದ್ರಿ. His entire evidence is based upon the wound certificate said to have been given by Tumkuru ಅನ್ನೋದನ್ನು ನೀವು ಓದಿದ್ದಕ್ಕೆ ವ್ಯತಿರಿಕ್ತವಾಗಿ ಹೇಳ್ತಾ ಇದ್ದೀರಿ.
With respect to that issue, Not there is a specification. ಚಿಕ್ಕನಾಯಕನಲ್ಲಿ ಅವರು ಯಾವುದೇ ಸರ್ಟಿಫಿಕೇಟ್ ಅಥವಾ ನಾವು ತುಮಕೂರಿಗೆ ರೆಫರ್ ಮಾಡಿದೀವಿ ಅನ್ನುವಂತಹ ಬಿಕಾಸ್ ಗವರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್ ಇದಾಯಿತು ರೆಫರ್ ಮಾಡುವುದಕ್ಕೆ ದಾಖಲಾತಿ ಎರಡನ್ನೂ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಎಲ್ಲೂ ಪ್ರೊಡ್ಯೂಸ್
ನೀವು ಅದನ್ನ ಅಲ್ಲೇ ಕೇಳಿದಿಲ್ಲ.
P4 ನೋಡಿ
ನೋಡಿ ವೂಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ನೋಡಿ
ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ ಎಕ್ಸಿಬಿಟ್ P4 ನೋಡಿ
ತುಮಕೂರು ಡಾಕ್ಟರ್ ಕೊಟ್ಟಿರುವಂತಹ ವೂಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ
ಎಕ್ಸಿಬಿಟ್
P4 ನೋಡ್ರಿ.
it shows the admission as a sexual
ಸೈನ್ ಮಾಡಿದ್ರು ನೋಡಿ ಆರೋಗ್ಯ ವೈದ್ಯಾಧಿಕಾರಿಗಳು ತಾಲೂಕು ಮಟ್ಟದ ಆಸ್ಪತ್ರೆ ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ಮೇಲೆ ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾರ್ಕ್ಸ್ ಅಂತ ಏನಿದೆ ಅದರಲ್ಲಿ ದ ಇಂಜೂರ್ಡ್ ಪರ್ಸನ್ ವಾಸ್ ಫಸ್ಟ್ seen by the undersigned at a general hospital CN Halli on the 5th 5/12/12 and the examination was commenced at general hospital CN Halli at 10:45 p.m. on 5/12/12 when the following injuries were found. Report from higher center district hospital Tumkuru IP so and so, date of admission 6/12/12, date of discharge not mentioned, suggestive of commuted fracture of right proximal 1/3 tibia.
This is the certificate issued based on the
This document is pertaining to the Chikkanayakalli Medical Hospital.
my argument is that on 5th when they come to the Chikkanayakalli hospital, on that day there is no document to show that they refer to the Tumkur hospital. This is the wound certificate issued subsequently based on the report of the
You are submitting, there is no record to show that injured had taken treatment in the Chikkanayakalli hospital. No, the wound certificate itself is shows that he had taken treatment in the Chikkanayakalli hospital.
Yes, we will consider that point that there are no any document of referring the injured to district hospital Tumkuru. Yes, next point.
and there is no part of the material to show that when he was discharged from the Tumkur hospital. And in the evidence of the doctor clearly support the theory of the accused that this injury even occurred
By fall.
So, there is no proper explanation with respect to the delay in filing the complaint. In one occasion, they are stating that 13th we filed the complaint because no one is taking care of that. In cross-examination, they stated that 6th itself, we went to the police station and gave the statement. Next is that there is a discrepancy with respect to the incidents is concerned. And the prosecution will fail to prove the involvement of the, what the weapons are interpreted, because the major witnesses are not supported. There. In this regard, entire thing is that the accused persons were tried for the alleged instance because of their previous some galata was taken place. Overall, summarize of this, the prosecution failed to the instance of the entire case.
Yes.
And also, the prosecution is not stated anything about that. What happens to the complaint which happened on 6/12/2012 filed by the complaint? Why the complaint? Which clearly shows that on 13th, the improved versions were presented before the jurisdiction police. And the prosecution examined one of the Manjunath as a eyewitness. As per the complainant witness also, he was not at all present on that day. Other than interested witness, not even one independent witnesses were examined. With respect to the entire alleged instance. In spite of there is a specific awareness about that, the Magamalu other than neighbors were present on that. That prosecution is utterly failed with respect to the prove the entire instance. Therefore, considering this aspect, rightly acquitted the from the alleged. Statements which were recorded by the police as per that PW6 is stated that he recorded the statement in the hospital, but he was not taken the consent of the doctor. He was not taken the statement in front of the presence of the doctor.
No, where that is mandated. You are opening a new Pandora box.
These things to show that
To show that ಅಲ್ಲ ಅದು ಮಾಡ್ಬೇಕಂತ ಎಲ್ಲಿದೆ ಅದು ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಬರುತ್ತೆ ಹೇಳಿ when that would arise, when that would be necessitated.
he is not in a position to be
ಅಲ್ವೇ
he ತಗೊಂಡಿದ್ದೀರಿ. It is that you have to take the statement of the doctor. ವೈದ್ಯಾಧಿಕಾರಿಗಳ ಹೇಳಿಕೆಯೂ ಕೊಡಬೇಕಿದ್ದಾರೆ.
ಅಲ್ಲಿ ತಗೊಳ್ಬೇಕು ಅನ್ನೋದನ್ನು ತೋರಿಸ್ಬೇಕು. ಫಸ್ಟ್ ಏನೇನ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಿ. ಫಸ್ಟ್ ಯು ಶುಡ್ ಕನ್ವಿನ್ಸ್ ದಿ ಕೋರ್ಟ್ ದಟ್ ಹಿ ವಾಸ್ ಡ್ಯೂಟಿ ಬೌಂಡ್ ಟು ಡೂ ದಟ್, ಹಿ ವಾಸ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಡೂ ದಟ್. ನಾಟ್ ಡೂಯಿಂಗ್ ದಟ್ has resulted to suspect the case of the prosecution. ಆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು. ಏನ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋದನ್ನಷ್ಟನ್ನೇ ಹೇಳಿಬಿಟ್ರೆ ಆಗೋಲ್ಲ ಅದು. ಅದು ಫಸ್ಟ್ ಮಾಡಬೇಕಿತ್ತು. ಯಾಕೆ ಅವಶ್ಯಕತೆ ಇತ್ತು? ಈ ಕೇಸಿನಲ್ಲಿ ಮಾಡಲಿಲ್ಲ. ಮಾಡದೇ ಇರೋದಕ್ಕೆ ಕಾರಣ ಕೊಟ್ಟಿದಾರ? ಆ ಮಾಡದೇ ಇರುವುದು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕೇಸನ್ನ ನಂಬಲು ಶಕ್ಯವೋ ಅಥವಾ ಸಂಶಯಿಸಬೇಕು. ಹಂತ ಹಂತವಾಗಿ ಹೋಗ್ಬೇಕು.
This statement, he is not even recorded which one he was admitted, where he was there, all other things, nothing is stated. It's a false statement. I am just stating is that difference is that not even he was taken the statement in the hospital itself. ಅವರ ಕ್ಲಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲೇ ಒಂದು ಹೇಳ್ತಾರೆ, ನಾನು ಚಿತ್ತೂರು PAS ಅವರ ಆಸ್ಪತ್ರೆಗೆ ಭೇಟಿ ಕೊಟ್ಟು ವಿಧಿಯನ್ನು ಬರೆದುಕೊಂಡು ಬರುವಂತೆ ಲಿಖಿತವಾಗಿ ತಿಳಿಸಿದ್ದ. ನಾನು ನನ್ನ ಹೇಳಿಕೆಯಲ್ಲಿ ಗಾಯಾಳುಗಾರರು ಆಸ್ಪತ್ರೆ ಯಾವ ವಾರ್ಡಿನಲ್ಲಿ ಸೇರಿಕೆಯಾಗಿದ್ದಾನೆ ಮತ್ತು ಒಳರೋಗಿಯಾಗಿ ಸಂಖ್ಯೆಯನ್ನು ಬರೆದಿಲ್ಲ ಅನ್ನುವುದು ಸರಿ. ಗಾಯಾಳುಗಾರರು ಹೇಳಿಕೆ ಕೊಟ್ಟ ಸ್ಥಿತಿಯಲ್ಲಿ ಇದ್ದರೂ ಅಥವಾ ಇಲ್ಲವೋ ಅಂತ ವೈದ್ಯಾಧಿಕಾರಿಗಳು ಅಭಿಪ್ರಾಯವನ್ನು ಪಡೆದಿಲ್ಲ. ವೈದ್ಯಾಧಿಕಾರಿಗಳ ಹೇಳಿಕೆಯನ್ನು ಸಹ ನಾನು ಪಡೆದಿಲ್ಲ. ನಾನು ಪುತ್ತೂರು ಆಸ್ಪತ್ರೆಗೆ ಭೇಟಿ ಎಲ್ಲಿ ಮಾಡಿಲ್ಲ ಅನ್ನುವುದು ಸರಿ ಅಂತ.
ವಕೀಲ್ರೆ, ಆ ಪಾಯಿಂಟ್ PW6 ನ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ, PW6 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡುವ ಅವಶ್ಯಕತೆಯೇ ಇರಲಿಲ್ಲ. ಅವ್ರು PW6 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ, ಬೇಡದೇ ಇರೋ ವಿಷಯ ಎಲ್ಲದನ್ನೂ ಮಾಡಿದ್ದಾರೆ. ನನ್ನ ಫಸ್ಟ್ ಪ್ರಶ್ನೆ ನಿಮಗೆ ಅದರಲ್ಲಿ ಇತ್ತು. ಯಾವಾಗ ನೀವು ದಿ ಡಾಕ್ಟರ್ ಸಿಗ್ನೇಚರ್ ಇಸ್ ನಾಟ್ ಒಬ್ಟೈನ್, ದಿ ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ದ ಡಾಕ್ಟರ್ ಇಸ್ ನಾಟ್ ಶೋನ್ ಅಂತ ಹೇಳಿದ್ರಿ, ಅವಾಗಲೇ ನಾನು ನಿಮಗೊಂದು ಹಿಂಟ್ ಕೊಟ್ಟೆ, ವೆನ್ ದಟ್ ವುಡ್ ಬಿ ನೆಸೆಸಿಯೇಟೆಡ್ ಅಂತ. ಆ ಸಂದರ್ಭದಲ್ಲಿ PW6 ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಂಡೆ ಅಂದಾಗ, ಹೌದಪ್ಪ ನೀನು ಅವನೇನ್ ಹೇಳಿದಾನೆ ಅಂತ ಹೇಳ್ತಿದ್ದೆ ಅದು ಸುಳ್ಳು, ಸಾಕಿತ್ತು ಒಂದು ಸೆಂಟೆನ್ಸ್. ಉಳಿದದ ಎಲ್ಲ ಏನು ಒಂದು ಪ್ಯಾರ ಆಗಿದೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್, ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ಅನ್ಕನೆಕ್ಟೆಡ್ ಟು ದಿ ಪ್ರೆಸೆಂಟ್ ಅಫೆನ್ಸಸ್ ಅಲೀಜ್. Anything else? Yes. Heard the argument of Learned Counsel for respondent number 1 to 4. Since the lunch time is intervening, call the matter at 2:30 p.m. for the reply by the RLA.
Remaining matters. Remaining matters.
ಮಧ್ಯಾಹ್ನ ಇದೆ ಅಲ್ವಾ ಸಿಟ್ಟಿಂಗ್?
ಇದೆ
ಮತ್ತೆ
ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್. ಈಗ ನಾನು ಹೇಳಿದ
Yes.
continuation of the argument, number 4. SPP, Vinay Kirti M for respondent 1 to 4.
Yes.
Date of incident matter. Summarize method, previous statement, responsible matter of project. Summarize method, list of the the date of incident is mirrored 5/12/12. The date of reporting incident is mirrored on 13/12/2012. FIR came to be registered in crime number 123 of 2000 for the offence under 323, 324, 504, 506, Red section 34 of IPC and section 3, 1, 10 and 15 of STST Act was followed in the initial. While filing the charge sheet, my lord, 323, 324, 326, 504, 506, Red section 34 and section 3.
ಒಂದಿದೆ ಇನ್ನೊಂದು ಒಂದು ಬರಬೇಕಿದ್ದೆ ನಾನು ರಿಪ್ಲೈ ಅಂತ ಈ ಮೂರನ್ನು ನನಗೆ ತಗೊಂಡಿದ್ದೆ ಇನ್ನೊಂದು ಇರಲಿ ಪ್ರೊಸೀಡ್ ಪ್ಲೀಸ್.
Then charge sheet was filed on the side of that.
Yes.
And the honorable trial court method framed the charges for the offence punishable under 323, 324, 326, 504, 506, Red section 3, 1, small term of the CST of the Act on 28/7/2014. Then, my lord, further, my lord, additional charges, my lord, was framed for 326 under section 3 to 5 was added.
Yes.
3 to 5 was added. So, my lord, while filing the FIR, my lord, 326 was not there, my lord, was not inserted. Subsequently, in the charge sheet, it was added, and charges was also framed. While framing the charges, my lord, 3 to 5 was inserted. I just come to the how all these sections attract to the case of the prosecution. I just come to that later on. Let me explain the evidences of that has been deposed by the prosecution. Because my learned friend started his arguments that said SCST Act provision is not applicable to the case on that. I just demonstrate, my lord, how these set provisions are applicable in my second stage of argument. The first stage of arguments, I just go through the evidence, all the evidences supported the case of the prosecution with respect to the witnesses.
Yeah, we have read the evidence in its entirety. You can draw our attention to the relevant portion.
Please, my lord.
Read our argument. Yes.
My lord, prosecution, my lord, 9 witnesses were examined.
Yes.
Sharadama is the complaint to which exhibit P1 complaint and exhibit P2 the spot master and MO number 1 and 2 were master. P2 PW2 is the Timaya, who is the victim.
Yes.
I just read these two evidence, my lord. And PW3 the Manjunath. ನಾವು ಕೇಳಿದ್ವಿ ಒಂದು ಪ್ರಶ್ನೆ, ಮಂಜುನಾಥ್ ಅನ್ನೋರು ಇಬ್ರು ಇದ್ದಾರಾ ಅಂತ ಕೇಳಿದ್ವಿ. So it is my duty, my lord, to enlighten the court that the two Manjunaths. ಇವ್ರ ಮಗನ ಮಂಜುನಾಥ್ ಇದ್ದಾರೆ, ಈ PW3 ಮಂಜುನಾಥ್ ಇದ್ದಾರೆ. ಅದ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ
ಇಬ್ರು ಮಂಜುನಾಥ್ ಇದ್ದಾರೆ. ಸೊ ಯಾವ ಮಂಜುನಾಥ ಎದ್ದಿದ್ದು?
ಮಂಜುನಾಥ್
ಎದ್ದೇಳು ಮಂಜುನಾಥ.
PW3 ಇದ್ದಿದ್ದು. PW3 ಅವ್ರ ಸ್ವಂತ ಮಗ, ಇವ್ರಿಗೂ ಅವ್ರಿಗೂ ಸ್ವಲ್ಪ ಮನಸ್ತಾಪ ಇದೆ, ಪಕ್ಕದ ಮನೆಯಲ್ಲಿ ವಾಸ ಆಗಿದ್ದಾರೆ. ಅದು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಂದಿದೆ.
ಅವನೇ PW3.
ಈ PW3 ಬಂದ್ಬಿಟ್ಟು ಈಸ್ ರಿಲೇಟಿವ್ ಟು PW1 and 2. ಇವ್ರ ಮಗನೂ ಕೂಡ ಮಂಜುನಾಥ್ ಈಸ್ ನಾಟ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್ ವಿಟ್ನೆಸ್. ಸೊ ಅದನ್ನ PW1 and 2 ಮಗನ ಸೈಡ್ ಬಿಟ್ಬಿಡ್ತೀನಿ. And my lord, PW4, my lord, is the doctor examined before the court, and the wound certificate, my lord, is at P4. P5 is one Ganesh, is the Caesar Master, comes hostile to the case of the prosecution. PW6, my lord, is the ASI, one Mr. Krishnamurthy Char. He, after registering the complaint, my lord, he visits the hospital in Tumkur, and his statement is recorded, which came to be marked to him at exhibit P5. And PW7 is one Raju PSI who receives the complaint and registers the FIR. And another witness, my lord, PW8 is also Caesar Mazar, does not support the case of the prosecution. My lord, PW5 and PW8, they are the spot Mazar and the Caesar Mazar to MO number 1 and 2. Both does not support the case of the prosecution, my lord. I mean to say, they do not completely give away the case of the prosecution. They admit the signature at exhibit P2. ಎರಡರಲ್ಲೂ signature admit ಮಾಡ್ಕೊತಾರೆ. Then PW9 is the investigating officer who was done the investigation, and he has submitted the charge sheet before the trial court. My lord, my learned friend, my lord, has stated that the ingredients of the SCST Act are not applied by reading the complaint, my lord. And there is a delay in lodging the complaint. These two aspects, my lord, I will cover in one argument, my lord, because both are connected to each other.
Yes.
Because for that I have to read exhibit P1 as well as the evidence of PW1.
Yes.
My lord, I exhibit P1, my lord.
Yes.
I will not read the entire, my lord.
Yes.
Because my lordship is ವಕೀಲರು ಒಕ್ಕಲಿಗರ ಡೈಲಿ ಕರಿಯಪ್ಪ ಮಗ ಸೊ ಅನ್ಸೋ ಅವ್ರು ಯಾರ್ಯಾರು ಬಂದು ಇವ್ರಿಗೆ ಹೊಡೆದಿದ್ದಾರೆ ಮಾಡಿದ್ದಾರೆ, ಯಾರ್ಯಾರು ಹೊಡೆದಿದ್ದಾರೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ದಾರೆ. ನನ್ನ ಗಂಡ ತಿಮ್ಮಯ್ಯನಿಗೆ 4 ಜನ ಸೇರಿ ಹೊಯ್ದಿದ್ದಾರೆ ಅಂತ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ದಾರೆ. ಯಾರು ಹೊಡೆದಿದ್ದಾರೆ, ಏನು ಹೊಡೆದಿದ್ದಾರೆ, ದೊಣ್ಣೆ ಕೈಯಿಂದ ಹೊಡೆದಿದ್ದಾರೆ. So, my lord, the PW1 in the chief examination, my lord.
When exhibit to P1, whether there is any ingredients of section 3 of the act?
That pertains some because the entire matter, my lord, whether the SCST Act is applicable to the present case or not, my lord, I may be permitted to address my arguments on.
Exhibit P1 is a base, is it?
Exhibit with P1 is the base of ಒಪ್ಕೋತೀನಿ ಕೈಯಲ್ಲಿ ಹೊಡೆದಿದ್ದಾರೆ ದೊಣ್ಣೆಲ್ಲಿ ಹೊಡೆದಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅವರು ಎಲ್ಲೂ ಜಾತಿ ನಿಂದನೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿಲ್ಲ ಅದಕ್ಕೆ ಬರ್ತೀನಿ ಸ್ವಾಮಿ ಆನ್ಸರ್ ಮಾಡಿ My lord, apart from the narration of the incident, my lord, the PW1, my lord, in the complaint, my lord, she further states why there is a delay. ನಾನು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ತದನಂತರ ನಾನು ಬಂದು ಫಿರ್ಯಾದನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ. So she has explained the delay. It is not that 8 days is a delay fatal to the case of the prosecution, my lord. She has very eminently has explained why there is a delay. ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ನೋಡ್ಕೊತಾ ಇದ್ದಾರೆ. Even, my lord, even in the chief examination, my lord, she clearly states ದಾಸ ಎರಡೂರವರು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಇದ್ದಾಗ ಯಾರು ನೋಡಿಕೊಂಡು ಇಲ್ಲದೆ ಇದ್ದುದರಿಂದ ತಡವಾಗಿ ಫಿರ್ಯಾದನ್ನು ಕೊಟ್ಟಿರುತ್ತೇನೆ. So, my lord, the first point of arguments there is a delay, my lord. Delay is very well explained even in the complaint as well as in the chief examination, my lord. And further, my lord, drawing of exhibit P2 Mazar, my lord, she is one of the witness. She identifies the Mazar that was drawn in front of her house. That is on the next day after registering the FIR, my lord. The next day the Mazar was drawn. The Mazar is at exhibit P2, my lord, at in page number 81 of the paperwork. In this, my lord, ಎರಡು ದೊಣ್ಣೆಗಳು ಒಂದು ಎದುರು ದೊಣ್ಣೆಯಾಗಿದ್ದು ಇದು ಸುಮಾರು 3.1 ಇಂಚು ಉದ್ದ, ಇನ್ನೊಂದು ದೊಣ್ಣೆ 2. This is the description of the MO, my lord, that has been explained in the Mazar. My lord, in the cross examination, my lord, fifth line, my lord, ನನ್ನ ಮನೆಯ ದಕ್ಷಿಣ ಕಡೆಗೆ
PW1.
PW1, ಒಂದನೇ ಆರೋಪಿ ಡೈರಿ ರಂಗಸ್ವಾಮಿ ಮನೆ ಪಕ್ಕದಲ್ಲಿ ಇದೆ ಎಂದರೆ ಸರಿ. Their own suggestion. So there is a diary abutting to the place where the resides. ನಮ್ಮ ಊರಿ 150 ಮನೆಗಳಿದೆ. KMF ವತಿಯಿಂದ ಡೈರಿಯನ್ನು ನಡೆಸುತ್ತಾರೆ. ಫರ್ದರ್, my lord, ಸದರಿ ಡೈರಿಗೆ 1ನೇ ಆರೋಪಿ ಕಾರ್ಯದರ್ಶಿ, 2ನೇ ಆರೋಪಿ ನಿರ್ದೇಶಕರು, 3ನೇ ಆರೋಪಿ ಡೈರಿಯನ್ನು ಹಾಲು ಪರೀಕ್ಷಿಸುವ ವೃತ್ತಿಯನ್ನು ಮಾಡುತ್ತಾನೆ. ನಮ್ಮ ಊರಿನ ಜನ KMF ಡೈರಿಗೆ ಹಾಲನ್ನು ಹಾಕುತ್ತಾರೆ. ಸಂಜೆ 6 ಗಂಟೆಗೆ KMF ವತಿಯಿಂದ ಲಾರಿಯನ್ನು ಡೈರಿ ಹಾಲನ್ನು ಶೇಖರಣೆ ಮಾಡಿ ಕ್ಯಾನ್ ಅನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋಗುತ್ತಾರೆ. So, my lord, with respect to the dairy, that is in that village is not disputed, and the accused number 1 is the Karyadarshi, so that is not disputed, my lord. Further, the questions have been posted ಈ ಗಾಯಗಳು ಕಲ್ಲಿನ ಬಿದ್ದರೆ ಹೀಗಾಗುತ್ತೆ. ಐ ನಾಟ್ ಟೇಕ್ ಇನ್ ಟು ದಟ್ one learned friend has brought to the notice of the cross examination in page number 6, my internal page.
Yes.
6 of the cross examination.
Yes.
In page number 54.
Yes.
ನಾನು ನನ್ನ ಮಗ ಮಂಜುನಾಥ್ ಸೇರಿ ಕುರಿತು ಗಲಾಟೆ ಮಾಡಿಕೊಂಡಿದ್ದಕ್ಕೆ ರೋಡಿನ ವಿಚಾರದಲ್ಲಿ ವೈಮನಸ್ಸು ಇದ್ದುದರಿಂದ ಸುಳ್ಳು ಫಿರ್ಯಾದನ್ನು ಕೊಟ್ಟಿದ್ದರಿಂದ ಸರಿಯಲ್ಲ. ಸೊ ಇಲ್ಲಿ ನಾನು ನನ್ನ ಮಗ ಸೇರಿ ಕುಡಿದು ಗಲಾಟೆ. ಸೊ ಇಲ್ಲಿ ಅವರ ಮಗ ಮಂಜುನಾಥ್ ಅಂತ
ಸೊ ತಾಯಿ ಮಗ ಒಟ್ಟೆ ಕುಡಿತಾರೆ ಅಂತ.
So my lord, this is the evidence of PW1. So where it clearly shows Ibro witness, sorry, Manjunath ಅನ್ನೋರು ಇದ್ದಾರೆ ಅನ್ನೋದು ನಮ್ಮ ಗಮನಕ್ಕೆ ತರ್ತದೆ.
ಹೇಳಿ.
ಅದರಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳ್ತಾರೆ ಮಂಜುನಾಥ್ ಘಟನೆ ನಡೆದ ಮರು ದಿವಸ ನಮ್ಮ ಮನೆಗೆ ಬಂದಿರುತ್ತಾರೆ. ಅದೇ ಮಂಜುನಾಥ್ ಚಾಸಾ 3 ಕಲ್ಲಿನ ಕಾಂಟ್ರಾಕ್ಟ್ ಚಾಸಾ 3 ಅಂತ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ. ಹಾಗೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ ಅವರು ಚಾಸಾ ಮಗ ಮಂಜುನಾಥ್. ಫರ್ದರ್ my lord, ಮಂಜುನಾಥ್ ಹೋಗಿ ಸಂಘದ ಕಾರ್ಯದರ್ಶಿ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ತಮ್ಮ ಮಗ ಅಂತ ಏನು ಬಂದಿಲ್ಲ. ತಮ್ಮ ಮಗ ಮಂಜುನಾಥ್ ಹೋಗಿ ಜನ ಕಾರ್ಯದರ್ಶಿ ಅಂತ ಬಂದಿಲ್ಲ. My lord, the evidence of PW2, my lord, who is the victim, he also states about the incident. ಯಾರು ಹೊಡೆದಿದ್ದಾರೆ ಏನು ಅಂತ ಚಿಕ್ಕ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ.
ಒಂದು ನಿಮಿಷ, ಜಸ್ಟ್ ಹೋಲ್ಡ್ ಆನ್. Yes.
This witness also, my lord. The cross examination, my lord, at page number 4, page number 58.
Additional charge. Yes.
ನನ್ನ ಮಗ ಸೊಸೆ ನನ್ನ ಜೊತೆ ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ಹಾಗೂ ತುಮಕೂರು ಆಸ್ಪತ್ರೆಗೆ ಬಂದಿರಲಿಲ್ಲ. ಆದರೆ ದಿನಾಂಕ 6/12, ಇಟ್ ಇಸ್ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ 6/12/2012 ತುಮಕೂರು ಆಸ್ಪತ್ರೆಗೆ ಬಂದಿದ್ದರು. ಶಾಸಕ 3ರವರು 7/12 ಬಂದಿರುತ್ತಾರೆ. ದಿನಾಂಕ 6/12/2001 ಶಾಸಕ ಬಂಧು ರವರ ಜೊತೆ ನನ್ನ ಮಗ ಶಿವಣ್ಣ ಶಾಸಕ 3 ಮಂಜುನಾಥ್ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಫಿರ್ಯಾದಿಯನ್ನು ಕೊಡಲು ಹೋಗಿದ್ದರು. So here also ಮಂಜುನಾಥ್ ಅಂತ ಬರುತ್ತೆ. May now take to the chief examination of PW3, my lord. ಅವನ ಹೆಸರು ಮಂಜುನಾಥ್, ಅವನ ತಂದೆ ಹೆಸರು ತಿಮ್ಮಯ್ಯ. PW2 ಆಲ್ಸೋ ತಿಮ್ಮಯ್ಯ, ಆದ್ರೆ ಊರು ಬೇರೆ ಬೇರೆ ಇದೆ.
ಈತ ಅಳಿಯ.
ಪ್ರಾಸ 1 ನನ್ನ ಅತ್ತೆ, ಪ್ರಾಸ 2 ನನ್ನ ಮಾವನಾಗಬೇಕು. ದಿನಾಂಕ 5/12 ಪ್ರಾಸ 1 ಮತ್ತು 2 ಮನೆಗೆ ರಾತ್ರಿ 8 ಗಂಟೆಗೆ ಸಮಯಕ್ಕೆ ಹೋಗಿದ್ದೇನೋ. ನಾನು ಹೋದಾಗ ಪ್ರಾಸ 2 ರವರು ಗಟ್ಟಿಯಾಗಿ ಕೂಗಿ ಕೊಳ್ಳುತ್ತಿದ್ದರು. ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮುಂದಿರುವ 1 ಮತ್ತು 2ನೇ ಆರೋಪಿಗಳು ಪ್ರಾಸ 2 ರವರಿಗೆ ದೊಣ್ಣೆಯಿಂದ
ಹೊಡೆಯುತ್ತಿದ್ದರು. ನಾನು ಮತ್ತು ಪ್ರೊಸೆಸರ್ ಬಿಡಿಸಲು ಹೋಗಿದ್ದೆವು. ಫರ್ದರ್ ಮೈ ಲಾರ್ಡ್ ಇನ್ ದಿ ಬಾಟಮ್. ಮಾರನೇ ದಿನ ಬೆಳಗ್ಗೆ ಪ್ರಾಸ 2 ರವರು ತುಮಕೂರು ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಸೇರಿಕೆಯಾದ ಬಗ್ಗೆ ಗೊತ್ತಾಯಿತು. ನಾನು ಪ್ರಾಸ 2 ರವರು ತುಮಕೂರು ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಚಿಕಿತ್ಸೆಯನ್ನು ಕೊಡಿಸಲು ಸಹಾಯ ಮಾಡಿದ್ದೇನು. So my lord, this Manjunath is the relative of PW 1 and 2. Then my lord, PW 4, my lord, who is the doctor, in the chief examination, my lord, he narrates. ನಾನು ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿಯಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ವೈದ್ಯಾಧಿಕಾರಿಯಾಗಿ ಅಕ್ಟೋಬರ್ 2016 ಇಲ್ಲಿಯವರೆಗೂ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಸಂಬಂಧಿಸಿದಂತೆ ಹುಲಿಯೂರು ಪೊಲೀಸ್ ಠಾಣೆ ದಿನಾಂಕ 9 ರಾತ್ರಿ 10:45ಕ್ಕೆ ಸಿಂಹಯ್ಯ ಅನ್ನೋರು ಗಾಯಾಳಾಗಿರುವ ಹೊಡೆದಾಟದ ಇತಿಹಾಸದೊಂದಿಗೆ ನನ್ನ ಮುಂದೆ ಪರೀಕ್ಷೆ ಹಾಜರುಪಡಿಸಿದ್ದರು. ಅವರ ಪರೀಕ್ಷೆ ಕೆಳಕಂಡಾಗ ಫರ್ದರ್ ಮೈ ಲಾರ್ಡ್, ಗಾಯಾಳರನ್ನು ಹೆಚ್ಚಿನ ಚಿಕಿತ್ಸೆಗೆ ತುಮಕೂರು ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಕಳಿಸಿಕೊಟ್ಟಿರುತ್ತೇನೆ. ಈ ಹಿಮ್ಸೆಲ್ಫ್ ಆಸ್ ರೆಫರ್ಡ್ ಮಾಡಿದ್ರು ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಬರ್ತಾರೆ, ಯಾಕಂದ್ರೆ ಅವರು ರೆಫರ್ ಮಾಡಿರೋದಕ್ಕೆ ಏನು ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಸದರಿ ತುಮಕೂರು ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಒಳರೋಗಿಯಾಗಿ ಚಿಕಿತ್ಸೆ ಮಾಡಿ ವರದಿ ಕೊಟ್ಟಿದ್ದರು. ಸದರಿ ವರದಿ ಆಧಾರದ ಮೇಲೆಗೆ ಮೇಲೆ 1ನೇ ಗಾಯ ಮೂಳೆ ಮುರಿತವಾಗಿದೆ, ತೀವ್ರ ಸ್ವರೂಪದ ಗಾಯವಾಗಿರುತ್ತದೆ ಅಂತ ಹೇಳಿದ್ರು. ಮೈಲಾಡ್ ಗುಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಮೈಲಾಡ್ ಇಸ್ ಮಾರ್ಕ್ಡ್ as exhibit P2 ಮೈಲಾಡ್. ಮೈಲಾಡ್ ಈ ಕ್ಲಿಯರ್ಲಿ ಸ್ಟೇಟ್ಸ್ ಮೈಲಾಡ್ ತುಮಕೂರಲ್ಲಿ ಕೊಟ್ಟಿರೋಂತ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ನ ವೆರಿಫೈ ಮಾಡಿ ಈ ಸೇಸ್ is not that without verifying the records. Yes, given this. The cross examination method. ತನಿಖಾಧಿಕಾರಿಗಳು ತುಮಕೂರು ಜಿಲ್ಲಾ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ವೈದ್ಯಾಧಿಕಾರಿ ವರದಿಯನ್ನು ಗಾಯದ ಪ್ರಮಾಣ ಪತ್ರದ ಜೊತೆ ಕಳಿಸಿಕೊಟ್ಟಿರುತ್ತೇನೆ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅದನ್ನು ಕಳಿಸಿಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ಈ ಗಾಯದ ಪ್ರಮಾಣ ಪತ್ರ ಜೊತೆ ಕಳಿಸಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅವರು ಅಯ್ಯೋ ಕೇಳ್ಬೇಕಾಗಿಲ್ಲ, ಇದನ್ನ ಮಾತ್ರ ಪಡ್ಕೊಂಡಿದ್ದೀರಾ, ಅದನ್ನ ಪಡ್ಕೊಂಡಿಲ್ಲ ಅಂತ ಎಲ್ಲೂ ಪ್ರಶ್ನೆ ಮಾಡಿಲ್ಲ.
ನೀವಾಗಿ ಅದನ್ನು ಮಾರ್ಕ್ ಮಾಡಿಸಬಹುದಿತ್ತು ಕೂಡ.
ಮಾರ್ಕ್ ಮಾಡಿಸ್ಬೇಕು. Then the next witness, my lord, is the Caesar Mazar, my lord. He doesn't support the case, but he only accepts his signature. Then PW6 is ASI who visits the hospital and records the statement. Even my lord, by perusing the exhibit P5, my lord, what is narrated in the complaint, what is reported in the prosecution, in the chief examination, ಅದರಲ್ಲಿ ಸೇಮ್ ಹೇಳಿದ್ದಾರೆ. there is no improvements, commission commissions ಏನಿಲ್ಲ. ಪ್ರತಿಯೊಂದು ಘಟನೆ ಏನ್ ನಡೆದಿದೆ ಅದೇ ತರ ಹೇಳಿದ್ದಾರೆ. Then my lord, PW7 who receives the complaint, my lord, and the other witness PW8, then accepting his signature, my lord. He denies the other is exhibit P2, my lord. That is he has been considered. Lord, the last witness, my lord, the investigating officer, my lord. Cross examination. ಫಿರ್ಯಾದಿದಾರರ ಮನೆಯ ಉತ್ತರ ದಿಕ್ಕಿನಲ್ಲಿ ಡೈರಿ ಇರುತ್ತದೆ. ಅವರ ಮನೆ ಮುಂದೆ ಓಡಾಡಬೇಕು ಅನ್ನೋದು ಸರಿ. ಫಿರ್ಯಾದಿ ರಸ್ತೆ ಜಾಗವನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ಮನೆ ಕಟ್ಟುತ್ತಿದ್ದಾರೆ ಅಂತ ಆರೋಪಿಗಳು ತಕರಾರು ಮಾಡಿರುತ್ತಾರೆ ಅನ್ನುವುದು ಸರಿ. ದಟ್ ಈಸ್ ದೇರ್ ಓನ್ ಸಜೆಷನ್ಸ್ ಮೈ ಲಾರ್ಡ್. ದೇರ್ ಓನ್ ಸಜೆಷನ್. ಆಲ್ ಡೈರಿ ಇದೆ ಅಂತ ಹೊಡ್ಕೋತಾರೆ. ಇಲ್ಲಿ ಆಲ್ ಡೈರಿ ಬರ್ಬೇಕಾದ್ರೆ ಓಡಾಡ್ಲಿಕ್ಕೆ ಇವ್ರು ಕಾಂಪೌಂಡ್ ಹಾಕಿದ್ರೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ಸೊ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಿ ಸೆಟ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಮೈ ಲಾರ್ಡ್, ದೇರ್ ಇಸ್ ನೋ ಡಿಸ್ಪ್ಯೂಟ್. Coming to the provisions that has been invoked, my lord. My learned friend has first addressed his arguments whether section 3:110, 3:25 that is applicable. May I read, my lord, the provision?
You have read it, you can proceed further.
Yes, my lord.
Yeah.
My lord, section 3:110, my lord, that is the prior to amendment, my lord. Intentionally insults or intimidates
In a place which is in public view, yes.
imitate a member of a scheduled caste or a scheduled tribe in any place within public view. So my lord, ಇದು ಮನೆ ಒಳಗಡೆ ಇದ್ದವನ್ನ ಆಚೆ ಕರೆದಿ ಆದಂತ ಇನ್ಸಿಡೆಂಟ್. So my humble submission is, my lord, this provision is applicable to the case only. ಮನೆ ಒಳಗಿದ್ದವರಿಗೆ ಆಚೆ ಕರೆದಿ ಹೊಡೆದಿದ್ದಾರೆ, ಜಗಳ ಮಾಡಿದ್ದಾರೆ ಅಂತ P1 ಹೇಳಿದ್ದಾರೆ, P2 ಹೇಳಿದ್ದಾರೆ. So ಇದರಲ್ಲಿ clear intentionally insults or intimidates with an intention to imitate a member of scheduled caste or a scheduled tribe in any place within public view. That is why, my lord, 3:110 has been invoked. My lord, the other SCST provision, my lord, is 3:25, my lord. Yes, read, my lord. It commits any offence under the Indian Penal Code punishable with imprisonment for the term of 10 years or more against a person or a property. My lord, this is the enabling provision, my lord. 3 to 5 is an enabling provision. Hence, my lord, subsequently, my lord, the court felt that there is additional charges required and telling additional charges was framed for 3 to 5, my lord. So, my lord, my respectful submission, my lord, as my learned friend said, that this both the provisions are not applicable, cannot be accepted. And with respect to the other offences, my lord, 323 voluntary crossing right, my lord, 324 voluntary crossing right with danger weapon, 326 voluntary crossing right by danger weapon or other means. Really don't know number 1 and 2. So though the witness does not support, my lord, signature na admit ಮಾಡ್ಕೊತಾರೆ. And 504 intentionally insult with intention to provoke a speech. 506, my lord, ಅವ್ರಿಗೆ ರೆಡ್ ಕೊಟ್ಟಿರೋದ್ರ ಬಗ್ಗೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಚೀಫ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಕ್ರಾಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. Jointly reading all the provisions, my lord, the prosecution has made out a case, my lord, and the appeal requires to be allowed, my lord.
Thank you. Appeal against acquittal format.
The summary of the case of the prosecution. Is that on the date 5/12/2012 at about 8 p.m. when the husband of the complainant by name Timmaya at CWT was in front of his house and was discussing about building a compound wall around his house. The accused, who were 4 in number, the appellants who were the accused and 4 in number, went there and appellants, the respondents bracket accused, who were 4 in number, went there and picked up a quarrel with CW2, warned him that in case if he erects a compound around his house, which causes inconvenience for the movement of the vehicles coming to their dairy, the CW2 may have to face a serious consequences, assaulted him with their hands and also with 2 sticks. ಅದು ದೊಣ್ಣೆಯ ಕಟ್ಟಿಗೆಯ ನೀವು ಹೊಡೆದಿರೋದು. ಏನಿದೆ ದಪ್ಪ? 4-5 ಇಂಚ್ ಇದೆಯಾ ಅಥವಾ 3-3.5 ಇಂಚ್ ಇದ್ದೊಂದು 2 ಅಡಿ 3 ಅಡಿ ಉದ್ದ ಇದೆಯಾ? 2.5 ಅಡಿ ಉದ್ದ ದಪ್ಪ, ಒಳ ಹಿಡಿ ಗಾತ್ರ. ಸ್ಟಿಕ್ ಮಾಡ್ರಿ. ಇದ ಕ್ಲಬ್ ಆಗಲ್ಲ, ಆಗಲ್ಲ. ಸ್ಟಿಕ್ ಇದೊಂದು ಕ್ಲಬ್ ಆಗದೇ ಇಲ್ಲ ಯಾವತ್ತು. Stick inflicting injuries upon him. Full point. The complainant, Srimati Shardamma, CW1, who was an eyewitness to the incident, joined by other person who rushed to the spot, shifted the injured to Chikkanaikanhalli General Hospital. And after initial treatment there, and at the advice of the doctor there, the injured Timmaya was shifted to Government Hospital at Tumkuru, where he was treated as an inpatient. Alleging that the accused, stating that herself and her husband were belonging to scheduled caste or scheduled tribe, Bovi. Scheduled Paka. Caste certificate ಕೊಟ್ಟಿದ್ದೀರಿ? ತೆಗಿರಿ caste certificate, exhibit P 3 4 ಏನೋ ಇರುತ್ತೆ ನೋಡಿ. P3 ನೋಡಿ, ಅದೆಲ್ಲ ಅದೇ ಆರ್ಡರ್ ಅಲ್ಲಿಯೇ ಬರ್ಬೇಕದು ಎಕ್ಸಿಬಿಟ್ಗಳು. ಬೋವಿ ಎಂದಿದ್ದಾರೆ. ಬೋವಿ ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್ ಶೆಡ್ಯೂಲ್ ಟ್ರೈಬೋ ಹೇಳಿಲ್ಲ. ನಿಮ್ಮ ಪ್ರಕಾರ ಏನದು? ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್ ಶೆಡ್ಯೂಲ್ ಟ್ರೈಬಾ? ಶೆಡ್ಯೂಲ್ ನೋಡ್ರಿ. ನಾನು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಎಕ್ಸ್ಪರ್ಟ್ in identifying the schedule. ಕರ್ನಾಟಕನಲ್ಲಿ ಎಸ್ಸಿನೇ ಇರ್ತದೆ, ಜಾತಿ ಅಂತ ಇದೆ, ಪರಿಶಿಷ್ಟ ಜಾತಿ ಇದೆ ಅಂತ. ಹಾ? ಟಚಬಿಲಿಟಿ. ಹಾ. ಇವ್ರು ಎಡಗೈನ ಬಲಗೈನ? ಹಾ. ಎಡಗೈ ಬಲಗೈ ಎರಡು ಅನ್ಟಚಬಲ್. ಹಾ, ಟಚಬಲ್. ಸೊ ಅವರೊಳಗೂ ಟಚಬಲ್ ಅನ್ಟಚಬಲ್ ಇದೆಯಾ? ಅಯ್ಯೋ ರಾಮಚಂದ್ರ,
22 ಕ್ಲಾಸ್.
ಏನೇನು ಅನ್ಕೊಂಡು ಎಷ್ಟೊಂದು ಒಳ ಹರಿವುಗಳು ತಿರುವುಗಳು ಇದೆ ರೀ. ಯಾವಾಗ ನಾವೆಲ್ಲ ಹೊರಗೆ ಬರ್ತೀವೋ ಅದರಿಂದ ಗೊತ್ತಿಲ್ಲ. ತಿಳ್ಳು ಕಾಸ್ಟ್ ಏನ್ರಿ? ಏನ್ ತಗೊಂಡ್ರಿ ಅದನ್ನ? ಸ್ಟೇಟಿಂಗ್ ದಟ್ herself and her husband belonging to Bovi caste, Bovi community, which is a scheduled caste, and that by their act, the accused 1 to 4 attempted to commit the murder of her husband. The complainant instituted a complaint with the complaint police on 5/12/2012, which came to be registered in the complaint station, crime number so and so, for the offences punishable came to be registered, the complaint station, crime number 323, 324, 504, 506, read with section 34 of IPC and under section 3110 and 3110 of SC/ST so and so act. ಎಲ್ಲದನ್ನು ಬ್ರೀವಿಟಿ ಹಾಕ್ಬೇಕು. ಲಾಸ್ಟ್ ಟೈಮ್ ಫಾರ್ಮ್ಯಾಟ್ ಸರಿ ಫಾಲೋ ಮಾಡಲಿಲ್ಲ. crime number 123 of 2012. After investigation, the complaint police filed a charge sheet against the accused for the offense. Charge sheet degree offense punishable under section 323, 324, 326, 504, 506, read with section 34 of IPC and under section 3110 of SC/ST Act. ಉಳಿದಿದ್ದೆಲ್ಲ ಫಾರ್ಮ್ಯಾಟ್ ನೋಡಿ ಹಾಕಿ, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಅದನ್ನು ಹಾಕಿ. Initially, the special court framed the charges against the accused for the offences punishable under sections so and so. Subsequently, additional charge elli. Subsequently, through an additional charge, section 325 of SC/ST Act was also framed against the accused. ಆಮೇಲೆ the accused pleaded not guilty, ಅದೆಲ್ಲದು ಬರುತ್ತೆ. The learned HCGP for the appellants in his argument submitted that all the prosecution witnesses except two panchas to the alleged scene of offense Panchanama have supported the case of prosecution. The material witnesses who are PW1, PW2 and PW3 have fully supported the case of prosecution. Their evidence is trustworthy, believable, and has come in consonance with each other. Further, the complainant, both in her complaint and in her evidence, has clearly explained the delay for lodging the complaint. Admittedly, when the son and daughter-in-law of the complainant were residing separate it was only the complainant, being the wife of the injured, was required to take care of her husband during the period of his hospitalization. As such, the complainant's evidence that since there was none other to take care of her husband while he was in hospital, she had to attend to him. As such, there was a delay in lodging the complaint. Is fully convincing and the delay has been properly explained. However, the trial court, opining that there is inordinate delay in lodging the complaint, has disbelieved the case of prosecution. The learned HCGP further contended that the fact that PW1, PW2 were belonging to scheduled caste is not denied from the accused side. Since the accused have assaulted and insulted PW2 in front of his house, which was in public view, the offense punishable under the SC/ST Act, for which the accused are charged, also have been proved by the prosecution. He further submitted that the special court, without considering, without appreciating the evidence placed before it in its proper perspective, has itself presumed untenable doubts, resulting in acquittal of the accused under impugned judgment. As such, the same warrants interference at the hands of this court. Where per contra, learned counsel for respondents number 1 to 4, in his argument, though did not deny that complainant and her husband, who were examined as PW1 and PW2 respectively, or belonging to scheduled caste, however, vehemently submitted that no way PW1 or PW2 have stated that, knowing that they belong to scheduled caste and with an intention to insult them, the accused have committed the alleged offense and insulted them in a public view. As such, merely because PW1 and PW2 were said to be belonging to scheduled caste, by that itself, it cannot be presumed that the offense punishable under section 3110 of SC/ST Act has stood proved. Thus, the trial court was justified in holding that the prosecution has not proved the guilt against the accused for the offences alleged under SC/ST Act. So, learned counsel for the respondent public accused further submitted that there is inordinate delay in lodging the complaint, which has not been convincingly explained by the prosecution, more particularly by the complainant. The contention of the complainant that she was taking care of her husband in the hospital is not convincing. He further submitted that in the evidence of prosecution witnesses, there is a disparity with respect to the alleged date of filing of the complaint. When the complaint at Exhibit P1 shows it as the same has been filed on 5 12/2005. The same has been held on 13/12/2012, whereas the evidence of some of the prosecution witnesses, including PW1, says that the complaint was filed on 6/12/2022. In such an event, if the complaint is filed on 6/12/2012, then it was for the prosecution to explain as to the fate of the alleged complaint dated 6/12/2012. In the absence of any explanation in that regard from the prosecution, the very case of prosecution becomes highly doubtful and unsafe to believe. Sapyara, with respect to the alleged incident, also the learned counsel for the respondent submitted that there are discrepancies in the evidence of PW1 and PW2 with respect to the occurrence of the alleged incident. The alleged incident. Admittedly, when there were several houses of neighbors, as neighbors to the place of incident, none of them have been examined by the investigating officer. This prima facie creates a doubt in the case of prosecution. He also submitted that the alleged incident is created, imagined by PW1 and PW2 according to their wish. He also submitted that the alleged seizure of 2 sticks at MO1 and 2 is highly doubtful, which has properly been appreciated by the special court. Finally, stating that the injuries said to have been sustained by PW2 has not been shown to have been caused by the accused, since PW4, the doctor, in his cross-examination has stated that those injuries can be caused at the fall of the injured on a hard substance. The learned counsel submitted that the prosecution's case has further weakened on its own leg. As such, the impugned judgment of acquittal does not warrant any interference at the hands of this court. Comment points for consideration. Whether the prosecution has proved beyond reasonable doubt that charge could. On the date 5/12/2012 at about 8 p.m. in Guruapura village within the limits of complaint police station in front of the house of PW2 in Guruapura village within the limits of complainant police station, while PW1 bracket CW1 Srimati Shardamma and PW2 bracket CW2 Shri Timmaya were sitting in front of their house and talking about putting up of a compound wall in front of their house. The accused number 1 to 4 approaching them abused PW2 Tamaya in filthy language and also abused in filthy language, thus provoking him to cause the breach of public peace and thereby has committed an offence punishable under section 504, read with section 34 of Indian Penal Code. Ali accused number 1 to 4 having approached them anta bantalla. While they were sitting in front of their house and bandra mele accused number 1 to 4 approached them anta bantu nodi odi. ಅಷ್ಟೆಲ್ಲ ಅಲ್ಲ ನಾನು ಕೇಳ್ತಿರೋ ಪಾಯಿಂಟ್ ಅಷ್ಟೇ ಓದಿ.
Like 1 to 4 are approaching, I think they abuse the PW2. The Tamaya
ಅಲ್ಲ
was provoking.
ಅಪ್ರೋಚಿಂಗ್ ದೆಮ್ ಅಂತಿದೆಯಲ್ಲ, ಅಪ್ರೋಚಿಂಗ್ ದೆಮ್ ಅದ್ರ ಮೇಲೆ ಅಲ್ಲೊಂದು ಕಾಮ ಹಾಕಿ 2 ವರ್ಡ್ ಸೇರಿಸಿ ಇನ್ ಫರ್ದರೆನ್ಸ್ ಆಫ್ ದೇರ್ ಕಾಮನ್ ಇಂಟೆನ್ಷನ್ of warning and causing the death of PW2 Timmaya. 307 ಇದೆಯಾ ಇಲ್ಲ, causing grievous injury to Timmaya ಅಂತ ಮಾಡಿ, ಡೆತ್ ಬೇಡ ತಿಮ್ಮಯ್ಯ, ಆಮೇಲೆ ಮುಂದಿನೆಲ್ಲ ಬರಲಿ ವಾರ್ನಿಂಗ್ ಎಕ್ಸೆಟ್ರಾ ಎಕ್ಸೆಟ್ರಾ. 2. Whether the prosecution has proved beyond reasonable doubt that on the date, time and place mentioned at point number 1 above, the accused number 1 to 4 in furtherance of their common intention. ಇದಿಷ್ಟು ಮುಂದಿನ ಪಾಯಿಂಟ್ಗಳಿಗೂ ಕಾಮನ್ ಆಗಿ ಬರುತ್ತೆ. After approaching PW1 and 2, threatened them of dire consequences in case if PW2 proceeds in execution of his idea of putting up the compound wall in front of his house, and thereby has committed an offence punishable under section 506, read with section 34 of Indian Penal Code. 3. Whether the prosecution, etc., etc., after approaching PW1 and 2, assaulted PW2 bracket CW2 Timmaya with their hands, voluntarily causing hurt to him, and thereby committed an offence punishable under section 323, read with section 34 of Indian Penal Code. 4. After approaching them, the accused number 1 to 4 in furtherance of their common intention assaulted PW2 CW2 Timmaya with sticks on his left leg, knee, and caused injuries to PW2 Timmaya, and thereby have committed an offence punishable under section 324, read with section 34 of Indian Penal Code. 5. Whether the prosecution has proved thoroughly assaulted PW2 Timmaya ಅಲ್ಲಿ ಹಿಂದಿನದ್ರಲ್ಲೂ ಪಾಯಿಂಟ್ 4 ನಲ್ಲಿ ವಾಲಂಟರಿಲಿ ಅಸಾಲ್ಟೆಡ್ ಅಂತ ಮಾಡಿ, ಇದರಲ್ಲೂ ವಾಲಂಟರಿಲಿ ಅಸಾಲ್ಟೆಡ್ ಅಂತ ಮಾಡಿ. PW2 Timmaya with 2 sticks and in a dangerous manner, resulting in PW2 Timmaya sustaining grievous injuries and thereby have committed an offence punishable under section 326 read with section 34 of Indian Penal Code. 5. So, the accused abused PW2 Timmanya by taking the name of his caste and insulted him in front of his house, which was in public view, after knowing that said Timmanya and his wife were belonging to scheduled caste, and thereby have committed an offence punishable under section 3110 of SC/ST Act. 7. The accused having committed an offence punishable under section 326 of Indian Penal Code against PW2, knowing that he was belonging to scheduled caste, knowing that he belongs to scheduled caste, and thereby are punishable under section 325 of SC/ST Act. It is an appeal preferred by the state against the judgment of the acquittal. It is the settled principle that the accused in such a case enjoy the double benefit of, enjoy the double presumption of ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ. ಈ ಸೆಂಟೆನ್ಸ್ ಬದಲು ಫಾರ್ಮ್ಯಾಟ್ ನಲ್ಲಿ ಏನಿದೆ ಅದನ್ನೇ ಹಾಕಿ ಚಂದಪ್ಪಸ್ ಕೇಸಿಂದ ರೂಪವತಿ ಕೇಸ್ ವರೆಗೆ 4 ಕೇಸ್ ಇದೆ. ಅದಷ್ಟನ್ನು ಹಾಕಿ. From a perusal of the evidence of PW 1 to 9, the undisputed fact remains that PW 1, CW 1, Srimati Sharadamma is wife of PW 2, CW 2, Timmayya. PW 1, PW 2 as husband and wife were residing together in the village Guruvapura within Chikkanayakkanahalli Taluk. The accused number 1 to 4, who are the respondents number 1 to 4 herein, are also the residents of the very same village and are known to the family of PW 1 and PW 2. The evidence that has the evidence to this effect which has come in the evidence of PW 1 and PW 2, PW 1, PW 2 and PW 3 have remained undenied and undisputed. Further, the evidence of PW 1 that among the 4 accused, the accused number 1 was the secretary, accused number 2 was the director, and accused number 3 was the milk examiner in a milk procuring center in their village, which generally they call as a local dairy. Has remained undenied and undisputed. It is in the light of these undenied and undisputed facts, the case of the prosecution with respect to the alleged incident is required to be analyzed. Fair. About the alleged incident of accused number 1 to 4 approaching them and assaulting them, more particularly PW2, CW2 Timmayya, has been attempted to be established by the prosecution in the evidence of PW1, PW2 and PW3 bracket CW3 Manjunath. Subfair. PW1 and PW2 in their examination chief have stated that on the evening of 5/12/2012 at about 8 o'clock, both of them were sitting near their house and talking about erecting a compound wall near their house. It was at that time all the accused approaching them in that place, initiated quarrel with them, stating that they would see how they are going to put up the compound wall, and started and dragged PW2 and started assaulting him with their hands and legs. PW1 has further stated that in the process, the accused abused her husband, bracket CW2, in filthy language as inverted comma, fuck your mother, close inverted comma, bracket nalli, English letter nalli haki kannadadu word ಇಲ್ಲಿ evidence nalli ಇದೆ in Kannada language. She also stated that in the process of assaulting her husband, accused number 1 and 2 assaulted her husband, bracket CW2, with sticks. Accused number 3 and 4 assaulted him with their hands. With their hands. Since CW3, who is their son-in-law, came to their rescue, the accused questioning him as to who is he to intervene, also assaulted him. PW1 further stated that due to the assault by the accused, her husband, bracket CW2, sustained bleeding injuries. He was shifted to Chikkanayakkanahalli Hospital. From there for higher treatment, since they were advised to take him to the hospital at Tumkuru, he was shifted in the same ambulance to Tumkuru, where he was treated in government hospital. PW1 has further stated that about the alleged incident, she has lodged a complaint which she has identified at Exhibit P1. She stated that during the stay of her husband in the hospital, since none were there to take care of him. ವೆಂಕಟೇಶ್ ನಿಗಳು ಹೊರಗಡೆ ಯಾರು ಮಾತಾಡ್ತಿದ್ದಾರೆ ಹೇಳ್ಕೊಂಡು ಬಂದು ಕೂರಿಸ್ಲಿಕ್ಕೆ ಹೇಳಿ. ಕೋರ್ಟ್ ನಡೀತಾ ಇದೆ, ಅಲ್ಲಿ ಗಟ್ಟಿ ಮಾತಾಡ್ತಿದ್ದಾರೆ. ಈಗ ಇವನು ಹೋಗಿ ಸೇರಿದ.
She stated that during the stay of her husband in the hospital, since none were there to take care of him.
There was delay in she lodging the complaint. Further stating that the police, after visiting the place of incident, have seized 2 sticks from the place under a Panchanama. The witness has identified the said scene of offense Panchanama at Exhibit P2 and identified 2 sticks at MO1 and MO2 respectively.
The placement was another P1. ಇನ್ನೊಬ್ರು P1 ಮೇಲೆ ಶಿಕ್ಷೆ ಸಾಗರ P1 ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಕೊಟ್ಬಿಟ್ಟು.
This witness was subjected to a detailed cross-examination wherein she adhered to her original version. However, she has given description about the existence of few more houses as neighbors to her house in the village. She gave the details that accused number 1 to 3 were running a dairy, which was a milk collection center in the village. And for collection and transportation of the milk, the vehicles would visit the said collection center bracket diary, which passes through in front of her house. She denied the suggestion that her husband, though was a drunkard, but was creating nuisance in the village. And there were some few complaints against him in that regard. CW2 Timmaya, the husband of PW1, CW2 Timmaya Bada, has further stated that the accused, after approaching him, warned him that he shall not put up compound near his house, since it causes inconvenience for the movement of the vehicle coming to their dairy. Since he told them that he is erecting a compound within his premises, the accused number 1 and 2, dragging him outside, started assaulting him, in which process accused number 1 assaulted him on his right leg below the knee with a stick. Similarly, accused number 2 also assaulted him with another stick on his left leg below the knee. Accused number 3 and 4 also assaulted him with their hands on the different parts of his body. He has stated that the accused warned him of taking away his life in case if he lodges any complaint with the police. It was at that time his wife and CW3 bracket Manjuna rushed there and rescued him. The witness further stated that in the process, accused number 1 to 4 assaulted his wife also, stating that in the incident, due to the assault by the accused, his leg was fractured. The witness added that he was shifted to Chikkanayakanhalli Government Hospital in an ambulance, and at the advice of the doctor there, he was taken to district hospital at Tumkuru, where he took treatment as an inpatient. The witness further stated that while he was in hospital, his wife bracket CW1 went to the police station and lodged a complaint. The police had visited the hospital on 14/12/2012 and had inquired and had recorded his statement. The witness identified the sticks at MO 1 and 2 in the court. In his cross-examination, PW from the accused side, PW to adhere to his original version. He denied the suggestion that he is addicted to liquor. However, he admitted that his daughter-in-law had lodged a complaint against him, in which connection the police had summoned him to the police station and inquired. He denied the suggestion that he was encroaching a public road and attempting to erect the compound. This witness also admitted that there were neighboring houses near his house, including the house of his son and daughter. He also stated that when the incident was going on, his son and daughter had rushed to his rescue. However, they too were assaulted. In his cross-examination, the witness has admitted a suggestion that a detailed complaint was given by his wife with respect to the incident, with the complaint police on 6/12/2012. However, he denied that on the very same day, the police had recorded his statement also. He also denied a suggestion that by his own fall on a hard surface, he had sustained injuries upon him. PW3 CW3 Manjunath, who stated that PW1 and PW2 are his relatives in the parlance of uncle and auntie, has stated that he had been to their house on 5/12/2012 at about 8 p.m. At that time, PW2 was screaming and the accused number 1 to 4. The accused number 1 and 2 were assaulting him with sticks. When himself, joined by PW1, rushed to their rescue, the accused questioned him as to why he is intervening and supporting PW2. The accused also abused him as son of a scheduled caste. Bracket, inverted comma, English letter nalli, Vaddanana Magane. Close inverted comma in Kannada language. The witness stated, since the accused came to quarrel with him, he left the place. Next day, he came to know about PW2 having been admitted to Government Hospital at Tumkuru and that he helped in getting treatment to him in the said hospital. The witness has identified the sticks at IMO 1 and 2 in the court. In his cross-examination, the witness has stated that by the time he visited the spot, the quarrel had already begun. However, he did not rush to the police station to give a complaint in that regard. He further stated that he had been to the police station on 6/12/2012 along with PW1. The police received the complaint given by PW1 at about 6:30 to 7 p.m. 6:30 to 7 p.m. He expressed his ignorance that after inquiry, the police came to an opinion that it was a frivolous complaint. The denial suggestion made to him in his cross-examination from the accused side were not admitted as true by the witness. Yeah. By the witness. ಅಲ್ಲಿ ಮೇಲೆ about the incident ಅಂತ ಪ್ಯಾರಾ ಶುರುವಾಗಿದೆ ನೋಡಿ ಬಿಗಿನಿಂಗ್ about the incident. It is PW1, PW2 and PW3 who have given their evidence ಅಂತ ಬಂದಿದೆ. ಆ ಜಾಗದಲ್ಲಿ the very first contention of the respondents, which was the main contention of them even in the special court also, was about the alleged delay in lodging the complaint, which makes the case of the prosecution about the incident highly suspicious and unbelievable. It is PW1, PW2 and PW3 who have mainly spoken about the incident in their evidence. Among them, PW1 has spoken about she lodging a complaint with respect to the incident. However, a reference about the lodging of the complaint about the incident can be seen even in the evidence of PW2 and PW3 also. ಇದಿಷ್ಟನ್ನು ಹಾಕಿ ಆಮೇಲೆ PW1, CW1 in her evidence has stated. ಅದು ಅಥವಾ ಅಲ್ಲ ಹಾಗೆ ತಗೊಳ್ಳಿಲ್ಲ ನಾನು. PW1 and PW2 in their evidence have stated that while they were sitting in front of their house. ಅದು ಕಂಟಿನ್ಯೂ ಆಗಿದೆ. ಅದು ಕಂಟಿನ್ಯೂ ಆಗಿದೆ. ಈಗ ಲಾಸ್ಟಿಗೆ ಬನ್ನಿ. From the above evidence of PW1, PW2 and PW3, it can be seen that though at one place PW1 has stated that there was some delay in lodging the complaint about the incident by her with complainant police and has attempted to explain the delay, however, in the cross-examination of the very same witness, including in the cross-examination of PW2 and PW3, some suggestions were made from the accused side, showing that the complaint with respect to the incident was also shown to have been lodged on 6/12/2012 itself. It is considering the evidence that has come out regarding the lodging of the complaint and including lodging of the complaint, including the suggestions made to PW1 to 3 in their cross-examination and the response of those witnesses to those suggestions made, the alleged delay, if any, in lodging the complaint is required to be looked into. According to prosecution, the date of the commission of the crime, the date of the occurrence, the date of the commission of the offense is 5/12/2012 at about charge literally 8 p.m. According to the prosecution, the date of lodging the complaint is 13/12/2012 at Exhibit T1. At 11:10 a.m. PW1, the complainant in her cross-examination at page 5 has stated that she lodged the complaint on 6/12/2012. On that afternoon, she had been to the police station to lodge the complaint. Though she has, in her cross-examination, stated that on 13/12/2012, CW4 had taken her to the complainant police station. However,
merely because she is said to have been taken to police station on 13/12/2012. By that itself, it cannot be concluded that the complaint was lodged on 13/12/2012 only. Subparagraph. PW2. The injured, the alleged injured in the incident, and also the husband of PW1, in his cross-examination, has admitted a suggestion as true that on 6/12/2012, his wife, that is PW1, lodged a detailed complaint. Page 3 in his cross-examination at page 3 and in his cross-examination at page 3 has admitted that on 6/12/2012, his wife, that is PW1, lodged a detailed complaint with complainant police station. It was also suggested to PW2 in his cross-examination in the very same page that police visited the hospital on the date 6/12/2012. Thus, by making these suggestions to PW2, the accused has taken a stand that a week before the alleged date of lodging the complaint, which according to prosecution is 13/12/2012, the complaint police had already visited the hospital and recorded the statement of the injury. Thus, by making the said suggestion, the accused himself has admitted that the complaint was given on 6/12/2012, but not on the date 13/12/2012, though PW7, the police officer, though PW7 bracket CW9 TV Raju, then police sub-inspector of the complaint police station, has stated that the complaint was received by him on 13/12/2012. Further, PW2 has admitted a suggestion made to him in his cross-examination from the accused side as true, that, along with his wife, that is PW1, even CW3 bracket PW3 close bracket Manjunatha had also been to the police station to lodge the complaint. Subparagraph. Said PW3 bracket CW3 Manjunatha, in his cross-examination from the accused side, has stated that along with the complainant, he had been to the police station on 6/12/2012. This undenied statement, elicited by none else than the accused, further corroborates the say of PW1 and PW2 that the complainant had been to the police station on 6/12/2012 to lodge the complaint. And that
PW3 bracket CW3 accompanied her. Full stop. Subpara. It was suggested to PW3 in his cross-examination from the accused side that PW3 along with CW4 and others threatened the Deputy Superintendent of Police at his office that in case if they do not register the complaint, they would go on strike. Though the witness has not admitted the said suggestion as true, that they threatened the Deputy Superintendent of Police, however, by making the said suggestion, the accused have shown that the complainant with CW3 and CW4 had approached the police at the earliest point of time, however, they were not prepared to register the crime. This inference, subpara, is further supported by one more suggestion made to PW3 in his cross-examination from the accused side, that, it was at their pressure, complaint at Exhibit P1 was registered on 13/12/2012. Thus, the suggestion was made from the accused side that it is only after the pressure the complaint was registered, which means otherwise it would not have been registered. Further, it is suggested that complaint was registered on 13/12/2012, but not that the complaint was given on 13/12/2012. Further ಅನ್ನೋದನ್ನ ಅಲ್ಲಿ ಫರ್ದರ್ ಜಾಗದಲ್ಲಿ added to the above ಅಂತ ಮಾಡಿ ಸಪ್ಯಾರ ಮಾಡಿ. It's also for the reason that even though PW7 has stated that complainant appeared before him on 13/12/2012 and lodged a complaint as per Exhibit P1. However, on the very front page of the complaint at Exhibit P1, there is an endorsement made on the left side margin of the complaint mentioning semicolon, unit comma, received on 12/12/2012 at 8 p.m. Beneath that sign 12/12/2012, close the inverted comma. It means the complaint was not given on 13/12/2012, but it was on some earlier date. PW4, bracket CW7, Dr. Sachin, the medical officer at Government General Hospital, Chikkanayakkanahalli, in his evidence has stated that injured Timmaya, bracket PW2/CW2, was brought to their hospital on the date 5/12/2012 at 10:45 p.m. with the history of assault, by Puliyuru police, bracket complainant police. Close the bracket, full stop. The said statement of the witness has not been denied from the accused side. Thus, even according to the doctor, the injured was brought on 5/12/2012 by none else than the complainant police, comma, that too, comma, with the history of assault. As such, before 10:45 p.m. on 5/12/2012, when the complainant police are shown to have brought the injured bracket PW2 to the hospital, they knew about the alleged incident. It is because of the same they could bring the injured bracket PW2 to the hospital with the history of assault. Further, further, the very same doctor bracket PW4 in his cross-examination has stated that they have sent MLC intimation to the police station about the appearance of the injured with the history of assault. Thus, even an MLC was also given by the doctor immediately after injured was brought to his hospital by the complainant police on 5/12/2012. The said statement about the doctor giving MLC was elicited from the accused side itself, and the said statement to PW4 and the said suggestion to PW4 has also remained undenied and undisputed. Lastly, even though PW7, who claims to have registered the crime, in his cross-examination has stated that prior to the date 13/12/2012, their station had not received any information about the present incident. However, the undenied evidence of PW4, the doctor, that on 5/12/2012 at about 10:45 p.m. itself, the injured was brought to his hospital by none else than the complainant police. Shows that the complainant police had the information and knowledge about the alleged incident much prior to the date 13/12/2012. Added to this, in the very cross-examination of PW7 from the accused side, a suggestion was made to the witness suggesting that the complainant had given a complaint earlier to 13/12/2012. Earlier to, aduna underline ಮಾಡಿ bracket ನಲ್ಲಿ emphasis supplied ಅಂತ ಮಾಡಿ. However, by making an inquiry, finding no truth in it, it was not registered. However, small letter, separate sentence, 13/12/2012, comma, however, comma, by making. Later, at the pressure of Dalita Sangarsha Samiti, a case came to be registered. Though the witness has not admitted the same to be true, still, by making the said suggestion repeatedly, the accused have themselves shown that the complainant police were informed and they were aware about the incident, and the complaint was also given to them much prior to 13/12/2012. As such, evidence of PW7 repeatedly go to show that he is not believable. As such, the evidence of PW7, the case registering police officer, go to show that he is not believable as true regarding the date of receipt of complaint, as also the information, as also about the alleged non-receipt of information by his police station. Added to the above, though the complainant exhibit P1 is shown to have been given and registered on 13/12/2012, and even after taking the same as true, still the complainant in the very complaint itself has explained the reason for delay, stating that since there were nobody to take care of her husband in the hospital, there was a delay in lodging the complaint. She has reiterated the same even in her evidence also. The wound certificate at exhibit P4 also go to show that injured PW2 was treated as an inpatient in the district hospital at Tumukuru, which was not the place of residence of PW1 or PW2. The evidence of PW1 and PW2 that they too alone reside in their house, and though they have a son and daughter-in-law, but they are residing separately, since having remained undenied and undisputed the evidence of PW1 that there was none to take care of her husband while he was under treatment in the hospital appears to be more truthful, believable. For all these reasons, argument of learned counsel for the accused that there is inordinate delay in lodging the complaint, as such the very incident is doubtful, is not acceptable. However, even though the analysis made above would go to show that the complainant had approached the complainant police at the earliest point of time, not later than 6/12/2012, and that the complainant police were aware of the incident since they themselves had taken injured PW2 to Chikkanaikkanahalli Government Hospital on 5/12/2012 at 10:45 p.m. As such, the burden would be upon the prosecution to explain as to why did not the complainant police took up appropriate action immediately after coming to know about the incident on 5/12/2012 itself, but the same would not take away the evidentiary value of the evidence of PW1, PW2, and PW3 with respect to the incident. Needless to say, the laches, if any, on the part of the investigating officer or the case registering authority cannot be allowed to cause injustice to the true victim in the case. As such, a mere alleged delay, if any, would not go to the root of the case of the prosecution in suspecting the case of prosecution. About the incident of alleged assault upon PW2, as analyzed above, as observed above, it is PW1, PW2, and PW3
who have uniformly stated about the occurrence of the incident. Among these three witnesses, learned counsel for the respondent in his argument vehemently submitted that the evidence of CW3 Manjunatha is not believable for the reason that none else than his aunt, that is PW1, herself has stated that said Manjunatha visited them only on the next day after the incident. As such, the evidence of PW3 that he was an eyewitness to the incident is not, he was an eyewitness to the incident, creates a serious doubt, making his evidence unsafe to believe. Per contra, learned HCGP in his argument submitted that the materials placed before the court, more particularly the evidence led by the prosecution, shows that there were two persons with the same name, Manjunatha, and incidentally both were shown to be son of Timaya. PW1 in her cross-examination has stated that the name of her son is also Manjunatha. Admittedly, his father is Timaya, who is PW2, the injured in the case. PW3 bracket CW3 is also Manjunatha, son of Timaya. However, as rightly submitted by learned counsel for the respondent, the person Tamaya, whom PW1 has referred as the one who visited them with respect to the incident and said to have visited them on the next day of the incident, is not their son Manjunatha, but it is PW3 bracket CW3 Manjunatha, since at one place in her evidence at page 5, she has given the name of the said Manjunatha along with his rank in the charge sheet as CW3. Therefore, when PW1, who is none else than the alleged eyewitness and the complainant in the case, herself has stated that said Manjunatha bracket CW3 came to their village only on the next day of the incident, it is not safe to believe that CW3 Manjunatha was an eyewitness to the alleged incident. As such, it is unsafe to believe his evidence that he witnessed the incident and has seen the alleged overt act of accused number 1 to 4. After the very same witness in her cross-examination at page so-and-so has stated that he came at the Bantu Nodi Hinde. Insertion no doubt. Very same PW1 in her examination in chief in the beginning itself has stated that said Manjunatha bracket CW3 had been to their house on 5/12/2012 to talk to them. However, she could not adhere to her original version in her cross-examination. Rather, cross-examination, full stop. On the other hand, she herself stated that said Manjunatha visited their village on the next day and he was doing a stone contract work. Had really
CW3, bracket PW3 Manjunatha, had visited the village of PW1 and PW2 on 5/12/2012 itself, PW1 would have necessarily adhered to her original version and would not have stated in her cross-examination that it was on the next day of the incident said Manjunatha visited their place. Idistu insertion. As such, the evidence of PW3 is unsafe to believe. ಅಂತ ಏನ್ ಹೇಳಿದ್ದೇನೆ ಅಲ್ಲಿ ಎಂಡ್ ಮಾಡ್ತೀನಿ. Since the evidence of PW3 Manjunatha has proven to be not safe to believe, the only other witnesses who claims to have given a direct account about the alleged incident is PW1 and PW3. PW1 and PW2. PW1 and PW2. The evidence of both PW1 and PW2 that accused number 1 to 4 approached them while these two witnesses were sitting near their house in the late evening on 5/12/2012. 5/12/2012, initiating a quarrel with PW2 and objecting for him to put up a compound wall in front of his house, gains support from the further undivided evidence of PW1 in her cross-examination that accused number 1 was the secretary, accused number 2 was the director, and the accused number 3 was the examiner of the milk in the local dairy, bracket milk collection center. It is further corroborated by the explanation given by her that every evening the vehicle from KMF visits the local dairy and carries the milk can to their place. The said undenied evidence was further corroborated from the suggestions made to PW1 in her cross-examination and eliciting her response from none else than the accused side. The same is clear in the cross-examination of PW1 at page 4, where it was suggested to the witness that PW1 and PW2, with an intention to obstruct the movement of the vehicles to the local dairy, were encroaching a public road in front of their house and attempting to erect a compound wall. It was also suggested to PW1 in her cross-examination that the secretary of the dairy and the director had approached them, bracket PW1 and 2, and requested them not to encroach the road since it causes inconvenience for the movement of the vehicle. Though the witness better. Further, it was also suggested to PW1 from the accused side that it was in connection with the same. There was rivalry between them. Though the witness has not admitted these suggestions as true, however, by making these suggestions and also taking those suggestions as one of their defense, the accused have shown about the accused have admitted about the existence of a local dairy in the village, and any vehicle going to that local dairy has to be necessarily passed in front of the house of PW1 and PW2. And more importantly, the accused number 1, 2, and 3, being the secretary, director, and the milk examiner of the dairy, previously also approaching PW2 and asking him not to put up compound wall. This elicitation of the statement in the cross-examination of PW1 by none else than from the accused side would corroborate the evidence of PW1 and PW2 that accused number 1, 2, and 3 as the office bearers of dairy, joined by accused number 4, approached them on the evening of the date of incident and initiated a quarrel in connection with PW2's apostrophe S idea of erecting a compound wall in front of his house and objecting for the same, stating that the same would obstruct the movement of the vehicles to their dairy. Thus, in the speed of shaking the evidence of PW1, which has come in full support of the case of prosecution, the accused themselves have led to admit several things which was helpful to the prosecution in proving the motive behind the commission of the crime without much effort. The evidence of PW1 that among the 4 accused who approached them on the evening of the incident, it was accused number 1 and 2 assaulted her husband with stick, and remaining 2 accused assaulted her husband with their hands and legs. He is further corroborated in the evidence of none else than PW2, the injured. He too has given the very similar picture of the alleged incident and has specifically and clearly stated that it was accused number 1 and 2 who, apart from dragging him outside his house, also assaulted with sticks on his both legs below the knee. He has even described the overt act of accused number 1 and 2 individually, stating that accused number 1 assaulted him with a stick below his right knee, whereas accused number 2 assaulted him with a stick below his left knee. The remaining accused number 3 and 4 were assaulting him with their hands on several parts of his body. The said evidence of none else than PW2, which has stood corroborated from the evidence of PW1, who also shown her to be an eyewitness to the incident, finds no reasons to disbelieve them. In spite of the same, as submitted by learned SCGP in his argument, by relying upon a case of a judgment of Honorable Apex Court in Lakshmana versus so and so, when the evidence of an injured witness is reliable and trustworthy, the sole evidence of the injured witness can be the basis for conviction. In the said case, our Honorable Apex Court has observed that 2021 9 HEC 191
The said case our honorable apex court has observed that ಅದು extract ಇದೆ format ನಲ್ಲಿದೆ ಹಾಕಿ ಅದನ್ನು ಇಡೀ ಪ್ಯಾರ. The view the principle laid down by the honorable apex court in Lakshman Singh's case bracket supra was reiterated it in its subsequent judgment in Ashok Kumar's case. ಅದು ಅಶೋಕ್ ಕುಮಾರ್ ವರ್ಸಸ್ ಸೋನ್ಸು ಅದರದನ್ನು ಹಾಕಿ ಅದು ನಂದೊಂದು ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿದೆ ಕೇಳಿ ಕೊಡ್ತಾರೆ. As such, even though evidence of PW2 as an injured which has successfully withstood the thorough and searching cross-examination from the accused side itself is sufficient to believe that accused number 1 and 4 have inflicted injuries upon him by assaulting him with stick and by their hands. Still, the evidence of PW1 also corroborates the same, thus further strengthening the case of prosecution towards proving the alleged guilt against the accused. The medical evidence led by PW4, CW7, Dr. Sachin, further corroborates the case of prosecution. The said witness has stated that while working as a medical officer at Government General Hospital, Chikkanayakkanahalli, the complainant police brought a person by name Timmayya as an injured with the history of assault. He examined the said injured patient on 5/12/2012 at 10:45 p.m. and noticed Exhibit P43. Small Roman 1. Tenderness and swelling over the right leg, and small Roman 2. Tenderness and swelling over the left leg. The witness has stated that he referred the patient to District Hospital Tumkuru for higher treatment. The said injured was treated as inpatient in the said Government Hospital at Tumkuru and had given their report. It is based on the report of the said hospital. He noticed that the injured had sustained a fractured injury also. Which was injury number 2, observed by him as above. Since it was a fractured injury, he concluded that the said injury was grievous in nature and the other one was simple in its nature. Accordingly, he has issued a wound certificate at Exhibit P4. After seeing the 2 sticks at MO1 and 2, the witness has stated that the injuries noticed with the injured are possible to be caused when assaulted with MO1 and 2. Subpara. The very same witness bracket PW4 in his cross-examination in the very beginning sentence has also stated that the injuries found on the injured are also possible to be caused when a person falls on a hard surfaced earth. The other suggestions that he has not mentioned on which particular portion of the leg the injury was found on the injured was admitted by this witness as true.
has given, he also has stated that the investigating officer had not produced before him the sticks at MO 1 and 2 and obtained his opinion. Para. It is based upon the said statement of PW4, the doctor in his cross-examination, that the injuries found on the injured are also possible to be caused when a person falls on a hard surfaced earth, the learned counsel for the respondent in his argument vehemently submitted that when those injuries are possible to be caused by fall of a person on a hard surface, it cannot be believed that PW2 sustained those injuries only at the assault alleged to have been inflicted upon him by the accused. No doubt, the evidence of PW4 would go to show an alternate possibility of the injuries found, the alternate possibilities of the occurrence of the injuries which were found on the person of PW2. But when the trustworthy and believable evidence of PW2, who is none else than the injured himself, clearly shows that he sustained injuries only at the assault made to him by none else than accused number 1 to 4. It cannot be taken that PW2 has sustained. It cannot be taken better. He sustained injuries only at the assault made by accused number 1 to 4 against him, and also when PW1 as an eyewitness has corroborated the evidence of PW2 by all means, stating that she has seen accused number 1 and 1 to 4 but assaulting her husband, among whom accused number 1 and 2 assaulting her husband, bracket PW2, with sticks at MO 1 and 2, the possibility of occurrence of a similar injury by alternate means cannot be taken as the one which makes the case of prosecution suspicious or unbelievable. On the other hand, the alternate possibility of occurrence of the injury requires to be not given importance than what it deserves. But the evidence of PW1 and 2, which is also corroborated by the evidence of the very same doctor at PW4, that the injuries found on PW2 are possible to be caused when assaulted with MO 1 and 2, requires to be accepted and believed. As such also, the argument of the learned counsel for the respondents, bracket accused 1 to 4, on the set point is not acceptable. On the other hand, the medical evidence also stands to the support of the case of prosecution and corroborates the evidence of PW1 and 2. 1 and 2. The weapons used in the commission of the crime, according to prosecutions, are the 2 sticks at MO 1 and 2. According to PW1 and 2, according to prosecution, those 2 sticks were found in the place of the incident and the same were seized at the time of drawing scene of offense Panchanama by the investigating officer, that is, i.e. PW9, bracket CW10, Vamshi Krishna, on 14/12/2012. According to PW9, the investigating officer on 14/12/2012, he visited the place of the incident as shown to him by PW1 and drew a scene of offense Panchanama as per Exhibit P2 in the presence of PW5, CW5, M. Ganesh and PW8, CW4, E. Nagaraju. And during the drawing of scene of offense Panchanama, he also saw the two sticks shown by the complainant as the one used in the commission of the crime by the accused and seized them, which the witness has identified at MO1 and 2. Subpara. The said Panchas to the scene of offense Panchanama, that is PW5 and PW8, have not supported the case of prosecution. They have fully, they have stated that they do not know what is written there Panchanama except putting their signature to the said document at the request of the police. Even after treating them hostile, the prosecution could not get any support from them by cross-examining them. However, taking the absence of support by PW5 and PW8 to the case of prosecution, in his favor, the learned counsel for the respondent contended that the absence of the support by PW5 and PW8 further makes the case of prosecution highly suspicious to believe. No doubt, the evidence of punch witnesses in an alleged incident of crime is also important and material. But however, in the case like the one on hand, when the very material witnesses, including the injured witness and one of the important eyewitness, have supported the case of prosecution about the incident, the place of incident, and also the weapon used. And further, when the medical evidence also, further where the doctor in his evidence also has opined that the weapons at MO1 and 2 can cause the injuries found on injured bracket PW2, injured PW1 and 2. And in the circumstance when from the accused side itself, by making suggestion to PW1, it was admitted that the accused were not happy with PW2 having an idea of putting up a compound wall in front of his house and had approached him on previously also with a request not to put up such a compound wall. The total inference which leads to only one conclusion is that the alleged offense, the total inference that can be drawn would be only one, that the incident has taken place at the very same spot as contended by PW1, which was in front of their house. And there is all the possibility of the sticks lying in the said place of offense after the incident. The special court, Satyara, while analyzing the evidence on the said aspect of alleged seizure of the sticks at MO1 and 2, expressed its suspicion about the presence of Hindi sentence in Tanri.
There is all the possibility of the sticks are lying in the said the spot after the incident.
There's all the possibility of the sticks being used in the commission of the crime and making its availability to the investigating officer. Investigating officer during the time of Panchanama. And next.
The special court file analyzing feature of the six demo 1 and 2 expressed a suspicion about the presence of
About the presence of the sticks in the place of the offense for such a long time after the incident. However, in the process, it failed to notice that the sticks were not lying in the spot when the scene of Panchanama was drawn on 14/12/2012, but those sticks were produced before the investigating officer by none else than the complainant, stating that it was with the very same sticks accused Sinappa bracket accused number 1 and accused Nataraj bracket accused number 2 assaulted her husband and had thrown the same in the spot, and that she had kept it safely. Thus, the very scene of offense Panchanama mentions that those sticks were not found lying in the spot. However, after the incident, PW1 had kept them safely and had handed it over to the investigating officer at the time of drawing the scene of offense Panchanama at Exhibit P2. As such, the said reasoning given by the special court to further disbelieve the case of prosecution, stating that the alleged seizure of MO 1 and 2 creates doubt in the case of prosecution, is also not tenable. In the light of the above para, the evidence of the rest of the witnesses, who mainly is PW7 and PW9, would not be of much importance. The PW7, CW9, TV Raju, then police sub-inspector of complaint police station, has stated about he receiving the complaint at Exhibit P1 on 13/12/2012, and after registering it in the station, preparing an FIR as per Exhibit P6 and submitting the same to the court. However, the veracity of his evidence and to the extent how far that can be believed has been analyzed in the beginning of this judgment. As such, his evidence, whether taken into consideration or not, would not shaken the case of prosecution or would not shaken or dilute the case of prosecution. The evidence of PW9, the investigating officer, about he conducting investigation in the matter, including drawing the scene of offense, including recording the statements of witnesses, including the injured, and obtaining the and collecting the wound certificate as per Exhibit P4. Stands corroborated by the evidence of the witnesses as discussed above. His evidence that he collected the court certificate of the accused and PW1 and 2 from the Tahsildar as per Exhibit P3 has not been specifically has not been seriously disputed. Thus, it stands proved beyond doubt by the prosecution that on the date 5/12/2012 at about 8 p.m., the accused number 1 to 4 in furtherance of their common intention approached PW2 and assaulted him with their hands and legs and also with 2 sticks at MO 1 and 2. Consequently, PW2 sustained simple and grievous injuries. The prosecution has alleged that the accused, thus by their act, have committed the offence punishable under section 323, 324, 326, reduced section 34 of Indian Penal Code. No doubt, the prosecution could able to prove that the act of the accused in assaulting PW2 was voluntary, without any provocation, voluntary and without any provocation from the injured side. Further, prosecution could also able to establish that the weapon used in the commission of the crime were the 2 sticks at MO 1 and 2. To attract section 326 of Indian Penal Code, it is not just sufficient if the witness, if the injured suffers, to attracting munche, the prosecution could also able to prove that due to the assault by the accused, PW2 sustained 2 injuries, one among which was grievous in its nature. However, to attract section 326 of Indian Penal Code, it is not just sufficient that voluntary causing, it's not just sufficient that the accused have voluntarily caused grievous injury upon the injured, but it is also required that such a voluntary act of the accused in causing grievous hurt to the injured must be by dangerous weapons or by some dangerous means. In the instant case, the weapons used by the accused, which are 2 sticks at MO 1 and 2, are described as 2 bamboo sticks in the scene of offence Panchanama, which can be held by hand and measuring. One is measuring 3.5 feet in length and another is measuring 2.5 feet in length. So when 2 bamboo stick of this length, which can be held easily with hand, cannot be considered as a heavy club or a dangerous weapon. According to PW 1 and 2, the accused have assaulted PW2 on the lower part of his lower limb, that is below the knee. As such, the place of injury, the place of the organ, as such, the part and place of the organ to which the injuries were inflicted is also not vital organ of the body. Nor even, as such, the means of assault cannot be termed as dangerous. Thus, one of the essential ingredient falls short in the case of prosecution to prove the alleged guilt of the accused punishable under section 326 of Indian Penal Code. However, the proven act
of accused as against PW2 in inflicting, in voluntarily causing grievous hurt to him with the sticks would squarely falls within the ambit of section 325 of Indian Penal Code. However, the trial court failed to notice the same and in a hurried manner proceeded to hold that the prosecution could not able to prove the alleged guilt against the accused for the offences punishable under section 323, 324 and 326 of Indian Penal Code. ಇಲ್ಲಿ ಹಿಂದ್ಗಡೆ ಸೆಂಟೆನ್ಸ್ ಬನ್ನಿ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮುಂಚೆ ಜಸ್ಟ್ ಇಟ್ ಫಾಲ್ಸ್ ಅಂಡರ್ 325 ಆದ್ರ ಮೇಲೆ ಒಂದು ಇನ್ಸರ್ಷನ್. It is also the evidence of PW1 and PW2 that accused, apart from inflicting injuries upon PW2 by assaulting him with 2 sticks at MO1 and 2, have assaulted him with hands and legs. Both PW1 and PW2 have stated that accused number 3 and 4 have assaulted PW2 with their hands and various parts of his body. The medical evidence given by PW4, coupled with the wound certificate at Exhibit P4, also shows that the injured PW2 had sustained a simple injury also as a tenderness and swelling over the right leg. Tenderness and swelling over the left leg. Thus, the act of the accused who had come together, sharing their common intent, in furtherance of their common intention to question PW2 and to assault him, have voluntarily caused hurt to PW2, thereby attracting section 323 of Indian Penal Code. As such, the prosecution could able to prove the guilt against the accused, punishable under section 323 of Indian, read with section 34 of Indian Penal Code also. Para. The accused are also charged for the offences punishable under section 504 and 506, read with section 34 of Indian Penal Code. No doubt, PW1 in her evidence has stated that the accused, after approaching her husband, abused him in filthy language with the words, ಅಲ್ಲಿ ಮೇಲೆ ಹೇಳಿದ್ದೇನೆ ನೋಡಿ ಅದನ್ನು ಹಾಕಿ. Had really the accused had abused the accused, had really the accused abused PW2 in filthy language, then definitely PW2 against whom such use of language is alleged to have been made, should have been necessarily stated in his evidence that the accused had abused him in a particular manner and had provoked him in any way. However, the evidence of PW2, who is none else than the affected person in the incident, is totally silent in this regard. As such, it is not safe to believe that the accused have committed an offence punishable under section 504, read with section 34 of Indian Penal Code. Subpara. Similarly, according to PW2, similarly, with respect to the other offence of accused threatening PW2 of dire consequences has been spoken only by PW2 in his evidence. Had really the accused had threatened PW2 of dire consequences, including taking away his life, then PW1, who was an eyewitness to the alleged incident, should have observed the same and without fail should have stated in her evidence about the accused putting threat to her husband. However, PW1, though has stated that PW3 bracket CW3 was also assaulted in the incident, has not whispered that the accused had threatened her husband of dire consequences. Under such circumstances, it is not safe to hold that the prosecution could be able to prove the guilt against the accused punishable under section 506 read with section 34 of Indian Penal Code. Para. The accused are also charged with the offense punishable under section 3110 and 325 of SC/ST Act. SC/ST Act. ST Act. In order to attract section 3110 of SC/ST Act, it is not just sufficient if it is proved that the affected or injured person were belonging to either scheduled caste or scheduled tribe, but it is also necessary that the accused, knowing fully well that the persons against whom they are committing crime belong to either scheduled caste or scheduled tribe, should have intentionally insulted or intimidated them with an intent to humiliate them in any place within public view. In the instant case, no doubt the incident has taken place outside the house of PW2, which according to accused also a part of the public road, as such it was in public view. However, neither PW1 nor PW2 have in clear term stated as to how they were insulted at the act of the accused or about the intention of the accused to insult them or to humiliate them. Neither of these two witnesses anywhere in their evidence have stated, ಹೇಳಿದಾರೇನ್ರಿ ಒಡನನ ಮಗನೇ ಅಂತ ಯಾರಾದ್ರೂ ಬೈದ್ರು ಅಂತ ಹೇಳಿದಾರೇನ್ರಿ? ಹೇಳಿಲ್ಲ. ಬರೀ ಬೋಳಿ ಮಗನೇ ಅಂತ ಅಷ್ಟೇ ಎಂದಿದ್ದು. ಅದು SC/ST Act ಅಲ್ಲಿ ಬರಲ್ಲ. ಕೂತ್ಕೊಳ್ಳಿ. ಎಂತಂದ್ರಿ?
Nowhere in the evidence has
stated that any of the accused at the time of incident have abused them by taking the name of their caste. As such, even though the caste certificate at Exhibit P3 shows that PW1 and PW2 were belonging to a caste called Bovi, which according to prosecution falls under the scheduled caste, and Exhibit P3 also shows that accused number 1 to 4 does not belong to either scheduled caste or scheduled tribe. By that itself, it can be held that the accused have committed the offense punishable under section 3110 of SC/ST Act. As such, the finding of the trial court on the said finding of the special court on the said aspect doesn't warrant any interference at the hands of this court. Lastly, the accused. Lastly, in order to attract section 325 of SC/ST Act would come into operation only when the offense proved is punishable with imprisonment for a term of 10 years or more against a person or property, knowing that such person is a member of a scheduled caste or a scheduled tribe, or property ಹೊಡೆದಾಕಿ, person or property ನಲ್ಲಿ or property ಹೊಡೆದಾಕಿ against a person knowing that such person is a member of a scheduled caste or scheduled tribe. In the instant case, though PW1 and PW2 were belonging to scheduled caste and the knowledge to that effect can be imputed to the accused. However, the offense proved against the accused 325 ಏನಿದೆ ರೀ punishment to 7 years is not punishable with imprisonment for a term of 10 years or more. As such, section 325 of SC/ST Act is also not attractive in the instant case. Correct. The motive behind the commission of the crime has already been discussed above in detail while analyzing the evidence regarding the incident. However, at the cost of repetition, it is observed that the prosecution could able to establish that the intention of PW2 to erect a compound, the plan of PW2 to erect a compound in front of his house was seriously objected to by the accused, who on the earlier occasion also had approached PW2 and asked him not to put up the compound, since erecting any such compound, according to the accused, would cause obstruction to the movements of the vehicles approaching their dairy. PW1 and PW2 in their evidence has reiterated the said motive behind the commission of the crime. In fact, in the cross-examination of PW9, the investigating officer, suggestions were made from none else than the accused side about the existence of the dairy near the house of PW2 and necessity of any vehicle going to the said dairy to be passed in front of the house of PW2. Thus, it is established that the accused never wanted the erection of any compound or structure by PW2, which according to them would cause obstruction for the movement of the vehicle coming to their dairy. It is in that regard the accused, who had previously asked PW2 not to put up such compound, had on the date of the incident, which was on 5/12/2012, took a drastic step of assaulting the accused with MO1 and 2. Thus, motive behind the alleged commission of the crimes also stands established. The defense of the accused para throughout the case is that the accused the PW2 was a drunkard addicted to liquor and had earned a bad name in the village. As such, he on his own had fallen on earth and fallen on a hard substance and sustained injuries found on his body. Suggestions to that effect were made in the cross-examination of PW1, PW2. However, both the witnesses have denied the said suggestion as true. No doubt, PW4, the doctor, has stated that the injuries found on the injured (PW2) can also possible to be caused when a person falls on a hard and rough surface. However, as analyzed above, the evidence of prosecution, more particularly of PW1 and PW2, has proved beyond reasonable doubt that the injury sustained by PW2 was not by accidental fall, but it was at the specific intentional act of accused voluntarily causing hurt to him, both by hands and by using the sticks at MO 1 and 2. As such, the defense taken by the accused also doesn't stand to to suspect the prosecution case. Consequently, the impugned judgment, which has given a clean chit to all the four accused from all the alleged offences, warrants interference at the hands of this court, and the impugned judgment warrants modification to some extent. Accordingly, we proceed to pass. The impugned judgment warrants modification on the lines observed above. Accordingly, we proceed to pass the following order. Addition, deletion, and yes. The criminal appeal stands allowed in part. The impugned judgment of conviction, the impugned judgment of acquittal dated so and so, passed by so and so in case number, special case of hacking number so and so, stands modified to the effect that the finding of the judgment of acquittal, acquitting the accused number 1 to 4, Hesru Kula Gotra, acquitting them of the offense punishable under section 323, 326, stands set aside. The accused number 1 to 4 stands convicted for the offense the accused number 1 to 4, the acquittal 326 acquittal now confirm ಮಾಡಬೇಕು. ಅಲ್ಲಿ 326 ನ set aside ಮಾಡೋದು ಬೇಡ. 323 stands set aside. The acquittal of accused 1 to 4 for the offense punishable under section ಅದಕ್ಕೆ ಮುಂಚೆ acquittal ಬೇಡ. 323 acquittal of accused number 1 to 4 for the offense punishable under section 323 stands set aside. Accused number 1 to 4 stands convicted for the offense punishable under section 323 read with section 34 of Indian Penal Code. Next line, the acquittal of accused number 1 to 4 for the offense punishable under section 326 read with section 34 of Indian Penal Code stands modified. The accused number 1 to 4 are held guilty of having committed the offense punishable under section 325 read with section 34 of Indian Penal Code. The rest of the portion of the judgment of acquittal of accused number 1 to 4 from the offense punishable under section 324, 504, 506 read with section 34 of Indian Penal Code and under section 3110 and 325 of SC/ST Act stands confirmed. Next line. Heard, learned counsel. For the accused, public respondent number 1 to 4 and learned HCGP on the sentence. Yes, please.
That they are also that any other part of the body was injured. Only injuries shown in the leg. There are authorities not both and
34.
ನೀವೆಲ್ಲರೂ ಬರೆಯೋದು ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಸೆಕ್ಷನ್ 34 ಮರಿತೀರಿ, ಸೆಕ್ಷನ್ 149 ಮರಿತೀರಿ ಅಲ್ವೇ? ಹೇಳಿ ಮುಂದೆ.
They are all category holders. previous history whatsoever.
They had no intention to assault ಅಂತ ಈಗ ಹೇಳಲಿಕ್ಕೆ ಬರಲ್ಲ. ನಾವು ಇಂಟೆನ್ಷನ್ ಬರ್ಸಿ ಆಗಿದೆ. ಈಗ ನಮ್ಮ ಜಜ್ಮೆಂಟ್ ಇನ ರಿವಿಷನ್ ಇನ ಗ್ರೌಂಡ್ಗಳು ನೀವು ಹೇಳಲಿಕ್ಕೆ ಬರಲ್ಲ. ಅದು ಬಿಟ್ಟು ಉಳಿದಂಗೆ ದಮ್ಮಯ್ಯ ದಕ್ಕಯ್ಯ ಅನ್ನೋದೇನಿದೆ ಅಷ್ಟು ಮಾತ್ರ. ಅವನಿಗೆ ಒಂದು ಅಫಿಷಿಯಲ್ ಹೆಂಡತಿ 3 ಜನ ಅನ್ಅಫಿಷಿಯಲ್ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಕಷ್ಟಪಟ್ಟು 24 ಗಂಟೆ ದುಡಿದವ್ರನ್ನ ಸಾಕ್ಬೇಕಾಗಿದೆ. ಏನಾದ್ರು ಮಾಡಿ ಕಡಿಮೆ ಶಿಕ್ಷೆ ಕೊಡಿ ಅಂತದೇನಾದ್ರು ಕೇಳ್ಬೋದೇ ಹೊರತು ಹ್ಯಾಡ್ ನೋ ಇಂಟೆನ್ಷನ್.
ಅವ್ರ ಇದು injuries ಆಗ್ಲಿ, that's not in.
ಅದು ಹೇಳಿದ್ರಿ ತಾವು. ಇಂಜುರೀಸ್ ಇಸ್ ನಾಟ್ ಆನ್ ದ ವೈಟಲ್ ಪಾರ್ಟ್ ಆಫ್ ದ ಬಾಡಿ, ಇಟ್ ಈಸ್ ಬಿನಿತ್ ದಿ ಲೆಗ್. ಅದೆಲ್ಲದನ್ನು ಹೇಳಿದ್ರಿ, ಅದು ತೊಂದರೆ ಇಲ್ಲ, ಅದು ಪರವಾಗಿಲ್ಲ. ವಿಲ್ ಲುಕ್ ಇನ್ ಟು ದಟ್.
3 and 4 ಅವರು ಇರ್ಬೇಕಾದ್ರೆ ಅಂತ ಪಾರ್ಟ್ ಆಫ್ ಮಾಡಿ.
ಹೌದು. Heard the submission from the learned counsel for the respondents and the learned HCGP on the sentence. Learned counsel for the respondents 1 to 4 bracket accused number 1 to 4 submitted that even according to prosecution, it was accused number 1 and 2 who are said to have assaulted PW2 with the weapon, whereas accused number 3 and 4 have only assaulted with their hands. Further, the weapon used is also not a dangerous weapon, which is only a bamboo stick. Bamboo stick. Furthermore, the injury inflicted is not on any vital part of the body, but below the knees of lower limbs.
He also submits that all the four accused are the only breadwinner in their family, having large number of dependents as such, and none of them have any criminal antecedent. As such, a lenient view be taken into consideration. Per contra, Learned SCGP in his argument submitted that the four persons in furtherance of their common intention have attacked and assaulted PW2 and made use of the weapons in assaulting him. They have caused fractured injury upon the injured. As such, in the circumstance of the case, the maximum punishment which can be ordered in the instant case. Next line, it is the sentencing policy that format. The sentence ordered must be neither exorbitant nor for namesake. It must be proportionate to the gravity of the proven guilt. In the instant case, the accused number 1 to 3 claimed to be the secretary, director, and a employee of a milk dairy. The prosecution case go to show that the said milk dairy is located near to the house of PW2. As such, all the vehicles required to go to milk dairy should necessarily go in front of the house of PW2. Therefore, so long the milk dairy would be there in the said location, and it would be necessary for the vehicles going to milk dairy to pass through in front of the house of PW2, the said PW2 can apprehend any caution or warning or objection from the accused. As proved, PW2 has sustained a grievous injury to one of the important limb of the body. Though the weapon used is not dangerous in its nature, however, the injury inflicted cannot be ignored. Under the said circumstance, none of the accused deserves Allah. Under the said bada. Further, all the accused have committed the alleged offense in furtherance of their common intention. As such, no discrimination among them can be made. No discrimination, but as such, common intention, which is proved by the prosecution, also cannot be ignored. Under the said circumstance, we are of the opinion that none of the accused deserves the benefit under Probation of Offenders Act, so and so. However, considering the mitigating factor submitted by learned counsel for the accused, that the accused are the sole breadwinner in their family, having large number of dependents upon them, and also considering the facts and circumstances of the case, we proceed to pass the following order. Format treatment haki, you last time use ಮಾಡಿದ format ಸರಿ ಇಲ್ಲ. Correct ಆಗಿ ತಗೊಂಡು ಹಾಕಿ. For section 325 IPC, 4 years simple imprisonment and 3,000 rupees fine each. In case of default of payment of fine, 3 months simple imprisonment. For the offence punishable under section 323 IPC, 6 months simple imprisonment. Both the sentences shall run concurrently, set off under section 428. Out of the total fine amount of rupees 12,000 paid by the accused, if any, a sum of rupees 10,000 be paid to PW2 Timaya as compensation. The remaining sum of rupees 2,000 goes to the state. The rest of the order of the special court with respect to the disposal of the properties at MO 1 and 2. ಹೇಳಿದ್ದಾರೇನ್ರಿ ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ ಹೇಳಿದಾರ?
ಇನ್ನೊಂದು ಬಲಗೊಳ
ರಿಮೈನ್ಸ್ ಆನ್ ಆಲ್ಟರ್. ಆನ್ ಆಲ್ಟರ್. ಅಕ್ಯೂಸ್ಡ್ ಸರೆಂಡರ್ ಬಿಫೋರ್ ದಿ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್. ಅದು ಫಾರ್ಮೆಟ್ ಪ್ರಕಾರ ಹಾಕಿ ನಾನು ಹೇಳೋ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲ. 45 days. ರಿಜಿಸ್ಟ್ರಿ ಟು ಟ್ರಾನ್ಸ್ಮಿಟ್. ಅದಕ್ಕೆ ಮುಂಚೆ ದಿ ಅಕ್ಯೂಸ್ಡ್ ಆರ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ಫ್ರೀ ಕಾಪಿ ಆಫ್ ದಿಸ್ ಜಜ್ಮೆಂಟ್. ರಿಜಿಸ್ಟ್ರಿ ಟು ಟ್ರಾನ್ಸ್ಮಿಟ್. ಎಸ್.
case of non-payment of fine. In case of non-payment of fine.
ಅದು ಹೇಳಿದೆ, ಡಿಫಾಲ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಹೇಳಿದೆ. ನೆಕ್ಸ್ಟ್ ಪಾರ್ಟ್ ಇಲ್ಲ. ಪಾಸ್ ಓವರ್ ಇದೆಯಾ?
ಇಲ್ಲ
ಪಾಸ್ ಓವರ್ ಇಲ್ಲ. ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಯಾರಿದ್ದೀರಿ? ಒಬ್ರದ್ದು 3 ಮ್ಯಾಟರ್ ಇದೆ ಇವತ್ತು. ಲತೀಫ್ ಇದ್ದೀರಿ. ಈಗ 5 ಅಲ್ಲಿ ನೀವೇ ಇದ್ದೀರಿ, ವಿನಯ್ ಕೀರ್ತಿ ಅವರೇ ಇದ್ದೀರಿ. ಹಾ, ಸೊ ಇವತ್ತು ಸ್ವಲ್ಪ ಸುಸ್ತಾಗಿದೆ, ನಾಳೆ ಬೇಡ. 11th 12th ಎಲ್ಲ ಬೇಡ. 11th 12th ನಾವು ಬಹಳ ಮುದುಕರಾಗಿರ್ತೇವೆ. ವಿಲ್ ಬಿ ಓಲ್ಡರ್ ಬೈ 2 more days. ಮಾಡಿ, ಅದ್ರಲ್ಲಿ ಪಾಕ್ಸೋ ಇದೆ, ನೇತ್ರಾವತಿ ಕ್ವಾರ್ಟರ್ಸ್. ಬನ್ನಿ ಮಾಡುವ. ಇದು ಬೇಡ. ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಲರ್ನ್ಡ್. ಅದ್ರಲ್ಲಿ ಯಾರಿದ್ದೀರಿ? HCGP ನ SPP ನ? Learned HCGP for the appellant and learned counsel for respondent number 1 and learned amicus curiae for the respondent number 2 are physically present. Since the court time is over, this matter could not be taken up today. List this matter on 6/7. ಯಾವ ತಾರೀಖು ಬೇಕು? 8. List this matter on 8ನೇ ತಾರೀಕು ಆಗ್ಬಹುದೇ? 8, 12, 23 on the top of the list. ಟಾಪ್ ಅಲ್ಲಿ ಬಂದಿರ್ತದೆ. ಅನ್ಲೆಸ್ ವಿ ಗಿವ್ ಎನಿ ಅದರ್ ಮ್ಯಾಟರ್ as ಟಾಪ್ ಮೋಸ್ಟ್. ಪಾಠ ಇದ್ರೆ ಮಾತ್ರ ಇದು ಬರ್ತದೆ ಟಾಪ್ ಮೋಸ್ಟ್. ಇದಾರೆ ಇದು ಟಾಪ್ ಇರ್ತದೆ. ಎಸ್.
Number 6.
6 learned HCGP for the appellant and learned amicus curiae for respondent are physically present. Same. Since the court time is over, this matter could not be taken up today. ಇದು ಯಾವಾಗ ಮಾಡ್ತೀರಿ? HCGP ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎನಿ ಡೇಟ್. ನೀವು ಯಾವತ್ತು ಮಾಡ್ತೀರಿ? 5, 6, 7. 6th. List this matter on 6, 12, 23 on the top of the list.
Number 7.
Learned additional SPP for the appellant and learned amicus curiae for the respondent are physically present. Since the court time is over, ಮುಂದಿಂದೆಲ್ಲ ಹಾಕಿ. ಇದು ಯಾವತ್ತು ಮಾಡ್ತೀರಿ? ಇದು ಪಾಕ್ಸೋ, ಬೇಬಿ ಗರ್ಲ್, DNA ಟೆಸ್ಟ್. ಇಲ್ಲ, ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅವರಿಗೆ 2 ದಿವಸ ಇತ್ತ. ಹೈಲಿ ಕಂಟೆಸ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಒಂದೇ ದಿವಸಕ್ಕೆ 2 ಬೇಡ. 4
2
ಪಾರ್ಟ್ ಹಾರ್ಡ್ ಇದೆ. ನೀವು ವೇಟ್ ಮಾಡೋದು ಬೇಡ. 5. 5ನೇ ತಾರೀಕು ಆಗ್ಬಹುದೇ ನಿಮ್ಗೆ? ಬೇಡ, ಇನ್ನೊಂದಿದೆ. 6th ಈ ಒಂದು ಕೊಟ್ಟಿದ್ದೇವೆ, ಅವರದ್ದೇ ಕೊಟ್ಟಿದ್ದೇವೆ. 7th 7th ವರ್ಕ್ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್. ಗುಲ್ಬರ್ಗಕ್ಕೆ ಹೋಗ್ಬೇಡಿ. ಗುಲ್ಬರ್ಗ, ಧಾರವಾಡ ನೋ. ನೀವು ಇಡ್ಸ್ಕೊಳ್ಬಾರದ್ರಿ. ನಾನು ಜುಡಿಷಿಯಲ್ ನೋಟಿಸ್ ಮಾಡ್ತೇನೆ. ಅಡಿಷನಲ್ SPP ಇಲ್ಲಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ರು ಸ್ಟೇಟ್ ಅಲ್ಲೆಲ್ಲ ತಿರುಗಿ ಇಲ್ಲಿ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಮಾಡೋದು ಸರಿಯಲ್ಲ ಅಂತ. ಇದು ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚು, ಎಗೇನೆಸ್ಟ್ ಅಕ್ವಿಟಲ್ ಡಿವಿಷನ್ ಬೆಂಚು.
ಅಲ್ಲೂ ಇದ್ದಾರೆ,
ಅಲ್ಲಿ ಇದ್ದಾರೆ, ಅಲ್ಲಿ ನಿಮ್ಮ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ RB ಪಾಟೀಲ್ನೇ ಕಳಿಸಿ, ಅವನೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾನೆ.
ಹಾ, ಸೌಖ್ಯವಾಗಿದ್ದಾನ? ನಿಮಗೇನಾದ್ರು ಬ್ಲೂಟೂತ್ ಕೊಟ್ನಾ? ಇಲ್ಲ ಇಲ್ಲ. 7th ಬೇಡ, 11 ಆಗ ತಾಳಿ. ಅವ್ರೆಲ್ಲಿ ಹೋದ್ರು? ವಿನಯ್ ಕಿಲ್ಪಿ ಹೋದ್ರ ಅವರು ಹಿ ವಾಸ್ ಆಸ್ಕಿಂಗ್ ಫಾರ್ 11. ನೀವು 8 ಇದ್ದೀರಾ ಇಲ್ಲಿ. ಸೊ ಅವ್ರಿಗೆ ಪಾಪ 11 ಕೇಳ್ತಾ ಇದ್ರು, ಅವರಿಗೆ 11 ಕೊಡುವ. ಒಂದ್ ಸ್ವಲ್ಪ ಓದ್ಲಿಕ್ಕೆ ಬರ್ತಾರೆ, ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಅವರಿಗೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 5 ನ 11, 12 ಮಾಡಿ. ಅಲ್ಲಿಗೆ ಇಬ್ರು ವಕೀಲರು ವಿ ಕ್ಯಾನ್ ಸ್ಯಾಟಿಸ್ಫೈ ಅಬೌಟ್ ದ accommodating them. So serial 5, 11, 12. Serial 8, 8, 12. 7, 12. 7th ಅವ್ರಿರಲ್ಲ, 8, 12.
Serial number 7, 8, 12.
Serial number 7 is 7, 12 ಆಗಿದೆ. Serial number 8 ಇಲ್ಲ, ಒಂದ್ ನಿಮಿಷ ತಾಳಿ. ಈಗ ತಗೊಂಡಿರೋದು ಯಾವ್ದು ನಾವು? 7 ನ. Serial number 7 is 8, 12. 8, 12 on the top.
Serial number 8, SPP, D. Latif,
ಯಾರಿದ್ದೀರಿ ಇದರಲ್ಲಿ?
connected matter.
ನೀವಿದ್ದೀರಿ. 4ನೇ ತಾರೀಕು. ಅಲ್ಲ, ನೀವು ವಕೀಲರುಗಳು ಕೋರ್ಟ್ ವರ್ಕ್ ಆಗದೆ ಮ್ಯಾಕ್ಸಿಮಮ್ 210 days. ಅದರಲ್ಲಿಯೂ ಕೂಡ 50% ಇನ್ಕನ್ವೀನಿಯನ್ಸ್, 30% ನಾಟ್ ವೆಲ್ಲು, 20% ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್. ಇನ್ ರಿಮೈನಿಂಗ್ 10% ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತೀರಿ? ನಿಮ್ಮ ಕಕ್ಷಿದಾರರು ಎಲ್ಲರೂ ನಿಮಗೆ ಮತ್ತೆ BMW ಕಾರ್ ಕೊಡಿಸ್ತಾರೆ. ಇವತ್ ಕಾದ್ರಿ 8ನೇ ತಾರೀಕು ಇನ್ನೊಂದಿದೆ ಅಲ್ಲ ವಕೀಲ್ರೆ, ಕೊಡುವ 8ಕ್ಕೆ. ಯಾರಿಗೇನೆಷ್ಟು? ಈಗ ಕ್ರಿಕೆಟ್ ಅಂದ್ರೆ ಗೌರವ ಬರ್ಸಲ್ಲ ರೀ, ಮೊನ್ನೆ ವರ್ಲ್ಡ್ ಕಪ್ ಆದ್ರ ಮೇಲೆ. ಇದರಲ್ಲಿ ಸೀರಿಯಲ್ 8 ಅಲ್ಲಿ ಸ್ಟೇಟ್ಗೆ ಯಾರಿದ್ದೀರಿ? ನೀವಿದ್ದೀರಿ. ಸೀರಿಯಲ್ 5 ಅಲ್ಲಿ ಯಾರಿದ್ದೀರಿ? ಸೀರಿಯಲ್ 5 ಅಲ್ಲಿ ನೀವಿದ್ದೀರಿ. ಇದು ಅನ್ಯಾಚುರಲ್ ಸೆಕ್ರಿ, ಇದು 377 ಮ್ಯಾಟರ್ ಸಣ್ಣದಿದೆ, ಆದ್ರೆ ಇಂಟ್ರಿಕೇಸಿ ಜಾಸ್ತಿ ಇದೆ. ಇದನ್ನ 11 ಹಾಕೊಳ್ಳು, ಯಾಕಂದ್ರೆ 11ಕ್ಕೆ ಒಂದರಲ್ಲಿ ಅವರಿದ್ದಾರೆ, ಇನ್ನೊಂದ್ರಲ್ಲಿ ನೀವಿರ್ತೀರಿ. ಇಬ್ರು ಪ್ರಿಪೇರ್ ಆಗಿ ಬರ್ಬೋದು. 11, 12 ಆನ್ ದಿ ಮೇಲ್ಗಡೆಗೆ ಇರೋದು ಸೀರಿಯಲ್ 5 ಸೆಕೆಂಡ್ ಟಾಪ್ ಅಂತ ಮಾಡಿ. ಸೀರಿಯಲ್ 5 ಸೆಕೆಂಡ್ ಟಾಪ್, ಇದು ಫಸ್ಟ್ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್. ಸೊ ನಿಮ್ಮದು ಟಾಪ್ ಮೋಸ್ಟ್ ಬರುತ್ತೆ ಅವತ್ತು. ನಿಮ್ಮದಾದ್ರ ಮೇಲೆ ಅವರು ಅವರು ಇರ್ತಾರೆ. ಸೊ ಅವ್ರು ಸ್ವಲ್ಪ ಪುರ್ಸತ್ತಲ್ಲಿ ಕೂರ್ಬೋದು.
Serial number 9, SPP, Rashmi Jadhav, correspondent.
Learned additional SPP for the state and learned counsel for the respondents are physically present. Since the court time is over, this matter could not be taken up today. List this matter on 12/12 on the top of the list.
Serial number 10,
ಬರ್ತದೆ. ಸೊ ಬೆಳಗ್ಗೆನೆ ರೀಚ್ ಆಗ್ತದೆ. ಸೀನಿಯರ್ಗೆ ಹೇಳಿರಿ ಬನ್ನಿ.
serial number 10, SPP.
ಇದನ್ನೆಲ್ಲ ಬರ್ಕೊಂಡಿರಿ ನೀವು. ಅದು ನಿಮ್ಮ ಬುಕ್ಕಿನಲ್ಲಿ ನಾವು ಬೇರೆ ಡೇಟ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಈ ಮ್ಯಾಟ್ರ್ ಅನ್ನೋದನ್ನು ಬರ್ಕೊಂಡಿರಿ. ಬ್ರಾಕೆಟ್ ಸಣ್ಣದಾಗಿ ಯಾವ ವಕೀಲರು ಏನ್ ಮ್ಯಾಟ್ರ್ ನಮಗೆ ಗೊತ್ತಾಗ್ತದೆ, ಬೇರೆ ಪಾರ್ಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಮುಂಚೆ. 10.
Serial number 10,
Learned additional SPP for the appellant alone present. Learned counsel for respondent not present. Since the matter, hence the matter could not be proceeded today. ಇದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ಲಿ ನಲ್ಲಿ ಬರಲಿ. ಹೇಳಿ. ಅಲ್ಲ, ಇದು ವೀಕ್ಲಿ ಎಲ್ಲ ಹಾಕ್ತೇನೆ. ಇದು ವೀಕ್ಲಿಗೆ ಬರ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಡೈಲಿಗೆ ಬೇರೆದು ನಮಗೆ ಗ್ಯಾಪ್ ನ ಫಿಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬೇರೆ ಪಾರ್ಟ್ ಮ್ಯಾಟರ್ಗಳು ಬರುತ್ತೆ. ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಆರ್ಡರ್ ಆಗಿದೆ, ಕೊಡ್ರಿ ಅದು ಆರ್ಡರ್ ಶೀಟ್.
ನೋಡ್ಬೋದು, 2017 ಮ್ಯಾಟರ್ ಇದೆ ರೀಚ್ ಆಗುತ್ತೆ, ಇದು 18.
ಒಂದು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ದಾರೆ. Vernon Council for Responsibility is also present. Since the court time is over, matter is adjourned.
ಅಲ್ಲ, ಅದು ಹಿಂದಿನ ಸರ್ತಿ ನಾವು ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ವಿ, ಇನ್ ಕೇಸ್ ಇಫ್ ಇಟ್ ಡಸಂಟ್ ಕಮ್ ಅಂತ. ನಾಟ್ ಪ್ರೆಸೆಂಟ್. ಕರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದಾರೆ, ಲಾಸ್ಟ್ ಟೈಮ್ ಇದ್ದಾರೆ, ಇರ್ಲಿ ವೀಕ್ಲಿ ಇರ್ಲಿ. ಎಸ್
ನಾಲ್ಕು ಇದೊಂದು ಸೇರಿದ್ರೆ
ಇದೇನು ಸೇರುತ್ತೆ?
22 ಆಗುತ್ತೆ. ಇನ್ನು 3 ಮ್ಯಾಟರ್ ಸೇರಿಸಿ.
ಸೀನಿಯಾರಿಟಿ ಕೆಳಗೆ ಬರಲಿ, ಆಡ್ ಆಗೋ ಮ್ಯಾಟರ್ಗಳು ಕೆಳಗೆ.